The Women's IP World Annual 2026. Front cover text. The Women's IP World Annual 2026. Celebrating the work and achievements of women in IP law, and innovation globally. Profiles, articles, rankings, experience, achievements, accolades, plus much more inside.
Inside front cover advertisement, Women's IP World, celebrating the work and achievements of women in IP law and innovation globally. Join the 8th annual edition of the Women's IP World Annual. Your story has the power to inspire. We invite you to join the Women's IP World Annual 2027 and be part of a global community of women who are shaping the future of IP. Profiles, accolades, experience, articles, ranking achievements. Share your journey, connect with peers, and let your voice be heard. Contact us to join now. Visit website www.womensipworld.com. Call +44 203 818 0457. Email us at wipw@northonsprmarketing.com.
Page 3. A message from the CEO. A word from our founder and CEO. The launch of the 2026 edition of the Women's IP World Annual marks a major milestone in recognizing the substantial growth and industry impact achieved since 2019. What began as a focused platform to recognize and celebrate women in IP law and innovation has matured into a publication with a truly global presence. Each edition has strengthened our purpose to highlight the expertise, determination, and impact of women defining the IP landscape, and this year's issue continues that tradition. Over the years, we have had the privilege of working with exceptional professionals from across the world. Their contributions have brought depth, perspective, and authenticity to every edition. As a result, Women's IP World has grown into more than a publication. It has become a trusted platform for women who would like to contribute professional knowledge to help juniors in the IP sphere and a growing network for IP professionals worldwide. A defining highlight this year is the successful introduction of the second edition of the Women's IP World Ranking, Top 100 Influential Women Leaders in IP Law, Champions of Leadership, Innovation, and Global Influence 2026. This initiative recognizes individual women who are making a meaningful difference across the IP sector. The responses we received across jurisdictions were remarkable, reflecting both the strength and diversity of talent within the community. Each nomination was carefully reviewed, taking into account professional achievements, legal expertise, policy involvement, mentorship, and broader contributions to the field. The finalists bring together a group of women who are not only leaders in their respective areas but also driving progress across the global IP ecosystem. Many have challenged norms, contributed to legal development, and actively supported greater inclusion within the profession. Their journeys reinforce the importance of representation and leadership in molding the future of IP law. Building on the success of this year's ranking, we are already looking ahead to 2027 with renewed focus. Our commitment remains clear: to maintain high standards, support diversity, and provide a platform that reflects the evolving voice of women in IP. To our contributors, I extend my gratitude for your sustained and ever-increasing trust. Your work is central to everything we do. To our readers, we are grateful for your ongoing support and confidence in our publication. And to the many women leading change across the IP industry, your efforts continue to inspire and guide this journey. With regards and optimism. Carlos Northern, Founder and CEO, Northon's Media PR and Marketing Limited. Published by Northon's Media PR and Marketing Limited. Carlos Northern, CEO and Founder, Northon's Media PR and Marketing Limited, publisher of the global IP magazine, the Women's IP World, the IP Tech and Innovation Services Annual and IP 360 Hub. Carlos at northonsprmarketing.com. Dhruva Dakani, Director of Creative Design and Global Marketing for the global IP magazine, the Women's IP World, the IP Tech and Innovation Services Annual and IP 360 Hub. Dhruva at northonsprmarketing.com. Hitanshi Gohil, Senior Graphic Designer and Researcher for the global IP magazine, the Women's IP World, the IP Tech and Innovation Services Annual and IP 360 Hub. Hitanshi at northansprmarketing.com. Bhumika Goswami, Sales Account Manager for the Global IP Magazine, the Women's IP World, the IP Tech and Innovation Services Annual and IP 360 Hub. Bhumika at northansprmarketing.com. Kushraj Singh Jowli, Senior Reporter for the Global IP Magazine, the Women's IP World, the IP Tech and Innovation Services Annual and IP 360 Hub. News Desk at northansprmarketing.com. Disha Panchal, Junior Creative Designer for the Global IP Magazine, the Women's IP World, the IP Tech and Innovation Services Annual and IP 360 Hub. Info at northansprmarketing.com. Disclaimer: all images in the articles are provided by the authors, unsplash.com, pixabay.com, pexels.com, canva.com, freepik.com, vecteezy.com, and Adobe Express. Page 4. Contents page. Page 07. Influential Woman of the Year Women's IP World Annual Woman of the Year article. From Vision to Value, Dr. Shweta Singh and the Democratization of IP in India. Segment: North America, Central America, Caribbean. Page 11. EPROINT Co-Managing Partner Profiles and Article. Beyond the Periphery, the Caribbean's Emerging Role in Global IP Protection. Gabriela Bodden, Co-Managing Partner at EPROINT, Caribbean Islands, and Vanessa Cabrera, Partner at EPROINT, Dominican Republic. Page 15. Advitum IP Founding Partner Profile and Article. The Lanham Act Gets a Shot: How GLP-1s Are Testing the Boundaries of Trademark Law. Michelle S. Katz, Founding Partner, and Noah Siskind, Associate, of Advitum IP, LLC, USA. Page 21. Abdelrazak and Assis's Founder and Partner Profile and Article. Turning Innovation into Growth in Haiti. Vanessa Abdelrazak, Founder and Partner at Abdelrazak and Assis's, Haiti. Page 25. Miller Simons Sullivan Partner Profiles and Article. Brand Protection in the Turks and Caicos Islands. Louise Malcolm, Partner, and Deborah Yvonne Garland, Trademark Administrator at Miller Simons Sullivan, Turks and Caicos Islands. Segment: South America. Page 31. Barlaw, Barrera and Asociados Founding and Managing Partner Profile and Article. Strategy to Successfully Enforce Your Brands in Peru. Adriana Barrera, Founding and Managing Partner at Barlaw, Barrera and Asociados, Peru. Page 37. Estrategia Juridica Managing Director Profile and Article. Compliance as a Competitive Edge for IP Law Firms. Claudette Vernett, Managing Director and Chief Legal Counsel of Estrategia Juridica, Colombia. Page 41. Vision Legalis Advocate and Attorney and Founder Profile and Article. Why Service Providers in Suriname Should Really Consider IP. Ellison Frank, Attorney and Founder at Vision Legalis Advocaten, Republic of Suriname. Page 44. Ayala and Asociados Founding Partner Profile and Article. Patents, Investment and Knowledge: The Case for a Genuine Reform of Venezuelan IP Law. Beatriz Ayala, Founding Partner, Ayala and Asociados, Venezuela. Europe. Segment: Europe. Page 48. Pakarenko and Partners Managing Partner and Founder Profiles and Article. Trademarks are a must-have in the modern economy. Antonina Pakarenko, Anderson, Managing Partner and Founder, and Alina Shamrina, Lawyer, Patent and Trademark Attorney at Pakarenko and Partners, Ukraine. Page 52. Hogan Lovells International LLP Partner Profile and Article. Pharma Patent Enforcement in the Eurasian Economic Union, Trends, Strategies and Emerging Risks. Dr. Natalia Gulieva, Partner at Hogan Lovells International LLP, Germany. Page 57. Dormand IP Director and Managing IP Consultant Profile and Article. Championing Innovation and Fair Access in a Changing IP Landscape. Claudia Kaya, Director and Managing IP Consultant, Switzerland. Segment: Asia. Page 61. Ennoble IP Founder and CEO Profile and Article. From Ownership to Omniscience: How Women Are Redefining IP Leadership in the Intelligence Era. Dr. Shweta Singh, Founder and CEO of Ennoble IP, India. Page 66. Biro Octroy Rusino Managing Director Profile. Migni Miriasandra, Indonesia. Page 67. Julius and Creasy Senior Partner Profiles and Article. Recognition of well-known trademarks in Sri Lanka. Anomi Wanigasekara, Senior Partner, and Sabira Sharif, Partner, of Julius and Creasy, Sri Lanka. Segment, IP Service Providers. Page 73. Patworld Senior Patent Analyst Profile and Article. Visualizing Decarbonization, a data-driven analysis on patent trends, Chulin Dai, Senior Patent Analyst at Patworld, United Kingdom. Page 79. PSS Solutions CEO Profile. Nadine Stuttel, Switzerland. Page 81. Innovair IP European Patent Attorney and Founder Article. A scientist and a lawyer? Dr. Claudia M. Duffy, European Patent Attorney and Founder of Innovair IP, UK. Page 85. A podcast just for us article. Michelle S. Katz, Founding Partner of Advitum IP, LLC, USA. Page 87. Women's IP World Ranking Results 2026. The top 100 influential women leaders in IP law, champions of leadership, innovation, and global influence 2026 ranking results. Brought to you by Northlands Media PR and Marketing Limited, United Kingdom. Page 91. Women's IP World Ranked Directory Listing 2026. The top 100 influential women leaders in IP law, champions of leadership, innovation, and global influence 2026 ranked directory listing. Brought to you by Northlands Media PR and Marketing Limited, United Kingdom.
Page 05. Quarter page advertisements. Advert 1. Tata Industrial Property. Invent hard, IP it smart. An individually tailored approach for getting the best possible protection for your business, inventiveness, and creativity in Bulgaria and Europe. www.ketpatent.com. Advert 2. Pakarenko and Partners. IP and law firm. Intellectual property law, anti-counterfeiting and anti-piracy operations, litigation, media law, advertising law, corporate and commercial law, competition law, pharmaceutical law. Main office, 72, Velika Vasilkivska Street, 03150, Kiev, Ukraine. Telephone +380 44 593 9693. Fax +380 44 451 4048. Email pakarenko@pakarenko.com.ua. Website pakarenko.ua. Page 6. Advertisement. Caribbean Trademark Services. Law Office of George C. J. Moores, PA. Over 40 years of one-stop trademark services in the Caribbean. www.caribbeantrademarks.com. Telephone 1-561-833-9000. Fax 1-561-833-9990. Email ip@caribbeantrademarks.com. Address 2855 PGA Boulevard, Palm Beach Gardens, Florida 33410.
Page 7. Women's IP World Annual Woman of the Year. From Vision to Value, Dr. Shweta Singh and the Democratization of IP in India. Across India's rapidly evolving innovation landscape, a new generation of leaders is shaping the future of IP rights by ensuring that creativity, research, and entrepreneurship are protected and nurtured. Among these influential figures stands Dr. Shweta Singh, founder and CEO of Ennoble IP, a professional whose work has significantly contributed to strengthening the country's IP ecosystem. Dr. Singh's journey reflects the spirit of determination and vision that defines many first-generation entrepreneurs. At a time when IP protection in India was often perceived as complex and accessible mainly to large corporations, she recognized a critical gap. In 2014, she founded Ennoble IP with a clear mission: to make IP rights accessible to innovators from all walks of life. Her vision was simple yet transformative. IP should not remain confined to the boardrooms of multinational corporations. It should also protect the researcher developing breakthrough technologies in a university laboratory, the small manufacturer building a new product in a rural town, the creative professional writing a script from a modest workspace, and the young engineer experimenting with ideas that may shape the future. Through Ennoble IP, Dr. Singh set out to ensure that these innovators could secure and protect the value of their ideas. What began as a consultancy has grown into a trusted advisory platform supporting startups, researchers, businesses, and creators across India and beyond. A defining element of Dr. Singh's success lies in her interdisciplinary background, which enables her to understand innovation from multiple perspectives. With a PhD in management focused on green technology, a master's degree in biotechnology, and an MBA, she combines scientific knowledge, business strategy, and legal insight to guide innovators through the IP process. Her specialized training in patent law from the National Academy of Legal Studies and Research, NALSA, further strengthened her expertise. She was also selected as the first Indian woman to attend the World Intellectual Property Organization, WIPO, colloquium in Geneva, an experience that expanded her understanding of global IP systems and policy frameworks. This unique blend of scientific, legal, and entrepreneurial knowledge enables Dr. Singh to identify the deeper intention driving an innovation, rather than viewing IP purely through a legal lens. By understanding both the technical foundation and the commercial potential of an idea, she helps innovators translate creativity into protected and scalable assets. While her professional achievements are significant, Dr. Singh's work extends beyond business success. She is deeply committed to advancing social equity and expanding opportunities for women entrepreneurs. She is the driving force behind the Women Innovation and Entrepreneurship Foundation, WIEF, an initiative dedicated to supporting women innovators, founders, and professionals. Through mentorship programs, networking opportunities, and access to resources, the foundation aims to strengthen women's participation within India's innovation ecosystem. In addition to WIEF, Dr. Singh founded SheReal, a professional networking platform designed to create meaningful connections and support systems for women across industries. The platform serves as both a digital and physical community where women can find mentorship, collaboration opportunities, and guidance for navigating entrepreneurial and professional challenges. For Dr. Singh, empowerment is not simply about individual success. It is about building ecosystems that enable others to thrive. As she often emphasizes, empowering women creates ripple effects that strengthen families, businesses, and entire economies. Her leadership and contributions have earned recognition from multiple national and international institutions, and her mantle is, evidently, thronged with accolades. She was named Times 40 Under 40 and is recognized by Economic Times as an inspiring women leader over multiple consecutive years. The cherry on top, she has been commended by the Prime Minister of India, Mr. Narendra Modi, for her efforts to strengthen the startup ecosystem. Yet those who work closely with Dr. Singh often highlight qualities beyond awards and accolades. They speak of her energy, her clarity of purpose, and her distinctive philosophy that bridges tradition with technological advancement. Her concept of Vedic to tech reflects a belief that innovation can honor traditional knowledge while embracing the possibilities of modern science. This philosophy is reflected in her latest venture, Harchi, which integrates ancient Vedic principles with modern skincare science, demonstrating how heritage and technology can coexist to create new opportunities. Today, as IP increasingly shapes global competitiveness, India's future growth will be driven not only by production capacity but also by its ability to innovate and protect those innovations. The value of ideas, creativity, and research continues to grow in a knowledge-driven economy. Dr. Shweta Singh's work reminds us that every innovation begins with a simple idea. When that idea is nurtured, supported, and protected through the right legal and commercial frameworks, it has the potential to grow into something transformative. From her early days as a biotechnology student to becoming a recognized leader in IP and entrepreneurship, Dr. Singh's journey demonstrates the power of vision, resilience, and purpose. Through Ennoble IP and her broader initiatives, she continues to champion the protection of creativity and the empowerment of innovators across India and beyond. Her story serves as an inspiration to students, entrepreneurs, and professionals who believe that ideas have the power to shape industries, communities, and nations.
Segment page: North America, Central America and the Caribbean. Women's IP World Annual 2026. Page 10. Half and quarter page advertisements. Advert 1. HSMIP. Looking to protect your IP across the Caribbean? The team at HSMIP, with over 100 years of combined intellectual property experience, can protect brand names, logos, inventions, trade secrets, creative works and designs. Portfolio management / strategic advice. Renewals / annuities management. Clearance / availability searches. Dispute resolution / enforcement. Prosecution services. Anti-counterfeiting. Contact Mrinali Menon, Senior IP Manager. +1 34 58 15 7436. mmenon@hsmoffice.com. Advert 2. IP Cyprus. Ionides, Clenthis & Co. LLC. IP Business Law Office. A law firm specializing in intellectual property law, which provides smart and pragmatic advice for Cyprus and EU matters. Address: 4 Prometheus Street, 1065 Nicosia, Cyprus. Telephone: +357 222 70638. Fax: +357 222 70639. Email: info@ipcyprus.com. Contact Maria Ioannidis, Marinos Clenthis. Website: www.ipcyprus.com. Advert 3. Singh & Singh. Bidika Sharma, Senior Partner at Singh & Singh Law Firm LLP, India. Ms. Sharma is a first-generation practicing lawyer with law graduation from Delhi University in year 2004. She is additionally ABSc Hons from Delhi University in year 2001. With her experience of almost 20 years, she has developed a bandwidth in handling patents, trademarks, copyrights, designs. Website: www.singhandsing.com.
Page 11. Profile: Costa Rica. Name: Gabriela Bodden. Law firm: Epoint. Position: Co-managing partner. Country: Costa Rica. Website: www.eproint.com. Gabriela Bodden is a highly regarded IP practitioner with over 28 years of experience, recognized internationally for her work across the Caribbean and Latin America. Her practice is distinguished by a sophisticated and strategic focus on IP-driven commercial and transactional matters, advising clients on complex issues that sit at the intersection of IP, corporate structuring, and investment. Gabriela regularly advises on IP-intensive contracts, licensing and distributorship arrangements, IP holding and wealth management structures, venture capital and private equity transactions, and the strategic management of global trademark portfolios. She is particularly known for developing tailored IP holding vehicle strategies and for delivering commercially focused advice aligned with clients' long-term business objectives. Gabriela has extensive experience in mergers and acquisitions involving IP, including the coordination and execution of large-scale, multi-jurisdictional assignments and recordals. She is recognized for her ability to manage complex cross-border projects with precision, ensuring effective alignment between legal strategy and transactional outcomes. A respected figure within the international IP community, Gabriela is a former president of the AIPPI Regional Group for Central America and the Caribbean. She is a member of the AIPPI Nominating Committee and assists in the coordination of the Women in AIPPI Social Group. Her profile is further defined by her in-depth and practical understanding of the legal and regulatory frameworks governing IP across the Caribbean and Latin America, expertise that is frequently sought by international clients and peer firms. She is also well known for her work in anti-piracy and anti-counterfeiting matters, supported by substantial customs and enforcement experience, having previously worked within the legal department of customs in Costa Rica. This background provides her with a distinctive, enforcement-focused perspective on IP protection in the region. Published article: Filing Strategies in the Caribbean and Central America, Don't Be Ambushed, Filing a Trademark in the Caribbean, What to Expect, the Future Legislation before the Caribbean Court of Justice and CARICOM, The Obligation of Use of Trademarks in the Caribbean, Trademarks in the Caribbean, Pirates, Plantations, Rum and Reggae, and IP? What to Expect when Conducting a Search in the Caribbean, It's All in the Mapping, many others. In addition, Gabriela has written and collaborated on chapters on trademark practice and procedure for various publications highly prized within the IP field. Qualifications: LLM in Intellectual Property Law, candidate for a master's degree in Intellectual Property and Tech Law by the International University of Valencia, Spain, Diploma in Medical Legal Cannabis Law, Phytosanitary and Business Aspects of Cannabis by the University of El Rosario, Colombia, course on Patents and Utility Models of the Patent and Trademark Office and the Patent Center of the University of Barcelona, Barcelona, Spain, Bachelors of Law with an emphasis in Business Management. ULICIT, Licentiate Degree in Law, ULICIT, Attorney at Law Notary Public. Languages: English, Spanish. Page 12. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Beyond the Periphery, the Caribbean's Emerging Role in Global IP Protection. Subhead: Gabriela Bodden, co-managing partner at EPROINT, Caribbean Islands, argues that the Caribbean and Central America are becoming strategically essential in global IP protection owing to modernized laws and international alignment. For decades, the Caribbean has been treated as a peripheral consideration in global IP strategies, an afterthought rather than a priority. That position is no longer tenable. With over 28 years of practice in the region, I have witnessed a decisive shift. The Caribbean is no longer optional. It is strategic, and in many cases, essential. Historically, many Caribbean jurisdictions inherited legislative frameworks rooted in British law. While these systems provided a solid foundation, they often became outdated and misaligned with modern commerce, digital innovation, and globalized trade. Over the past decade, however, a clear shift has emerged. Several countries have taken deliberate steps to modernize their IP regimes, reflecting both economic ambition and a desire for legislative autonomy. A key driver of this transformation has been the adoption of international treaties, most notably the Madrid Protocol. The accession of multiple Caribbean jurisdictions has significantly streamlined trademark protection, allowing brand owners to secure rights across several territories through a single application. Jurisdictions such as the Bahamas and Bermuda have not only joined the system but have also enacted updated trademark legislation to support its implementation. Grenada has recently joined the treaty. Other countries, including Belize, Cuba, Antigua and Barbuda, Barbados, Jamaica, and Trinidad and Tobago, have likewise embraced the system, reinforcing a broader trend towards international alignment. These reforms go beyond compliance. They signal a commitment to creating a more business-friendly environment by modernizing procedures, improving registry operations, and enhancing legal certainty, factors that increasingly attract foreign investment and rights holders. The Caribbean presents a nuanced landscape in the field of patents. It is generally not a first-filing region, largely due to the scale of local research and development and market size. Instead, it plays a more prominent role in the later stages of the patent lifecycle, particularly for entering national phase applications under the Patent Cooperation Treaty, PCT. Industries such as pharmaceuticals, biotechnology, energy, and telecommunications often extend protection into Caribbean jurisdictions as part of broader international strategies. In this context, the region functions as a complementary jurisdiction, supporting the consolidation and enforcement of rights rather than their initial creation. Beyond legislative reform, the appeal of the Caribbean and Central America lies in a combination of strategic, economic, and legal factors. Geographically, the region bridges North and South America while maintaining strong ties with Europe, making it a natural hub for trade and distribution. Many Caribbean jurisdictions offer stable legal systems based on common law principles, providing predictability for international practitioners. Courts are increasingly sophisticated in handling IP disputes, contributing to a more reliable enforcement environment. At the same time, governments are recognizing the importance of IP in sectors such as tourism, creative industries, agriculture, and emerging technologies, and are investing accordingly. Rather than being defined by cost alone, the Caribbean presents a varied and strategically nuanced filing landscape. Certain jurisdictions, such as the Cayman Islands, Turks and Caicos Islands, and Bermuda, are characterized by comparatively high official fees and ongoing maintenance requirements, including annual renewal obligations. Conversely, other territories offer more streamlined filing options. The presence of Madrid Protocol members across the region, including Belize, Cuba, Antigua and Barbuda, Barbados, Jamaica, and Trinidad and Tobago, further enhances flexibility, allowing rights holders to tailor their filing strategies according to commercial priorities. In Central America, adoption of the Madrid Protocol has been more gradual, reflecting differing legislative priorities. While Belize is a member, other jurisdictions continue to rely on national systems. Nevertheless, there is a clear trajectory towards greater harmonization. As trade and foreign investment increase, so too does the incentive to align with international frameworks. Accession to the Madrid Protocol is increasingly viewed not only as a procedural improvement but as a signal of openness to global business. The region is therefore likely to see steady, if measured, convergence with international IP standards. Importantly, the behavior of the IP market in the Caribbean and Central America reflects a practical dimension that is sometimes underestimated. Enforcement, while varying by jurisdiction, can be effective and commercially meaningful, particularly in smaller markets where infringements are more visible and easier to contain. The region's reliance on tourism amplifies the importance of trademark protection, as brands are exposed to high volumes of international consumers, increasing both their value and their vulnerability. In addition, several jurisdictions function as logistical and re-export hubs, meaning that gaps in protection in a single territory may have broader regional consequences. When coupled with the role of offshore corporate structures and the growth of emerging sectors such as fintech and digital services, IP protection in the region becomes not merely defensive, but a strategic necessity aligned with wider commercial considerations. In conclusion, the development of IP in the Caribbean reflects a region in transition, moving from legacy systems towards modern, internationally aligned frameworks. While it may not rival larger jurisdictions as a center for initial filings, its role within global IP strategies is increasingly significant. For practitioners and rights holders alike, understanding these evolving dynamics is essential. The trajectory is clear: greater integration, enhanced sophistication, and a growing recognition of IP as a cornerstone of economic progress. Page 14. Profile: Dominican Republic. Name: Vanessa Cabrera. Title: Partner. Company: Eproint. Country: Dominican Republic. Website: www.eproint.com. Vanessa Cabrera is an attorney with more than 20 years of experience in the practice of IP, regulatory, and corporate law. She is a graduate of the law school at the University of Action Pro Education and Culture, APEC. She holds a master's degree in business law from the Antonio de Nebrija University in Madrid, Spain. Throughout her career, Cabrera has built a reputation for her unwavering sense of responsibility, strong professional ethics, and deep commitment to her clients. Her practice is defined by a strategic, detail-oriented approach and a constant pursuit of excellence, which has positioned her as a highly trusted advisor and a sought-after professional. Her ability to anticipate risks, design effective legal strategies, and deliver results with precision has made her services consistently in high demand among both local and international clients. Cabrera currently serves as partner at Eproint, leading the Dominican Republic office, where she advises local and international clients on the protection, enforcement, and strategic management of their IP rights. Cabrera has combined her practice with civil, commercial, and administrative litigation that affect the aforementioned areas of law. She is a former career prosecutor of the Attorney General's Office of the Dominican Republic and obtained a specialization in criminal sciences from the Universidad Autónoma de Santo Domingo, UASD, to reach that position. In the past, she oversaw the litigation department of a prestigious firm in the country, representing important local and international clients in the protection and defense of their intellectual rights. Her career includes experience in applications and maintenance of patents of invention, utility models and industrial designs, registrations of distinctive signs, their renewals and modifying acts, copyright registration, obtaining and renewing sanitary registration, among others. Cabrera has been recognized for her work in IP by Chambers, Legal 500, and World Trademark Review. In addition to her professional practice, Cabrera has demonstrated a strong commitment to academic excellence and the development of future legal professionals. She is a professor at the Pontificia Universidad Católica Madre y Maestra, PUCMM, in the subject of Trade and Intellectual Property in the Master of International Relations, and at the University UASD. She has also been a teacher in the Diploma of Intellectual Property of the Judicial Gazette and in the Summer Law School ADED Criminal Law. Cabrera has participated as speaker in congresses and webinars of the Intellectual Property Unit of the General Attorney's Office, International Trademark Association, INTA, and the Inter-American Association of Intellectual Property, ASIPI. Similarly, she has led outstanding projects in the anti-piracy committees of said associations and has represented multinational companies in the training of notorious brands for prosecutors and DR authorities. She has written legal guides for well-known foreign and local companies and has published articles such as Counterfeiting Medicines, What to Do, Actions for Infringement of the Industrial Property Law in Accordance with the Criminal Procedure Code, and Counterfeiting and Piracy in the Dominican Republic. Cabrera is a member of various IP associations, such as ASIPI, INTA, and AIPPI, serving on the Unfair Competition Committee of ASIPI. Page 15. Profile, USA. Name, Michelle S. Katz. Title, Michelle, Founding Partner. Company, Advitum IP, LLC. Country, USA. Website, www.advitumip.com. Michelle Katz, the co-founder of the IP law firm Advitum IP, LLC, based in Chicago, has provided powerful expertise in client counseling, strategic analysis, licensing, prosecution, and litigation across all areas of IP law for more than 20 years. Her diverse skill set and drive to deliver results apply equally to obtaining trademark and copyright registrations and issued patents as they do in obtaining favorable outcomes in state and federal court and before the Trademark Trial and Appeal Board, U.S. Customs, and the U.S. Court of Appeals for the Federal Circuit. As a certified mediator, Katz has also helped parties reach creative solutions to their disputes. She is passionate about giving back in a meaningful and measurable way. Her firm, in collaboration with her family, started a scholarship fund in the name of her beloved father, an icon in the IP field, and annually funds a master's scholarship in the innovative sciences at the Hebrew University, Israel. In the same vein, Katz created an online program that mentors law students and new lawyers all over the world in all aspects of professional development and goal attainment. She also speaks annually for the Young Entrepreneurs Academy, YEA, about entity formation and IP. An advocate of education, Katz is also on the speaking circuit. She has spoken on high-level IP topics at global conferences as well as locally to business owners and students. As far as accolades go, Katz was included in IAM Strategy 300, the world's leading IP strategists 2019 present. She was selected as the only U.S. attorney to be featured in this inaugural issue of the Women's IP World Annual Magazine in 2019 and every year since. Now, also a host for the Women's IP World podcast. Recently, she's been recognized as an International Advisory Experts Award winner, a global alliance of well-established and experienced legal, financial, and consulting firms, included in Marquis Who's Who in America, the standard for reliable and comprehensive data for today's leaders. Selected as a leading lawyer, included in the top 100 alumni we love from her alma mater, the Hebrew University, voted into Illinois Super Lawyers, and a winner of the Corporate Intel Magazine Global Award for Trademark Litigation Expert of the Year in Illinois. Katz has passions outside of the IP world as well. She enjoys spending time with family, including her 4 children, traveling, refining her foreign language skills, getting her heart rate up with outdoor activities and riding her Peloton bike, and relaxing with food, wine, and whiskey tastings, which she turned into an educational Instagram blog at ordained_foodie. In the summer, she spends a week volunteering at La Semana, a week-long culture day camp for adopted children from Latin America and their families. Fostering cultural understanding has always been an integral part of Katz's personal life and Advitum IP's business practice. Cats would like to close the gap between those who want to expand their family through adoption and children waiting for a forever home, and founded the Plus One Adoption Foundation, a not-for-profit organization with a mission to increase awareness and provide vetted resources related to adoption. At Plusoni Adoption on Instagram and www.plusoniadoption.org. Connecting her wine sommelier certification and adoption mission, Katz has recently started a wine label, Wine for Good, to help move forward her foundation's efforts.
Page 16. Advertisement. Advitum IP Attorneys at Law. A calming influence in a chaotic world. Hackers, counterfeiters, squatters. When too much of daily professional life is filled with the stress of IP portfolio management, many companies and entrepreneurs turn to Michelle S. Katz. Calm, focused, thorough. Advitum IP Attorneys at Law. Trademarks, copyright, trade secrets, domain names, litigation, customs, anti-counterfeiting, licensing, alternative dispute, resolution, and portfolio management. www.advitumip.com.
Page 17. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: The Lanham Act Gets a Shot. How GLP-1s Are Testing the Boundaries of Trademark Law. Subhead: Michelle S. Katz, founding partner, and Noah Siskind, associate, of Advitum IP, LLC, USA, examine how the surge in GLP-1 weight loss drugs like Ozempic is pushing the boundaries of the Lanham Act amid false advertising frenzies. www.advitumip.com. The GLP-1 boom has not just changed medicine, it has changed culture. In just a few years, drugs like Ozempic, Wegovy, and Mounjaro moved from doctors' prescribing pads to dinner table conversation. They became shorthand for dramatic weight loss and for a new pharmaceutical promise, that a weekly injection could accomplish what decades of dieting, gym memberships, and sheer willpower often could not. With that cultural shift came commercial gravity. GLP-1 drugs are not simply prescriptions. They are brands, carefully built, heavily advertised, and instantly recognizable. Their names function almost like verbs in the public imagination. And as with any brand that becomes ubiquitous, they attract imitators, affiliates, substitutes, and marketers eager to harness the attention those names command. Where consumer demand spikes and supply tightens through insurance denials, high out-of-pocket prices, or pharmacy shortages, the market improvises. In the GLP-1 economy, that improvisation has taken the form of telehealth startups, subscription wellness platforms, medical spas, and compounding pharmacies offering semaglutide-based treatments framed as alternatives. Online, many of these sellers speak the same language consumers already recognize, the language of Ozempic. That linguistic shortcut is commercially powerful. Mentioning Ozempic, for example, signals legitimacy. It reassures buyers who may be anxious about injecting a medication sourced from a clinic they found on social media. It captures search traffic. It lowers friction in the purchasing decision. But it also blurs lines, sometimes deliberately, about what is actually being sold. That blurring is now triggering a wave of legal disputes under the federal statute that governs false advertising and misleading commercial claims, the Lanham Act. Under Section 43A of the Lanham Act, a company may be liable if it uses false or misleading representations of fact in commercial advertising that misrepresent the nature, characteristics, qualities, or geographic origin of its goods or services. Unlike classic trademark infringement, which focuses on source confusion, false advertising under the Act targets the substance of what is being said about a product. In the GLP-1 marketplace, the most legally fraught claims are not necessarily bold promises of weight loss. They are claims, explicit or implied, of equivalence. A telehealth platform may advertise semaglutide treatment while prominently referencing Ozempic. A clinic may reassure consumers that its injection is the same active ingredient or just like Wegovy. A landing page may appear in response to a search for Ozempic online and walk a consumer through a subscription checkout without clearly distinguishing between an FDA-approved product and a compounded alternative. These are not accidental phrasing choices. They leverage the enormous goodwill embedded in pharmaceutical brands owned by companies like Novo Nordisk and Eli Lilly and Company. Those companies invested billions in clinical trials, regulatory approval, manufacturing infrastructure, and brand development. The resulting products, Wegovy, for example, carry reputational weight that newer entrants cannot independently replicate. The legal question becomes whether referencing those brands merely describes a therapeutic category or whether it crosses into a misrepresentation about what consumers are receiving. The distinction between FDA-approved drugs and compounded medications sits at the center of these disputes. An FDA-approved drug is evaluated through controlled clinical trials, reviewed for safety and efficacy, manufactured under strict quality standards, and labeled for specific indications. Its marketing is tightly regulated. Compounded medications, by contrast, are prepared by pharmacies under certain statutory conditions to meet individualized patient needs. They may lawfully contain the same active ingredient, such as semaglutide, but they are not approved in the same way, and they may differ in formulation, dosing, or delivery. These regulatory differences can be medically significant. But online, those distinctions can dissolve behind sleek branding, influencer testimonials, and carefully curated FAQs. A consumer scrolling through social media may see semaglutide weight loss injection and reasonably infer equivalence with Ozempic or Wegovy. If the marketing context suggests interchangeability through imagery, comparison charts, or ambiguous phrasing, that inference may not be unreasonable. Under the Lanham Act, the key issue is not whether the advertiser technically avoided stating a falsehood. It is whether the net impression of the advertisement is misleading. Courts often analyze this through two pathways: literal falsity and implied falsity. A claim is literally false if it is untrue on its face. More commonly in this space, plaintiffs argue implied falsity, meaning that the overall message conveyed to reasonable consumers is misleading, even if individual statements are technically accurate. Saying a product contains semaglutide may be factually correct. Suggesting, through placement, emphasis, or omission, that it is therefore equivalent to an FDA-approved product may not be. The Food and Drug Administration regulates prescription drug promotion, and the Federal Trade Commission polices deceptive advertising more broadly. But neither agency can instantaneously monitor every telehealth funnel, affiliate landing page, or sponsored social media clip. The GLP-1 boom is unfolding across a decentralized digital marketplace. Influencers generate demand. Telehealth platforms give access. Compounding pharmacies fulfill it. Affiliate marketers amplify it. Content changes rapidly, sometimes daily. In that environment, the Lanham Act becomes a tool of private enforcement. Competitors do not need to wait for regulators. They can sue directly, alleging that misleading marketing is siphoning customers and damaging brand equity. To prevail, a plaintiff typically must show a false or misleading statement of fact in commercial advertising, that the statement actually deceived or had the tendency to deceive a substantial segment of the audience, that the deception is material and likely to influence purchasing decisions, that the defendant caused the statement to enter interstate commerce, and that the plaintiff has been or is likely to be injured as a result. In the GLP-1 context, materiality is often the critical factor. If consumers choose a product because they believe it is equivalent to or approved like Ozempic, that belief directly influences sales. These cases present unique evidentiary challenges. Online advertising is constantly changing. A landing page can be updated after a cease and desist letter, disclaimers may appear in revised campaigns, sponsored search results can vary by user, and social media ads may be visible only to targeted audiences. Plaintiffs must capture and preserve exactly what consumers actually saw, while defendants may argue that cited examples are outdated, unrepresentative, or offset by clarifying disclosures elsewhere. Courts must also evaluate consumer perception in a digital ecosystem shaped by speed and distraction. The reasonable consumer in this space is not reading a printed brochure at leisure. They are scanning, clicking, and checking out on a phone. Disclaimers, especially those buried in footers, may not cure an otherwise misleading net impression. The Lanham Act does not allow an advertiser to imply one message prominently and correct it inconspicuously. Another doctrinal tension arises when Lanham Act claims intersect with FDA regulatory determinations. Courts are cautious not to allow false advertising suits to become vehicles for private parties to enforce the Food, Drug, and Cosmetic Act indirectly. If a claim turns on whether a product was properly compounded under FDA rules, a court may hesitate to adjudicate technical compliance questions better suited to regulators. But when the dispute focuses on how a product is described to consumers, particularly claims of equivalence or approval, courts are more willing to engage. The GLP-1 disputes therefore test the boundary between regulatory oversight and marketplace truthfulness. They ask whether courts can police misleading marketing without stepping into the FDA's lane. The stakes extend beyond one class of drugs. GLP-1 medications may be the first truly viral pharmaceutical products of the social media era. They have been widely discussed online, endorsed by celebrities, and dissected by influencers. Their brand names carry cultural weight far beyond traditional prescription advertising. As medicine becomes increasingly consumer-facing, delivered through telehealth platforms and marketed with lifestyle aesthetics, the line between pharmaceutical promotion and brand storytelling will continue to blur. The incentives in this market are powerful. A single well-optimized keyword campaign referencing Ozempic can drive substantial traffic, while a carefully worded FAQ may reassure hesitant buyers, and a side-by-side comparison chart can convert curiosity into subscription revenue. Yet even in a competitive landscape fueled by digital marketing tactics, the Lanham Act imposes clear guardrails. It does not prohibit competition, nor does it forbid truthful references to competitor products. What it does prohibit are misrepresentations, whether express or implied, that distort consumer understanding of what is actually being sold. In a market where like Ozempic can mean anything from an identical active ingredient to loosely related weight loss support, that guardrail matters. The GLP-1 boom illustrates a broader truth about modern trademark law: brand names are economic assets with gravitational pull. When a name becomes shorthand for a category, competitors will test how closely they can orbit it without crossing legal boundaries. The Lanham Act, enacted in 1946, predates television drug commercials, internet pharmacies, and influencer marketing. Yet its core principle remains durable: commercial speech must not mislead consumers about the nature or qualities of a product. As courts confront GLP-1 disputes, they are not only resolving fights over semaglutide. They are shaping how pharmaceutical brands can be referenced in an era where medical treatment is marketed through search ads and subscription checkouts. Consumers may never read the complaints or the opinions, but they will live with the consequences of how clearly or ambiguously these powerful treatments are described. In the end, the question is not whether alternatives to Ozempic exist, it is whether the law will require sellers to say precisely what those alternatives are and what they are not. In a marketplace where an injection can transform a body, words can transform expectations. Under the Lanham Act, those words still matter.
Page 20. Advertisement. Abdel Razak and Associés, your IP experts in Haiti. 19 Rue Moise, Pétionville, Haiti. Telephone 509-3819-9200. Email vanessa@cabinetabdelrazak.com.
Page 21. Profile, Haiti. Name, Vanessa Abdelrazak. Title, Founder and Partner. Company, Abdelrazak and Associés. Country, Haiti. Website, www.abdel-razak.com. Vanessa Abdelrazak is an attorney registered with the Port-au-Prince Bar with over 15 years of experience advising and representing clients in Haiti and internationally. She is a trusted advocate for businesses, creators, and innovators, helping them protect and enforce their IP rights in an increasingly complex legal landscape. Her expertise in IP law spans trademark registration, copyright protection, patent filings, industrial designs, and brand enforcement. Abdelrazak has guided numerous companies, ranging from startups to multinational corporations, in securing and defending their IP assets in Haiti, ensuring compliance with local regulations. Her firm, Abdelrazak and Associés, is recognized for its strategic, client-centric approach, assisting businesses in navigating the registration, protection, and commercialization of their IP. In addition to its client services, Abdelrazak and Assassis engages in pro bono work aimed at helping young entrepreneurs and innovators by providing legal guidance on IP protection, business formation, and regulatory compliance. This initiative reflects Abdelrazak's dedication to fostering innovation and supporting emerging businesses in Haiti. She is a member of various global and regional IP-focused organizations, actively participating in global discussions on emerging IP challenges. Abdelrazak holds a law degree from Quisqueya University in Haiti and a master's in international and comparative environmental law from the University of Limoges, France. She also earned a master's in public law and a university diploma in comparative legal studies from Aix-Marseille University, France. Additionally, she obtained a diploma of advanced studies in international business law from the University of London and has pursued specialized training in trademark, copyright, and IP enforcement through programs with the World Intellectual Property Organization, WIPO. Her commitment to continuous learning is reflected in her participation in international IP conferences, legal training programs, and policy discussions. Abdelrazak regularly engages with global industry leaders, regulatory bodies, and businesses to stay ahead of emerging trends, enforcement strategies, and digital brand protection. Beyond her legal practice, Abdelrazak is dedicated to mentoring and educating the next generation of lawyers. Since 2016, she has been a lecturer in environmental and contracts law at Quisqueya University and frequently speaks on IP rights in business and innovation forums. A multilingual professional fluent in French, English, Spanish, and Haitian Creole, Abdelrazak seamlessly supports international clients looking to expand and protect their brands in Haiti. She is passionate about bridging the gap between IP law and business strategy, ensuring that her clients not only safeguard their rights but also leverage their IP assets for growth and innovation. Page 22. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Turning Innovation into Growth in Haiti. Subhead: Vanessa Abdelrazak, founder and partner at Abdelrazak and Assassis, Haiti, highlights how Haiti's abundant but largely informal innovation could drive sustainable economic growth if supported by stronger IP ecosystems. Website: www.abdel-razak.com. As an IP practitioner in Haiti, I am consistently struck by a structural paradox: innovation is both widespread and underleveraged. Haitian entrepreneurs, creators, and businesses continuously generate value through brands, processes, and creative outputs, yet this value is rarely captured within a framework that allows it to scale, attract investment, or integrate into global markets. This disconnect is not rooted in a lack of creativity or technical capacity. Rather, it reflects institutional, legal, and systemic limitations that prevent innovation from evolving into a formal driver of economic growth. When properly supported, innovation has the potential to become one of Haiti's most powerful economic engines, particularly in a context where traditional industrial models face significant constraints. Bridging informal innovation and a structured innovation economy through effective legal instruments. Innovation in Haiti is frequently informal, embedded in everyday business practices and problem-solving strategies. Entrepreneurs develop new product formulations, distribution methods, or service models without necessarily identifying them as IP assets. This is particularly evident in sectors such as agro-processing, cosmetics, construction techniques, and small-scale manufacturing. This situation reflects a significant reservoir of unrecognized economic value. While trademarks are increasingly understood, technical innovations, particularly process-based improvements, often remain outside any protection strategy. Yet, locally developed methods for food preservation, low-cost water filtration, or construction adapted to environmental constraints may, in certain cases, meet the criteria of novelty, inventive step, and industrial applicability as defined under international standards promoted by the World Intellectual Property Organization, WIPO. Despite this potential, patent filings remain rare. This is less a reflection of the absence of innovation than of limited awareness, procedural barriers, and lack of integration into international filing systems. As a result, innovations are frequently disclosed without strategic consideration or remain confined to local markets without protection. Encouraging greater familiarity with patent mechanisms would allow innovators to move beyond informal practices and engage more confidently in structured growth strategies. Protection of technical solutions, when appropriate, can facilitate partnerships, enhance credibility, and support expansion into new markets. Frugal innovation as a foundation for scalable solutions. Innovation in Haiti is often characterized by efficiency and adaptability, reflecting the constraints within which it develops. This has led to the emergence of solutions that are cost-effective, resource-conscious, and highly responsive to local needs. Such innovations, whether in energy, agriculture, or service delivery, are increasingly relevant beyond the Haitian context. Markets facing similar constraints are actively seeking solutions that combine functionality with affordability. Haiti's experience in developing such approaches positions it advantageously within this global trend. The key lies in ensuring that these innovations are not only effective, but also capable of being protected and scaled. By combining practical ingenuity with appropriate legal mechanisms, Haitian entrepreneurs can extend their reach and participate more actively in regional and international markets. SMEs and microenterprises as innovation laboratories. Haiti's SMEs and microenterprises operate as dynamic spaces of continuous experimentation, where innovation is driven by necessity and close interaction with market realities. In these environments, new ideas are tested, refined, and implemented in real time, often without formal recognition as intellectual assets. These businesses generate value through a combination of brand development, proprietary know-how, and incremental improvements in products or processes. However, without structured protection, this value remains vulnerable and difficult to leverage. Businesses may struggle to secure financing, expand through licensing, or maintain a competitive advantage in the face of imitation. Facilitating access to IP tools would enable these actors to convert their everyday innovation into recognized and transferable assets. A single registered trademark, for instance, can serve as a foundation for broader commercial strategies, supporting distribution agreements, brand positioning, and long-term growth. The structuring role of incubators in the entrepreneurial ecosystem. Over the past years, the emergence of incubators and entrepreneurial support structures has contributed significantly to bringing greater organization and strategic thinking into Haiti's innovation landscape. These initiatives have helped identify promising ventures, support their development, and connect entrepreneurs with broader networks. One of their most valuable contributions lies in the early introduction of business structuring practices. Entrepreneurs supported within these environments are more likely to formalize their activities, clarify their governance, and consider issues such as brand protection and scalability from the outset. This shift in approach is critical, as it allows innovation to evolve within a framework that supports long-term growth rather than remaining confined to informal markets. Strengthening these support structures and integrating more systematic guidance on IP and legal strategy would further enhance their impact, ensuring that innovation is not only encouraged but also effectively anchored within a sustainable economic model. Universities and research and development as emerging pillars of innovation. Haiti's academic institutions represent an important, though still developing, component of the innovation ecosystem. They concentrate significant intellectual capital, particularly in technical and scientific fields, and hold the potential to contribute more directly to applied innovation. There is increasing scope for universities to engage in research aligned with local economic needs, develop technical solutions with commercial applications, and collaborate more closely with private sector actors. In many jurisdictions, such collaboration has led to the emergence of structured research and development ecosystems, where academic research translates into patentable technologies and marketable products. For Haiti, strengthening this dynamic would involve clarifying ownership of research outputs, encouraging partnerships between academia and industry, and supporting the protection and commercialization of innovations. By doing so, universities can evolve from primarily educational institutions into active contributors to a knowledge-based economy. Diaspora-driven innovation and knowledge transfer. The Haitian diaspora constitutes a strategic extension of the national innovation ecosystem. With expertise in advanced sectors and exposure to international markets, diaspora professionals are uniquely positioned to contribute to innovation development in Haiti. Their involvement can take multiple forms, including collaboration on technical projects, investment in local ventures, and transfer of knowledge and best practices. In the context of more technical innovation, such collaboration can also facilitate access to international protection systems and enhance the overall credibility of projects. Creating conditions that support these interactions, through clear contractual frameworks and predictable regulatory environments, would allow Haiti to more fully leverage this resource. The diaspora, in this sense, represents not only a source of capital but also a bridge between local innovation and global opportunity. Strengthening legal frameworks to unlock investment and scale. For innovation to attract investment and achieve scale, it must operate within an environment characterized by clarity, reliability, and predictability. Investors and partners seek assurance that rights will be respected, agreements enforced, and assets secured. Enhancing these conditions would contribute to increased confidence and facilitate the development of partnerships and investment flows. In particular, the recognition and protection of intangible assets, brands, technologies, and creative outputs play a central role in shaping investment decisions. The availability of efficient dispute resolution mechanisms, including arbitration, further reinforces this environment by providing practical solutions for managing risk and resolving conflicts. Haiti's innovation potential is both tangible and significant. It is reflected in the daily activities of entrepreneurs, the creativity of its industries, and the evolving structures that support business development. The challenge is not to create innovation, but to structure, protect, and amplify it. IP and legal frameworks serve as essential enablers in this process, allowing innovation to move from informal practice to recognized economic asset. By strengthening awareness of patent protection, supporting entrepreneurial ecosystems, engaging academic institutions, and leveraging diaspora expertise, Haiti can build a more integrated and dynamic innovation economy. Innovation, in this context, represents more than an opportunity. It is a pathway toward sustainable growth, capable of redefining Haiti's economic trajectory through creativity, resilience, and strategic legal infrastructure. Page 25. Profiles: Turks and Caicos Islands. Profile 1. Name: Louise Malcolm. Title: Partner. Company: Miller Simons O'Sullivan. Country: Turks and Caicos Islands. Website: www.mslaw.tc. Louise Malcolm is an experienced attorney who has been practicing in the Turks and Caicos Islands, TCI, for over 18 years. Malcolm is a Turks and Caicos Islander who spent a great part of her life until her early adult years moving around the Caribbean while also completing her secondary and tertiary education in the US and UK. Malcolm graduated from Oklahoma City University in 2003 with a Bachelor of Arts degree in political science. Malcolm then obtained her law degree in 2006 at the University of Bristol in England, followed by the legal practice course in 2007 at the University of the West of England in Bristol, England. Following her time in England, Malcolm returned to the TCI and immediately commenced work at Miller Simons O'Sullivan, MSO, as an associate. MSO is one of the oldest and largest law firms in the TCI, having been established in 1981. The firm offers a full range of legal services and provides advice to leading international law firms, major financial institutions, and both domestic and international clients. MSO is also one of the leading law firms in the TCI that provides IP services, and the firm's clients own both regionally and internationally recognized marks. Malcolm was called to the bar in the TCI in 2008. In 2009, Malcolm was admitted as a solicitor in England and Wales. In October 2023, Malcolm became the first female partner of MSO. Malcolm has been part of the IP department of MSO for the majority of her time with the firm. She plays a large role in this department, with a heavy focus on trademarks and patents, and has assisted the department in providing effective services to the various clients and advising clients on key issues to enable satisfactory protection of their marks in the jurisdiction. Malcolm's practice areas are diverse and include residential and commercial property, immigration, banking and finance, and aviation in addition to IP. Malcolm is a member of the TCI Bar Association, the Law Society of England and Wales, the International Trademarks Association, INTA, and the Intellectual Property Caribbean Association, IPCA. In addition, she previously acted as the treasurer of the TCI Bar Association and as an ad hoc member of the Labour Tribunal of the TCI. In her free time, Malcolm enjoys giving back to the community. She is a former member of the Rotaract Club, and she currently supports the TC Health and Wellness Foundation. She also enjoys keeping fit and spending time with her family. Profile 2. Name: Deborah Yvonne Garland. Title: Trademark Administrator. Company: Miller Simons O'Sullivan. Country: Turks and Caicos Islands. Website: www.mslaw.tc. Deborah Garland is a trademark administrator who has been working with Miller Simons O'Sullivan, MSO, for 30 years. MSO is one of the oldest and largest law firms in the TCI, having been established in 1981. The firm offers a full range of legal services and provides advice to leading international law firms, major financial institutions, and both domestic and international clients. MSO is also one of the leading law firms in the TCI that provides IP services, and the firm's clients own both regionally and internationally recognized marks. Garland, who is known professionally by her middle name Yvonne, is a Turks and Caicos Islander who was born and raised in Grand Turk, the capital island of the TCI. Garland first began providing general administrative services at MSO, then joined the firm's IP department. During her time in the IP department, Garland has assisted MSO in fostering a strong relationship with the Trademarks Registry. She became responsible for maintaining the firm's increasing database of client trademarks, which enabled Garland to ensure the accurate record-keeping by the Trademarks Registry for these marks. Her efforts with the Trademarks Registry assisted the firm's department in providing effective services to its various clients and in ensuring satisfactory protection of their marks within the jurisdiction. Garland is a member of the International Trademarks Association, INTA, and the Intellectual Property Caribbean Association, IPCA. In her free time, Garland enjoys cooking and spending time with her family. She also enjoys being involved in her church and community, and uses her creative side to assist with the printed materials required for various functions taking place on island. Page 27. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Brand Protection in the Turks and Caicos Islands. Subhead: Louise Malcolm, partner at Miller Simons O'Sullivan, Turks and Caicos Islands, outlines how the Turks and Caicos Islands' evolving trademark and patent frameworks are supporting growing local and international brands while highlighting the need for broader, more accessible IP protection. Website: www.mslaw.tc. The Turks and Caicos Islands, TCI, is a British overseas territory located in the Caribbean. The TCI consists of approximately 40 islands and keys, 9 of which are currently inhabited. The TCI is located below the Bahamas and above the Dominican Republic and Haiti, and its proximity to the east coast of the U.S. enables it to benefit from direct flights to multiple U.S. cities. The TCI is also a popular luxury tourist destination, attracting over 1 million tourists annually. The TCI is undergoing major developments in the tourism industry, with several new hotels, including internationally known hotel brands, and condominium developments underway. The growing interest in the TCI has also boosted non-tourism industries here, and, by extension, the TCI has seen an increase in IP applications for local and internationally recognized brands. The TCI prides itself on its straightforward brand protection process. It is currently possible to maintain both trademarks and patents in the TCI, and the Trademarks Registry and the Patents Registry are both located on Grand Turk, the capital island of the TCI. With the expansion of local businesses, local products, and also local hotel developers in the TCI, proprietors have the opportunity to protect their business brands on island. Proprietors of international marks also receive the reassurance that their marks can be specifically protected in this jurisdiction. Whilst it is a British overseas territory, the TCI has its own legislation which includes the Trademarks Act, formerly the Trademarks Ordinance, Cap 17.04, and the Patents Act, formerly the Patents Ordinance, Cap 17.03. Trademarks. The Trademarks Act was first enacted in 1978 and enabled marks to be registered and protected in the TCI. This Act, as amended, currently enables the registration of marks within 34 classes of goods and 11 classes of services, pursuant to the 7th edition of the NICE Classification Treaty. It is currently possible to register the following types of marks in the TCI. Word marks, which can include a single word or a phrase containing words, numbers, and symbols. Figurative marks, which can include a design or logo that contains a single color or multiple colors. Certification marks, which are marks that distinguish certain goods or services from others as being certified with respect to their characteristics, including their geographical origin and materials. Collective marks, which distinguish the goods or services of members of an association. Registration applications generally take upwards of 8 weeks to complete, provided there is no opposition to the application. It is also possible for a mark to be registered in multiple classes, enabling proprietors to obtain extensive protection for their brands within a single jurisdiction. The TCI also accommodates priority applications for trademarks. Trademarks that have been registered in the United Kingdom or a convention country to which the TCI is a party to have a right to priority of registration in the TCI. However, these priority applications must be submitted to the TCI within 12 months of the overseas registration date. Registered trademarks have a 10-year registration term, which can be extended for further 10-year periods at renewal. Whilst the annual maintenance of trademarks is also required, such fees can be submitted annually or in lump sums as desired by the proprietor. The Trademarks Act makes it possible for proprietors to amend the details of their marks if necessary and also seamlessly facilitates the assignment of marks. This gives proprietors the confidence that their brand protection can be maintained and updated as they operate and promote their businesses. Patents. The Patents Act was first enacted in the TCI in 1990, enabling patent registration in the jurisdiction. However, patents must first be registered in either the UK or the European Union (EU) before they can be registered in the TCI. Applications in the TCI are to be submitted within 5 years from the date of grant in the UK or the EU, and the patents are maintained in the TCI as long as they remain maintained overseas. Proof of the UK or EU grant and the patent specifications must accompany the TCI registration application. Registration applications generally take upwards of 12 weeks to complete, provided there is no opposition to the application. This requirement for prior registration in the UK or EU enables a more straightforward approach for international patent owners, as patent maintenance is generally focused on the UK or EU patent. Copyright. The TCI currently does not have local legislation to provide copyright protection. Any protection rights will derive from English common law. Moving forward. In light of the general development of the TCI's economy and the international economy, it is important to ensure that trademark protection in the TCI evolves alongside this economic expansion. This will guarantee that local and international brand owners can continue to receive the protection relevant to the ever-changing economic climate. A keen insight into the development of the TCI economy and the international economy will also require the evolution of the classes of goods and services currently permitted under the Trademarks Act. From a long-term perspective, the TCI may wish to consider whether additional IP protection options are possible, so that local and international brand owners can benefit from stronger brand protection. It will also be essential for the general public to become more aware that brand protection is available, so that local businesses can utilize the protection options properly. As a result, the TCI ought to experience a reduced likelihood of infringement and a reduced need for enforcement against counterfeit products. As much as increased protection is encouraging for local businesses, the requirement to register patents abroad before registering them in the TCI may be perceived as a challenge to patent protection for local inventors. Upcoming local proprietors are more likely to face constraints than well-established local proprietors, which may make it difficult for them to arrange overseas patent protection. This challenge may lead local proprietors to forego patent protection, which could adversely affect their businesses and the use of their inventions. It is hoped that it will eventually become possible for local inventors to register their patents locally before needing to register them overseas. The continued efforts by the TCI to support proprietors will encourage further development of the local economy and greater protection of local brands. This support for local proprietors will also encourage additional international proprietors to protect their marks in this jurisdiction. The future for brand protection in the TCI is bright.
Segment page. South America. Women's IP World Annual 2026.
Page 31. Profile, Peru. Name, Adriana Barrera. Title, Founding and Managing Partner. Company, Barlaw, Barrera and Asociados. Country, Peru. Website, www.barlaw.com.pe. Adriana Barrera, a lawyer with almost 30 years of experience, advises global corporations, developing comprehensive strategies for the protection, defense, and litigation of trademarks, unfair competition, copyrights, patents, and the protection of personal data. She graduated from the University of Lima, Peru, and completed postgraduate studies at PAD School of Senior Management, Universidad Pura, Peru, Franklin Pierce Law Center, LLM, USA, and the University of Salamanca, Spain. For more than 20 years, she has been an active member of various committees within leading professional associations, including INTA, Marques, AIPPI, APPI, IAPP, IACC, ASAPI, ECTA, and AMM, member since 2017. Notably, she served as president of the IP Commission of the American Chamber of Commerce in Peru, 2021 to 2022, and is currently a member of the board of directors of its IP Commission. She is also a member of ASIPI's Diversity, Equity, and Inclusion Working Committee for the 2026 to 2027 term and a member of INTA's Law Firm Committee for the 2026 to 2027 period. Also, she has been invited to participate in the Global Advisory Council of Latin America and the Caribbean for a period of 2 years, which is an elite group of INTA. Since last year, she has been recognized as an expert for Peru within UNIFAB, Union des Fabricants. Adriana has shared her expertise through talks, panels, and interviews across various platforms, both online and in person, as well as at the international level. Her presentations in the past year include a webinar on copyright protection in the digital age, challenges and opportunities for authors and publishers at UNIFE, Universidad Femenina del Sagrado Corazon, a moderator role on the future of IP enforcement in Latin America, AI, legal innovation and return on enforcement at the IACC Annual Conference 2025, and as speaker on the panel Regulating AI, What the AI Act Means for Business and Innovation at the Leaders League Alliance Summit. During 2025, she shared her expertise as a speaker in the webinar Intellectual Property Valuation, co-organized by ECTA and ASAPI, and participated in the ASAPI podcast episode Fight Against Customs Crimes and Piracy in Peru, originally in Spanish. She also appeared in episode 3 of season 5 of the Women's IP World podcast, where she discussed the evolving landscape of non-traditional trademarks and the strategic advantages of the IP framework in the Andean region. She participated as a LATAM expert speaker at the ACAP Center Brand Protection Strategy Summit at the University of Michigan in both 2025 and 2026. In addition, she was a speaker at the 2025 European Forum of Intellectual Property organized by UNIFAB, and in 2025, she served as one of the professors at the ASAPI Academy for the course titled Trademark Law in the 4.0 Industrial Revolution. She also writes articles and contributes to various publications, including ASAPI, the Legal Industry Review, INTA Bulletin, Marquesa, and World Trademark Review. Our managing partner was recognized by Women's IP World in the top 100 influential women leaders in IP law, champions of leadership, innovation, and global influence ranking, ranked number 1 in the leadership and vision category in 2025. And among the top 3 in the leadership in IP commercialization and licensing category in 2026. She was recognized by WTR 1000 as a gold tier individual in 2025 and 2026. Adriana has been recognized for more than 12 consecutive years as Latin America Anti-Counterfeiting Recommended Lawyer, and was the only Peruvian lawyer listed in 2026. She was named a Global Leader, Private Practice by WTR Global Leaders, nominated for Partner of the Year at the Luxury Law Awards, listed among the top 250 women in IP 2025 by IP Stars, and recognized as one of Latin America's top private practitioners by Latin Lawyer Lacquer. Page 32. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Strategy to Successfully Enforce Your Brands in Peru. Subhead: Adriana Barrera, Founding and Managing Partner at Barlaw, Barrera and Asociados, Peru. Website: www.barlaw.com.pe. Brand owners consistently face difficulties enforcing their IP rights across different jurisdictions. After evaluating the best way to protect their creativity, innovation, and distinctive elements that have earned a reputation with consumers, brand owners need to fight against bad actors who try to infringe on their protected rights. In Peru, as in other Latin American countries, it is possible to protect IP through trademarks, copyrights, designs, patents, and trade secrets. Non-traditional elements, e.g., packaging or product design, shape, or color, may be protected in one of three ways. As 3D and other non-traditional trademarks, if the protected elements show inherent or acquired distinctiveness, registration lasts for 10 years with renewal for indefinite periods. As industrial designs, when novel, may be registered before Patent Office for 10 years with no additional renewal period, or as copyrights, original artworks, which do not need to be registered, but showing copyright. Registration in any other country may help for enforcement purposes. Once protected, it is important to establish a complete brand protection and enforcement strategy. Nowadays, a proper strategy needs to cover both online and offline markets, which include the following recommended steps. Initial assessment and market surveillance. Depending on the case, we may recommend the following actions. 1. Market survey in key areas to identify infringers and counterfeits and assess the scope of infringement. This is important for answering the initial questions that may arise, such as which brands are involved, whether the threat is online and/or offline markets, the extent of the illegal activity, and the number of counterfeiters. 2. Once the targets have been identified, it is important to investigate and determine which are most important to pursue with enforcement action. An online investigation may include monitoring social media, e-commerce platforms, marketplaces, and web pages to obtain evidence of fake or infringing goods and to obtain digital content certifications that may be used as evidence in a legal action. When possible, a test purchase should be conducted. It is also important to conduct searches in public registries to obtain accurate information on counterfeits and infringers, such as names and addresses, the number of establishments, identification of related individuals and/or companies, and monitoring of importation or exportation records in the customs database. Offline investigation is advisable to verify physical premises, such as warehouses, stores, and workshops, and to identify the routes most commonly used to offer their products, as well as how they manufacture and distribute the infringing goods. At this stage, it is important to obtain photographic evidence and proceed with test purchases. Enforcement. Once the targets are identified and evidence is collected, we may decide to send a cease and desist letter or initiate administrative and/or criminal legal actions. Cease and desist letters. It is not always advisable to send a cease and desist letter as a first step to enforce IP rights. In most cases, it is better to skip this stage due to the informality of the infringer. Before sending the cease and desist, the idea is to secure certified evidence that may be obtained through certified online content or a certified test purchase. Otherwise, the infringer could try to make the evidence disappear. The cease and desist letters are sent, particularly when the infringer is a formal business and/or the volume of infringing products is limited and/or a more strategic approach is advisable to avoid reputational impact or where rights may be less robust. The main goal is to enter into out-of-court agreements, undertakings. The letters may be legally based on trademark or copyright infringement, design infringement, unfair competition, or any other relevant legal grounds. In the event of a positive response, the brand owner may initiate negotiations with the infringer and seek to settle. Among the terms of the agreement shall be included the immediate cessation of the infringement, an economic penalty clause, recovery of legal fees and expenses, destruction or donation of infringing goods, and the recognition, by the counterfeiter, of the IP rights. Additionally, the recommendation is to monitor and act against online infringement across social media, e-commerce platforms, and marketplaces through takedown actions and digital evidence collection, especially when the infringement occurs only online. Legal actions. In Peru, there are two ways to fight counterfeiting infringement of IP rights: administrative and criminal actions. 1. Administrative actions: trademark, copyright, and patent office. An administrative action can be initiated as a first step or when we do not receive a positive response after a cease and desist letter. Any trademark, copyright, or design owner may file an administrative claim before the Peruvian Trademark, Copyright and Patent Office, INDICOPI, against any third party who is infringing its IP rights. When detecting an infringement, be it in manufacturing, distribution, transportation, commercialization, or importation and exportation, the IP owner can A. File an IP infringement action before the INDICOPI, requesting an inspection, most often when the owner is certain of infringement. B. Request an inspection at the infringing premises in order to verify products, obtain samples and/or pictures. After verifying the goods, the owner could decide whether to file a trademark or any other IP right infringement, most commonly with importation and exportation, when the owner is not positive of infringement. In any of these cases, law enforcement may order the seizure or immobilization of the infringing goods as precautionary measures. Claims may be based on trademark infringement, or trademark infringement combined with unfair competition acts, exploitation of another's reputation and likelihood of confusion. Trade name infringement, which requires proof of use and may also be used as a defense by the infringer as long as the use is proven before the registration date of the trademark. Copyright infringement, which requires a declaration of ownership to proceed. Unfair competition grounds, only when no registered IP right is available or the conduct falls under general unfair competition, including acts of deception, denigration, improper comparison or association, breach of sectoral regulations, or any conduct contrary to good faith in business, under the general clause. In Peru, it is possible to stop suspected merchandise at the borders through customs seizures under the Peruvian Borders Measures legislation. Customs recordation is a key procedure to successfully stop merchandise at borders. According to Peruvian statutes, any third party may record its trademarks and/or copyrights with customs. Once companies or individuals record IP rights, it is easier to receive alerts of suspected merchandise from customs officers. If border measures are not applied by customs officials, the regular IP infringement proceedings remain available. Training seminars for law enforcement are an important tool for brand protection because they keep authorities updated on and involved in the brand owner's strategy and objectives. Generally speaking, these are the legal steps in an administrative proceeding. 1. File a claim and request precautionary measures and an injunction, cease of use, seizure of infringing merchandise, closure of establishment. 2. Inspection at the infringer's premises or at customs warehouses. If the infringer refuses to open the doors or permit law enforcement to inspect the premises, the infringer may be fined. 3. Conciliation hearing or settlement. Law enforcement may schedule a conciliation hearing after the inspection. Alternatively, out-of-court settlements may be reached and submitted for approval. If no agreement is reached, the authority issues a first-instance decision. 4. First-instance resolution. The decision may order the payment of a fine, collected by law enforcement, or a warning, in cases involving small quantities. Payment of legal fees and expenses. Definitive seizure of the infringing products, and a permanent cessation of use of the infringing sign. In rare cases, additional measures may be included if previously requested as injunctions. Time frame for issuance of an administrative decision. First instance, from the filing of the claim legally 180 business days, approximate. 9 months, in practice, 18 to 24 months. Second instance, Legally 180 business days, approximate. 9 months, in practice, 12 to 18 months. Advantages. 1. The administrative action does not preclude other civil or criminal actions, meaning that, depending on the importance of the case, the IP right owner could seek indemnity or file a criminal claim against the infringer. 2. This action is very helpful for border measures, since customs and Indocopi have a good line of communication to stop the importation-exportation of counterfeit goods. 3. The goods are almost always taken to a private warehouse until the end of the procedure. 4. The parties could settle. In a settlement, the IP rights owner may decide whether to donate or destroy the goods. Disadvantages. 1. It is difficult to collect fines imposed on infringers because no crime is involved. 2. Indocopi does not always carry out large-scale raids at important galleries or clandestine factories, since it has to request police assistance for these matters. 2. Criminal actions. Crimes against IP rights are set out in the Peruvian Criminal Code. The action can be started with a criminal claim filed by a trademark or copyright owner before the public prosecutor or the police specialized in IP matters, or with an ex officio raid. The IP owner may request an inspection, in coordination with the police and a prosecutor specialized in IP matters, at the location where the fake goods are being manufactured or commercialized, where seizure or immobilization of the goods is ordered. The public prosecutor may invite the parties to try to settle the case but will suggest the terms of settlement. For large raids or clandestine factories and workshops that frequently change location, police support is required. After this, the prosecutor investigates the case and, depending on the evidence filed, may decide to file a claim before the criminal court. As the criminal case is a public action, the IP owner participates in this process only as a third party. The seized goods remain at the IP police or prosecutor warehouse. Usually, seized goods are donated or destroyed, toxic goods generally, at the end of the proceedings. If found guilty, the infringer may face a jail sentence of up to 5 years and a fine. A criminal case may last around 2 to 3 years. Sometimes, after many years of litigation, jail sentences are not effective. The defendant is released from the charges and is ordered to pay only civil compensation, following long proceedings in which the IP rights owner is only a third party, as the prosecutor is the party that files the claim before the judge.
Page 36. Advertisement. Estrategia jurídica. Compliance and IP law services. During our years of service, we have managed to succeed in the following matters for our clients: risk management and regulatory exposure, anti-corruption and regulatory compliance, compliance frameworks and internal controls, risk environment assessment, governance, oversight, and reputational risk. Bogota, Colombia. Contact us. Telephone 571-638-1071. Email estrategia@estrategiajuridica.company. www.estrategiajuridica.co.
Page 37. Profile. Colombia. Name, Claudette Vernet. Title, Managing Director and Chief Legal Counsel. Company, Estrategia Juridica. Country, Colombia. Website, www.estrategiajuridica.co. Claudette Vernet advises multinational companies on brand protection programs, regulatory compliance, and the enforcement of IP rights. She supports clients in developing market expansion strategies by providing effective solutions to combat smuggling and counterfeiting, as well as the recovery of damages. She currently leads a legal team that delivers strategic and effective solutions for the defense and management of IP portfolios and business strategies. With a results-driven approach, Vernet has become a trusted advisor for companies seeking to strengthen their presence in Latin America and safeguard their brands in highly regulated and competitive markets. Vernet and her team maintain a strong presence in Colombia's main ports, where they have developed and delivered academic training programs covering trademark law, criminal procedure, investigative techniques, and online enforcement actions related to trademark and copyright infringement on digital platforms. In 2025, the firm trained more than 600 customs and police officers across various ports and cities in Colombia. Her leadership has positioned the team as a key ally for enforcement authorities, enhancing national capabilities to detect, prevent, and prosecute IP violations. Through a network of local consultants and service providers, the firm offers comprehensive nationwide coverage, enabling brand owners to access a complete portfolio of enforcement and protection services. In coordination with Colombian customs and enforcement authorities, the firm has initiated more than 235,000 seizures at ports throughout the country. The firm also supports clients entering the Latin American market by guiding them through company incorporation processes and advising on best practices for the management of regional IP portfolios. Achievements and affiliations. Vernet is a member of the Colombian Association of Intellectual Property, ACPI, the Caribbean Intellectual Property Association, IPCA, the Inter-American Intellectual Property Association, ASAPI, the Association of Trademark Law Specialists, APRAM, and the International Trademark Association, INTA. Since 2025, Estrategia Juridica has been appointed by the French association UNIFAB as part of its College of Experts, representing the Colombian jurisdiction. In 2025, Vernet obtained a master's degree in compliance, fraud, and anti-money laundering from the Spanish business school EALDE. Her academic background, combined with her extensive field experience, strengthens her ability to design robust compliance frameworks and advise clients on risk mitigation across complex regulatory environments. Practice areas: brand protection, criminal law, unfair competition, trademarks, consumer law, compliance. Languages: Spanish, English, French, and Italian. Page 38. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Compliance as a Competitive Edge for IP Law Firms. Subhead: Claudette Vernet, Managing Director and Chief Legal Counsel of Estrategia Juridica, Colombia, explains how embedding rigorous compliance into IP practice transforms brand protection from a defensive obligation into a strategic competitive advantage. Website: www.estrategiajuridica.co. In the competitive Colombian legal market, IP firms that do not integrate compliance into their DNA are doing their clients a disservice. A fully integrated brand protection program begins with due diligence to identify risks, market surveys to detect entry barriers and opportunities, and competitive research to understand the market and guard against unfair business practices. A brand protection program that emphasizes compliance at every step is built on a firm foundation and avoids future problems related to undesirable business partners, corruption, liability, and regulatory pitfalls. Incorporating a compliance program into a market strategy, whether in-house or outsourced, is no longer a luxury. It is both a necessity and a strategic advantage that strengthens credibility with clients, investors, and authorities. This article briefly explores why law firms must adapt to this new reality and outlines some basic steps to integrate compliance into their practice. IP lawyers are constantly interacting with prosecutorial offices, prosecutors' assistants, judges, police, and official forensic document examiners. They draft all criminal complaints and handle the entire process until a final judgment is rendered. Latin American judicial systems are notoriously corrupt. Judges, prosecutors, and attorneys are subject to undue influence to dispose of cases for personal or economic gain. An IP holder who is not diligent in monitoring the legal processes can run the risk of being inadvertently involved in a criminal act, for example, if their business partner or lawyer engages in unlawful activity. This can result in sanctions, the loss of IP rights in the jurisdiction, or reputational damage. The managing director of the firm is responsible for coordinating with the director of the IP area to ensure that payments do not include bribes and to understand when facilitating payments are accepted in compliance with the Foreign Corrupt Practices Act, FCPA, local anti-bribery regulations, and ISO Standard 37001 of 2016. The fast-paced environment, competitive pressures, and sometimes opaque nature of judicial proceedings create opportunities for corruption. Some bad practices could include data manipulation, e.g., the falsification of seizure numbers and the alteration of judicial judgments. The way to combat this is through written policies and contracts with personnel, strict supervision, regular review and controls of payments, and checks and balances within the firm. Having more than one person involved in processes limits opportunities for corruption. A good internal but independent financial review is also key, as is the restriction of access to client files based on the specific permissions of each position. This ensures that only authorized personnel handle sensitive information related to ongoing cases and has the added benefit of operational integrity. Oversight of collaborations with third parties, e.g., investigative firms, is also critical. Again, formalization of relationships with contracts, detailing expectations, and compliant conduct is fundamental. This includes destruction companies where codifying compliance and standards of proof, e.g., requiring certifications and photos, can avoid risks such as contraband re-entering the marketplace or being destroyed in a manner inconsistent with environmental and safety standards, thereby reducing risks of environmental liability. ISO 14001 standard. Other recommendations. Short-term maintenance of digital records of all due diligence materials, including contracts and correspondence, ensuring compliance with data retention laws. Medium-term implementation of an internal investigation system and identification of the company's strengths and weaknesses, as well as the opportunities and threats of the environment in which it operates. Long-term formalization of contracts with destruction agencies to include compliance clauses, requiring semi-annual reviews of their adherence to environmental and safety standards. The implementation of a compliance program in an IP law firm or department follows the principles of the 3Cs: codification, controls, and communication. Every party involved with an IP practice must be subject to a contract detailing roles, responsibilities, and results. Controls must be in place to provide regular review of work, payments, and checks and balances, and to secure sensitive information on a need-to-know basis. Written policies, procedures, training, and reporting mechanisms and response protocols must be implemented to encourage reporting of irregularities and follow-up. In the implementation of a compliance area within IP law firms, it is necessary to strengthen incident response protocols that include immediate notification to the compliance officer, client notification procedures, and subsequent reviews, using governance, risk, and compliance tools to record incidents and monitor corrective measures. The goal is to create a culture of compliance in your IP law firm or department. This begins with hiring the right people and then training them to do the right thing. This involves demonstrating the benefits of ethical professional conduct and the risks of non-compliance. A compliance program is not an accessory for IP law firms, it is the structure that sustains credibility, prevents exposure to corruption risks, and protects the value of clients' intellectual assets. Firms that embed compliance into every operational layer position themselves as trustworthy, resilient, and aligned with global best practices, strengthening both their reputation and the long-term protection of the rights they defend.
Page 40. Advertisement. Northon's Media PR and Marketing Ltd presents IP360 Hub, the global industry profile guide, connecting the global IP community. IP360 Hub connects IP professionals, law firms, and service providers through an affordable print and digital interactive networking platform, where the IP world connects effortlessly through profiles, advertisement, and service and rates listing. Printed handbook and interactive digital platform. Launching in early 2027. IP lawyers, counsel, service providers, advisors, industry partners. Visit www.ip360hub.com. Email info@ip360hub.com. Phone 4402038130457.
Page 41. Profile, Republic of Suriname. Name, Elson Frank. Title, Attorney and Founder. Company, Vision Legalis Advocaten. Country, Republic of Suriname. Website, www.visionlegalis.com. Elson M. Frank is an attorney and founder of the law firm Vision Legalis Advocaten in Paramaribo, Suriname. She started the law firm in 2018 after 14 years at one of the larger law firms. She has a general practice, and her work involves legal advice on various areas of law, including business law, employment law, inheritance succession law, and, of course, IP law. During her 19 years as an attorney, She has developed a passion for assisting entrepreneurs and SMEs, both new and existing, by providing them with legal advice to achieve the goals they have set for themselves. Elle-Sun takes pride in assisting entrepreneurs in setting up their businesses and providing sound legal advice, while drafting or reviewing all necessary contracts and other legal documents. Her approach always depends on the entrepreneur and their vision for their business. Clients are encouraged to share their plans and vision with her as much as possible. Once the vision of the entrepreneur is clear, her role as an attorney becomes that of a translator. The goal then really becomes to translate adequately and accurately the vision of the business owner into the required legal structures, contracts, and other legal documents necessary for the growth of the company. Hence, Vision Legalis. Notwithstanding her work in other areas of law, IP law, especially trademark law, has taken a very special place in her heart as well as in her day-to-day practice at Vision Legalis. Her goal is to help boost awareness among Surinamese entrepreneurs, especially SMEs, about the value and importance of IP. To achieve this, she frequently assists with initiatives to promote and improve IP in Suriname and sometimes even initiates these activities herself. As a firm believer in cooperation and collaboration, especially in the region, Elle-Sun is a proud member of IPCA, Intellectual Property Caribbean Association, and INTA. At IPCA, she is a member of the Education Committee, and at INTA, she is a member of the SME Resources Committee. Besides her law practice, Elle-Sun is currently the president of the Surinamese Bar Association and the honorary consul to the Kingdom of Sweden in Suriname. She was recently sworn in as Commissioner of the Regional Judicial and Legal Services Commission. Frank is a board member of the Foundation Medical Mission Primary Healthcare Suriname, Stichting Medisch Zending Primary Healthcare Suriname, as well as the Foundation for Asset Management Moravian Church Suriname. Her belief in collaboration and cooperation is also reflected in Ladies' Lunches, which she founded in 2018 to provide women with a platform to discuss topics and share experiences that are important to them. Past events of this organization have included topics such as working moms, women in managing positions within their workplace, and women and retirement. Page 42. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Why Service Providers in Suriname Should Really Consider IP. Subhead: Elle-Sun Frank, attorney and founder at Vision Legalis Advocaten, Republic of Suriname, explains why IP is crucial for service providers whose brands, reputations, and expertise are their most valuable business assets. Website: www.visionlegalis.com. Entrepreneurship in Suriname is steadily evolving. Where businesses once relied primarily on location, personal networks, or word of mouth, many now compete through branding, visibility, and reputation. Whether it is a food brand or a candle manufacturer, an architect or a consultancy practice, Suriname's entrepreneurs are building brands. Sometimes, even before formalizing their business structures. This is a positive development. It reflects creativity, ambition, and a diversifying economy. But it also introduces a risk: many entrepreneurs invest significantly in building a brand without adequately protecting it. In today's economy, where perception often determines success, failing to protect your brand can have serious consequences. Many entrepreneurs delay protecting their brand. As an IP attorney, I frequently encounter entrepreneurs who feel that their business is too small for trademark protection or think that IP is only relevant for companies that sell products. These misconceptions can lead to serious consequences. In some cases, businesses are forced to rebrand after investing significantly in building recognition. A brand could be the most valuable asset a business owns. In traditional business models, business value is largely tied to physical assets such as buildings, machinery, or inventory. For many entrepreneurs, it therefore still feels counterintuitive to think that something intangible, like a name or logo, could be more valuable than equipment or buildings. Yet, nowadays, the most valuable assets are often intangible, especially for small and growing businesses. Branding has become an essential factor in modern business. Greater visibility through social media and online platforms has increased competition across sectors. Better informed, more selective consumers make for pickier customers. In this environment, branding performs several critical functions. 1. Customer certainty. A strong brand acts as a shortcut for trust, especially important in online environments and service-based industries. 2. Driving customer loyalty. With a strong brand, customers choose based on trust, experience, and emotional connection instead of price or convenience, leading to repeat business and long-term stability. 3. Supporting pricing power. A strong brand allows businesses to charge more. Customers are not only paying for the product or service, but also for reliability, consistency, and perceived quality. 4. Creating differentiation. In crowded markets, branding is often the clearest way to stand out. It communicates who you are, what you offer, and why customers should choose you over competitors. 5. Enabling growth and expansion. A strong brand makes it easier to introduce new products or services, enter new markets, and build partnerships. Commercial value. All these functions explain why branding is no longer just a marketing tool, it is a core business asset that can generate value. A protected trademark can be licensed to third parties, form the basis for franchising, or increase the attractiveness of your business to investors or partners. The brand itself may become an important driver of business value. In disputes or negotiations, a registered trademark provides legal certainty, makes enforcement more efficient, and strengthens your position when dealing with competitors or potential partners. Why IP is important for service providers. The above is also true for service providers, who often feel that IP is not relevant to their business because they don't sell products. The opposite is true. Service-based businesses are often more dependent on IP than product-based businesses, precisely because they lack physical assets. Their value lies in reputation, expertise, and presentation, all of which are closely tied to IP. 1. Your brand is the product. For service providers, the brand is not just a label but often the primary reason clients choose you. Unlike physical products, services cannot be tested in advance. Clients cannot try legal advice, consultancy, or creative work before buying it. Instead, they rely on the name, reputation, and visibility of a service to choose. For a service provider, it is therefore important that your brand becomes an indicator of expertise, quality, and reliability. This makes trademark protection just as important, if not more so, than for businesses selling goods. 2. Reputation is a core business asset. Service providers build their business on trust. That trust is attached to their name or the firm's name, a logo, a recognizable style, or a consistent market position. Over time, this reputation can become your strongest asset. It determines whether clients approach you, are willing to pay premium fees, or refer others. 3. Service providers create IP on a daily basis. Many service providers overlook that their daily work constitutes the creation of IP. Reports, legal opinions, training materials, marketing content, social media posts, methodologies, and processes are all creations and are protected by copyright. These are intellectual assets that contribute directly to your competitive advantage. 4. Differentiation is built through branding. Within service markets, differentiation is often subtle. Many providers offer similar services at comparable levels of quality. Your brand communicates your expertise, approach, and your perceived level, premium, accessible, niche, etc. This positioning is what makes clients choose you over others. Many service providers overlook IP because they are focused on day-to-day client work, believe IP is only relevant to products, and lack an overall awareness of how much value is tied to branding and content. However understandable, this mindset overlooks a key reality. If your business depends on your name, your reputation, and your expertise, then it depends on IP. The question is whether you are actively protecting it. Because service providers do not deal with physical goods, their IP risks are often less visible, but not less real. Whether it be another firm using or registering a similar name, competitors adopting a confusingly similar identity, third parties reusing your content without permission, or losing control over your brand as your visibility grows, these risks often only become apparent after damage has already occurred. Without proper IP protection, you may have limited ability to act against this. Conclusion. As Suriname's entrepreneurial landscape continues to evolve, IP is becoming increasingly important. What was once optional is now essential. For both product-based businesses and service providers, the message is clear: your brand is an asset. It builds trust, drives loyalty, supports growth, and creates value. And if it is that important, it deserves to be protected, early, properly, and strategically. Service providers may not sell physical goods, but they operate almost entirely in the realm of intangible value. Their brand, their reputation, and their content are the foundation of their business. That means IP is not an afterthought, it is essential. Page 44. Profile: Venezuela. Name: Beatriz Ayala. Law firm: Ayala and Asociados. Position: founding partner. Country: Venezuela. Website: www.ayalayasociadosip.com. Beatriz Ayala is a distinguished Venezuelan lawyer specializing in intellectual property, IP. With extensive experience in trademark registration, patent protection, copyright, trade secrets, litigation, and unfair competition, she provides strategic legal solutions across multiple industries. Academic background and teaching experience. Beatriz earned her law degree from the Central University of Venezuela, UCV, followed by postgraduate studies in administrative law at UCV, and a master's in intellectual property with honors from the University of Los Andes. Her academic achievements include Fashion Law Program, Professor Pamela Echeverria, Argentina. Advanced course in Fashion Law, University of Salamanca, Spain. Professor of International IP and Fashion Law at Universidad Monteavila. Member of the Acelera program at Andrés Bello Catholic University, UCAB. Professional experience. As the founding partner of Ayala and Asociados IP, Beatriz leads a firm that specializes in trademarks and patents, registration, management, and litigation. Copyright and related rights, protection of creative works and software. Unfair competition and litigation, legal defense and IP representation. Entertainment and fashion law, counsel for artists, writers, and designers. Memberships and representative positions. Roles: Beatriz Ayala has held key positions in leading IP organizations, member of the Venezuelan Bar Association and COVAPI, Venezuelan Association of IP Agents. Industrial Property Agent. Member of ASIPI and INTA. ASIPI Delegate, 2007 to 2014, and President of ASIPI's Entertainment Law Committee. Current member of ASIPI's Fashion Law Committee. Awards and recognitions. Her contributions to IP have earned her prestigious national and international recognitions, Diploma and Honor Medal, Caracas Bar Association. Marquesa Excellence Award, Leading IP Professional in Venezuela, 2013. Chambers and Partners, Chambers Latin America, 2015 to 2026. Best Lawyers Award, 2018, 2019, 2020. Publications. Who Suffers from Piracy? El Universal Newspaper. Fashion Law in Venezuela, IP as a Legal Protection Tool, Image and Fashion Law 2023 to 2024. The Origin of Fashion Law in Latin America, Poise Publishing. Conferences and events. Speaker at LES Andean Community International Congress. Organizer and speaker, Innovation and IP in Fashion, Universidad Monteavila. Panelist, The ABCs of IP and Trademarks Economic Impact, ASIPI. Guest speaker, Innovation Day, Protecting Creations and Brands, IESA. Speaker at Fashion Law and IP, University of San Carlos, Guatemala. Regular participant in IP conferences by ASIPI, INTA, and others. Impact on IP in Venezuela. Beatriz Ayala actively promotes IP awareness in Venezuela, advising entrepreneurs, businesses, and universities on legal protection strategies. She has contributed to policy recommendations for improving Venezuela's legal framework and leads educational initiatives, including international IP and fashion law courses at Universidad Monteavila. Diploma in Fashion Law featuring international experts. Page 45. Article. Disclaimer: Images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Patents, Investment and Knowledge: The Case for a Genuine Reform of Venezuelan IP Law. Subhead: Beatriz Ayala, founding partner of Ayala and Asociados, Venezuela, outlines how Venezuela must overhaul its outdated IP law to attract technology-driven investment and integrate into the global knowledge economy. Website: www.ayalayasociadosip.com. A 1955 law in a 2026 world. The central deficiency of Venezuela's IP framework is not procedural, it is architectural. The industrial property law of 1955 cannot, by design, accommodate the categories of innovation that define the global economy today. The advancement of technology must go hand in hand with updating laws. From 2001 to 2006, Venezuela operated under Decision 486 of the Andean Community of Nations, CAN, a modern instrument aligned with WTO TRIPS standards covering patents, trademarks, industrial designs, geographical indications, trade secrets, and enforcement mechanisms. Upon withdrawal from the CAN in April 2006, the country fell back by default to the 1955 statute, not a regulatory gap but a structural regression. Patent issuances were suspended, legal certainty for rights holders collapsed, and Venezuela acquired a reputation in international IP circles as a high-risk jurisdiction. Nearly 2 decades later, that reputation has not been fully reversed, though there has been meaningful progress in the granting of patents. The specific deficiencies. The current law presents critical gaps across 6 areas. Biotechnology, advanced chemistry, and new materials fall outside patentability or into legal ambiguity, a gap that directly affects the petrochemical and energy sectors. Software is protected only by copyright law, which cannot address the functional and technical dimensions of digitally implemented inventions. Without that protection, Venezuela cannot attract the technology-intensive investment that transforms resource economies into knowledge economies, and technology transfer is essential at this moment. The draft AI law approved in the first parliamentary reading in November 2024 includes IP as a governing principle, yet defines no ownership framework for AI-generated inventions, a live question, not a theoretical one, for companies evaluating R&D operations in Venezuela today. In pharmaceuticals and food, reversion to the 1955 law narrowed patentability compared to Decision 486, creating a contradiction between TRIPS commitments assumed at the WTO and absent domestic implementation. Enforcement is equally deficient. Article 98 sets criminal penalties for patent infringement at 1 to 12 months, a range that has no deterrent effect when a single violation can result in millions in losses. Finally, Venezuela is not a contracting party to the Patent Cooperation Treaty, PCT, which excludes its inventors and investors from the unified international filing system used by the rest of the world. Why this matters for investment? Venezuela is making significant efforts to attract foreign investment across multiple sectors. The 2026 reform of the hydrocarbons law reflects an understanding at the highest levels of government that legal frameworks must be updated to capture capital. The same logic applies to patents. Without enforceable, predictable rights, sophisticated investors will not commit their most valuable intellectual assets to a jurisdiction. They may bring capital, but not their strategic technology. Venezuela's oil sector, for instance, would benefit from the latest enhanced recovery technologies, digital reservoir modeling and emissions reduction processes, all patent protected by international companies that will not deploy them where IP cannot be adequately protected. What a genuine reform must contain. The 2026 to 2027 legislative agenda formally includes a new industrial property law. To be genuine, it must address 7 elements. 1. Expanded patentability, explicit recognition of biotechnology, advanced pharmaceuticals, technically characterized software-implemented inventions and AI-assisted innovations, in line with TRIPS Article 27. 2. TRIPS-compliant pharmaceutical protection, data exclusivity, second medical use patentability and a clear compulsory licensing framework balancing public health and investor protection. 3. Modern enforcement, injunctive relief, damages proportionate to actual economic harm, scaled criminal sanctions, and specialized IP judicial capacity. 4. A framework for AI and emerging technologies, provisions on AI-generated inventions, human-AI co-inventorship, and ownership allocation, drawing on comparative approaches from the EU, the UK, and the United States. 5. PCT accession, a parallel, non-negotiable commitment. Without PCT membership, even a modernized domestic law will remain disconnected from the international technology flow system. 6. Streamlined administrative procedures. SAPI has made genuine progress. Patents are being granted in good time and trademarks are being registered within 5 months. These advances must be consolidated with binding statutory deadlines and transparent examination criteria. 7. Alignment with international standards. The new law should meet, and where possible exceed, the protection levels of Decision 486, TRIPS, and the Singapore Treaty on the Law of Trademarks. Conclusion. The legislative agenda is set, and political will has been expressed. A law that updates procedures without expanding patentability, without resolving pharmaceutical protection, without addressing AI, and without PCT accession will not change Venezuela's position in the international IP system. One that does can reverse 2 decades of legal stagnation and signal to the world that Venezuela is open not just to capital, but to knowledge. Venezuela is a remarkable country, extraordinarily privileged in its natural resources, its landscapes, its climate, and above all, its people, hardworking and entrepreneurial. With the law we have done well. Imagine what a genuinely modern IP law could achieve. About the author. Beatriz Ayala is an IP specialist and founding partner of Ayala and Asociados, a Venezuelan firm dedicated to IP law, trademark and patent prosecution, and IP strategy for domestic and international clients. Key legal references. Industrial Property Law of Venezuela, 1955, Official Gazette N. Degree 24873, 14 October 1955. Copyright Law of Venezuela, 1993, Official Gazette N. Degree 4638, Extraordinary, 1 October 1993. Decision 486, Common Regime on Industrial Property, Andean Community of Nations, 2000. Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS, WTO, 1995. Draft AI Law of Venezuela, First Parliamentary Reading, National Assembly, November 2024. Basic Legislative Plan 2026-2027, National Assembly of Venezuela, January 2026. WIPO. Country IP Statistics Profile, Venezuela. Geneva, 2024.
Segment page. Europe. Women's IP World Annual 2026.
Page 48. Profiles, Ukraine. Profile 1. Name, Antonina Pakarenko-Anderson. Law firm, Pakarenko and Partners. Position, founder and managing partner. Country, Ukraine. Website, www.pakarenko.ua. Antonina Pakarenko-Anderson is the managing partner and founder of Pakarenko and Partners. She is a registered patent attorney and doctor of laws who has been working in the field of intellectual property, IP, for over 25 years. IP is Antonina's greatest passion, serving as a constant source of motivation and inspiration for her work. Antonina is genuinely in love with her work, and she is not the only one. The entire team at Pakarenko and Partners is enthusiastic about IP. The company's specialists are always eager to acquire new knowledge and take on pioneering cases, which is why the professional team of Pakarenko and Partners can take on difficult tasks with ease. As a result, clients recommend Antonina as one of the best professionals in her field, a real IP guru, because they are confident that the work will be done well and in a reasonable time frame. Antonina's specialized practice covers all aspects of IP rights protection and enforcement, IP litigation, and non-judicial dispute resolution, licensing, and contracts. Antonina also has vast experience in representing clients before the Anti-Monopoly Committee in unfair competition matters and before the State Inspection of Ukraine for the protection of consumers' rights. Being a certified trademark mediator, certification by the International Trademark Association, INTA, she has practical experience in mediating complex trademark disputes. She also serves as a panelist neutral of the forum, formerly the National Arbitration Forum, USA, an ECAN-accredited provider of services in arbitration and mediation of domain name disputes. Antonina's experience in consultancy at the national level includes serving as a consultant to the Education and Science Committee of the Ukrainian Parliament. For an extended period of time, she has served on the advisory body under the Ukrainian National Office for Intellectual Property and Innovations. On an international level, Antonina has been active with a number of international governmental and non-governmental organizations in the IP field, particularly AIPPI, INTA, PTMG, IBA, ECTA, and Marques. The company under her management is a member of the American Chamber of Commerce, ACC, in Ukraine, the German-Ukrainian Chamber of Industry and Commerce, AHK Ukraine, the European Business Association, EBA, the Seed Association of Ukraine, the Ukrainian Berries Association, SIOPERA, and ACACAP. As the acting chairman of the Ukrainian Alliance Against Counterfeiting and Piracy, UAACP, and a member of several international anti-counterfeiting coalitions, she provides assistance to businesses in tackling counterfeiting and piracy problems in Ukraine. Antonina is the president of the Ukrainian National Group of AIPPI, the vice president of the Ukrainian National Committee of the International Chamber of Commerce, ICC Ukraine, on intellectual property issues, and a member of both the Ukrainian Patent Attorneys Association and the National Association of Patent Attorneys of Ukraine. Profile 2. Name: Alina Shamrina. Law firm: Pakarenko and Partners. Position: lawyer, patent and trademark attorney. Country: Ukraine. Website: www.pakarenko.ua. Alina Shamrina is a lawyer, partner and chief financial officer of IP Pakarenko and Partners, Kiev, and a Ukrainian patent and trademark attorney No. 141 with over 25 years of experience. Alina is an assertive, proactive manager with a distinct leadership style and outstanding personal, organizational, and strategic leadership skills, which have been key to the successful operation of Pakarenko and Partners under her leadership, especially in the challenging global business environment of the past 5 years, impacted by the crisis of the pandemic and war. Alina's highest qualifications as a business leader enabled the company to solve business problems through critical analysis of a complex and diverse crisis environment and ensured the successful operation of IP and Pakarenko and Partners as a whole, which is named among the 5 leading Ukrainian firms in the field of IP. Alina has professional knowledge and practical experience in successfully managing IP portfolios of over 200 regular clients of world-renowned companies. Her experience includes obtaining protection for trademarks, obtaining recognition of marks as well-known, obtaining protection for industrial designs, inventions, licensing, and the transfer of IP rights, protection of copyright and related rights, resolving issues involving unfair competition, and further enforcement of IP rights in administrative proceedings and litigations. Alina is named among the leading lawyers in IP as a recommended and proven expert in this field according to domestic and international ranking surveys. Alina's achievements during the recent years of crisis include maintaining the financial success of Pakarenko and Partners law firm under conditions of a limited legal personnel market and reduced clients' expenditure on legal services not critically necessary due to the wartime situation. Alina adjusted personnel management rules due to a large staff shortage, created new jobs, formed new professional teams in the company, and ensured the process of providing patent and legal services was maintained at the highest professional level and generated profit from the company's activities. Background: with degrees in economy and law and advanced training in IP, Alina is a graduate of Kiev Institute of National Economy, presently the Vadim Hetman Kiev National Economic University, 1988, Kiev National University of Construction and Architecture, 1995, Kharkiv Institute for Patent Engineers, 1997, Law Department of the Interregional Academy of Personnel Management, 1998. Membership in professional organizations. Alina is a member of a number of international organizations, in particular the Ukrainian group of the International Association for the Protection of Intellectual Property, AIPPI, and the International Trademark Association, INTA, in which she actively worked in the Bulletin Committee, famous and well-known Marks Committee, etc. She is also a member of the International Licensing Society, LACI. She actively cooperates with international organizations in the field of IP such as FICPI, International Federation of Intellectual Property Attorneys, Marques, European Association representing the interests of brand owners, ECTA, European Communities Trademark Association, PTMG, Pharmaceutical Trademarks Group. She is also a member of All Ukrainian Association of Patent Attorneys and National Association of Patent Attorneys, Ukraine. Languages: Ukrainian, Russian, English. Page 50. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Trademarks are a must-have in the modern economy. Subhead: written by Antonina Pakarenko-Anderson, Managing Partner at Pakarenko & Partners, Ukraine. Website: www.pakarenko.ua. In today's competitive and identity-driven markets, trademarks have become essential strategic assets for businesses seeking to protect and grow their brands. In the 21st century, competition has shifted from production capacity to intangible assets. Brand, reputation, and consumer trust are increasingly more valuable than equipment or raw materials. The modern market is a buyer's market, where supply exceeds demand, giving buyers priority over sellers. Modern markets reflect not only economic relationships but also people's identities and lifestyles, which is why today's markets are called identity markets. In a consumer market of this kind, a trademark, as an important element of the brand, has transformed from a formal legal tool into a strategic business asset. For IP professionals, this means a change in role from an IP rights registration consultant to a consultant on company value management issues. Trademark as a key intangible asset. Since modern markets are the markets of identities, a consumer buys not only the product, but also associations with quality, lifestyle, reliability, and status. A trademark has become a carrier of economic value. In merger and acquisition practice, company valuation is increasingly based on the brand portfolio. For example, in the technology sector, the share of intangible assets in business value can exceed 80%. Without proper legal protection, this value is non-existent in a legal sense. The ownership of a right to a trademark provides exclusivity of use, monopoly on commercial identification, possibility of licensing, brand capitalization, protection of investments in marketing. That is why trademark registration is not a formality, but a legal transformation of marketing into property. Let's see why registration is more important today than before. Globalization of e-commerce. E-commerce has destroyed geographical boundaries. Now, even small businesses operate in several jurisdictions at the same time. The problem lies in the principle of territoriality. Trademark rights are valid only where they are registered. A common situation: a Ukrainian brand sells goods on Amazon or Etsy and later discovers that the trademark has already been registered by a third party in the EU or the USA. As a result, accounts may be blocked, goods delayed at customs, and infringement lawsuits filed. Therefore, a portfolio strategy for trademark registration, national, regional, and international, has become mandatory, and the Madrid system, which allows trademarks to be registered worldwide, has become a standard step for companies entering global trade. The outburst of marketplaces and algorithmic sales. Today, a trademark dispute is not only a legal issue but also an SEO, search engine optimization, issue. SEO is a key tool for attracting customers and increasing brand awareness in the digital age. It involves methods that improve a website's visibility in search engine results such as Google, helping attract broader audiences and build trust in the brand. Marketplaces operate on the principle that ownership entitles visibility. Without a registered trademark, a company is not entitled to use tools such as brand registry on Amazon and other platforms, cannot effectively block counterfeit listings, or remove parasitic listings. This results in a loss of control over the market, even without litigation. Defensive function: combating unfair competition. Today, The greatest threat today is not direct counterfeiting but product imitation. This includes deliberate imitation of a successful product's distinctive features without using the actual trademark or brand name. Modern forms of imitation include lookalike packaging, phonetic similarity, keyword hijacking. Without a registered trademark, proving infringement becomes extremely difficult, as marketing use alone does not establish legal ownership of a legitimate right to use it. In Ukraine, enforcement of trademark rights can be carried out through the courts, the Anti-Monopoly Committee, or the IP Customs Register. All these mechanisms require a trademark registration document. In Ukraine, the registration authority in Ukraine is the Ukrainian National Office for Intellectual Property and Innovations, where the application filing date determines priority and serves as key evidence in disputes. Offensive function, monetization and licensing. Lawyers have traditionally treated trademarks as a tool of protection. However, in a modern economy, it is also a profit-making tool. Usage models. 1. Licensing. Franchising, private label, collaborations. Without a registered trademark, the agreement appears to be a marketing contract with no legal exclusivity. 2. Brand ecosystems. One mark covers dozens of ICGS classes for clothing, accessories, cosmetics, and digital products. 3. Investment attractiveness. Investors actually buy brand recognition, not just the product. In Europe, brand due diligence is a standard procedure that comes before investing. New challenges: AI, metaverses, and digital goods. In recent years, a fundamentally new problem has emerged: virtual markets. The following types of assets have appeared: NFTs, digital clothing, virtual stores, and AI-generated brands. Questions that arise: whether Class 25 covers digital clothing, whether the use of a trademark includes its use in AI generation, who is responsible for the use of a trademark in prompt content, a user's text request to AI? Over time, international practice is shaping a position: registration should be ahead of technology. Therefore, a new strategy for business suggests proactive expansion of trade. Mark registration classes. Mistakes that businesses still make. Even large companies repeat typical mistakes. 1. Registration after launch. Today, marketing activities are launched earlier than a legal audit is conducted. As a result, rebranding is needed after receiving a claim. 2. Limitation to one class. The trademark is later registered for related products. 3. Lack of monitoring. Registration is not a final step, but an initial one. Without monitoring competitors, the trademark becomes diluted quickly. 4. Ignoring infringing domains. Domain disputes have become a cheaper tool for raiding than classic counterfeiting. Today's role of an IP professional. An IP expert is no longer just a consultant on trademark registration matters. He performs the function of a risk manager, strategic consultant, brand architect, and advisor on international expansion. In fact, an IP lawyer works at the intersection of law, marketing, and finance. Conclusion. In a modern economy, a trademark is the legal formalization of consumer trust. Without it, the brand exists only in the mind, but not in law. And what does not exist in law has no commercial value. Page 52. Profile Germany. Name: Natalia Gulieva. Title: Partner. Company: Hogan Lovells International LLP. Country: Germany. Website: www.hoganlovells.com. Natalia Gulieva is a partner at Hogan Lovells International LLP in Düsseldorf and a part of the firm's global regulatory and IP, media, and technology practice. Natalia is known for advising innovative businesses on intellectually demanding and commercially significant matters related to IP, technology, data, and other complex disputes. Natalia combines deep legal knowledge with strong commercial judgment. She works with various clients in spheres including life sciences and healthcare, telecom, media, digital platforms, and other high-tech-driven industries. Natalia has extensive experience across patent, trademark, design, copyright, trade secret and domain name matters, and is highly valued for handling legal issues that require technical understanding, top legal expertise, and practical business sense. In addition to contentious work, she advises on risk management and portfolio protection, helping clients to address disputes in a way that supports their long-term commercial objectives. Natalia's academic and professional background reflects an international and multidisciplinary character, as does her practice. She holds a PhD from the Lomonosov Moscow State University and an LLM. Magna cum laude from the University of Tübingen on trade secrets dispute resolution. She completed an executive MBA at the Stockholm School of Economics and Leadership Programs at the said Business School, University of Oxford and Harvard Business School. This combination of legal and business training enables Natalia to approach client needs and matters not only as legal, but also as strategic business decisions with operational and reputational implications. Natalia is admitted to practice in England and Wales, Germany, and Russia and is qualified as a patent, design and trademark attorney. Beyond client work, she is very active in international professional and educational initiatives. She serves as a tutor for the WIPO Arbitration and Mediation Center and contributes to leading professional bodies, including SIARB, INTA, and the WIPO Mediation and Arbitration Advisory Committee. These roles reflect both Natalia's standing in the profession and the ongoing engagement with the development of best practices in the cross-border dispute resolution and IP strategy. Natalia contributed to major international publications on IP and dispute resolution, including the GAR Guide to IP Arbitration, the GAR Guide on Challenging and Enforcing Arbitration Awards, Domain Name Law and Practice, an international handbook by Oxford University Press, and Domain Name Law by Carl Heymans Verlag. Her market recognition includes leading rankings and industry commendations that highlight client focus, responsiveness, and commercially minded advice. She is highly praised for her business sense, clear management style and solution-oriented thinking, the qualities that are particularly valuable in cross-border matters which involve multiple actors and various jurisdictions. Overall, Natalia demonstrates a rare combination of IP in-depth knowledge, international perspective, sector knowledge and practical judgment, qualities that make her a trusted advisor to global businesses navigating complex legal and technology environments. Page 53. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Pharma Patent Enforcement in the Eurasian Economic Union, Trends, Strategies, and Emerging Risks. Subhead: Dr. Natalia Gulieva, Partner, Hogan Lovells International LLP, Germany, examines how pharma patent protection in the Eurasian Economic Union is becoming more sophisticated and why companies now need a coordinated, evidence-driven strategy to preserve their patents. Website: www.hoganlovells.com. Patent protection in the Eurasian Economic Union, EAEU, has become increasingly sophisticated, commercially significant, and strategically complex. For innovative pharma businesses, the region remains important not only because of its market size and the number of patients located in the region, but also because it represents a mix of judicial, administrative, and regulatory mechanisms that shape the practical value of patent rights. At the same time, generic, GX, businesses have become more active and more creative in contesting exclusivity, combining revocation proceedings, patent term extension challenges, compulsory license claims, and market entry tactics in order to weaken or delay patent enforcement. As a result, patent protection in the EAEU can no longer be viewed as a narrow litigation issue but rather as a broader activity that requires coordinated efforts across dispute resolution, regulatory monitoring, competition law, and evidence management. The patent enforcement landscape across the EAEU states is not uniform. In practice, patentees have been more active in patent enforcement in Russia and Kazakhstan and less prompt in actions in Armenia, Belarus, and Kyrgyzstan. Yet this trend is changing. Recent developments, including favorable decisions for patentees in Belarus, suggest that this state may become more relevant for patent enforcement. This is important as patentees increasingly need to think in regional rather than merely national terms. Although patent disputes are still litigated within national systems, GX business strategy, drug launches and defensive strategies are often coordinated across multiple states. Hence, an effective patent enforcement strategy must take into account both state-specific tools and broader regional patterns. Eurasian Pharma Patent Registry. An important element of regional patent protection is the Eurasian Pharma Patent (EPP) registry administered by the Eurasian Patent Organization (EAPO). The EAPO unites 8 states: Azerbaijan, Armenia, Belarus, Kazakhstan, Kyrgyzstan, Russia, Tajikistan, and Turkmenistan, with a combined population exceeding 210 million people. The registry has become an instrument for pharma patent protection. Launched in 2021, it links international non-proprietary names to relevant Eurasian and national patents. It provides open and regularly updated information on patents, including pharmacologically active substances, compositions and combinations, methods of obtaining pharmacologically active substances, and medical uses. It also includes data on patent legal status, licenses, and registered drugs. The registry already contains more than 340 international non-proprietary names, owned by over 140 patentees from more than 20 states. The majority of recorded patents are owned by patentees from the United States, Switzerland, and Germany. In recent years, the registry has started to play an important role in the context of public procurement and patent enforcement. Procurement authorities increasingly rely on the registry when assessing bids and selecting drugs for supply. When an international non-proprietary name is listed in the registry, procurement organizers verify whether the marketing authorization submitted in the tender corresponds to the information contained in the registry. As a result, the registry entries may directly influence procurement outcomes. Information from the registry is increasingly used as supplementary evidence regarding the scope of patent protection in patent disputes, thereby enhancing legal certainty and supporting patentees in enforcement proceedings. The recording process is straightforward and both time and cost efficient, and as a result, listing patents on the registry helps pharma business and legal functions to excel in public procurement and patent enforcement. Evidentiary standards for threat of patent infringement actions. One of the most notable developments in Russia concerns the evidentiary standards for threat of patent infringement actions. Previous approaches often placed significant weight on formal indicators such as the existence of a marketing authorization, the registration of a drug price, and the statutory obligation to commence use of the marketing authorization within a defined period. These factors could support a claim that a GX launch was imminent. Recently, the approach has become more nuanced and fact-specific, as lower courts are following the guidance of the Russian IP court. Evidence of manufacturing activity, production of batches, logistical preparation for launch, and even patterns of prior conduct by the GX business may now be relevant. Patentees may succeed if they can demonstrate preparatory acts pointing to an imminent threat of market entry or a bad faith attitude of the GX business in the past. This development has very practical implications for both sides. For patentees, it supports the importance of proactive monitoring and careful evidence collection. Market research, manufacturing information, and litigation history can all contribute to building a record of imminent threat. For GX businesses, it limits pre-launch activities that previously may have remained outside the reach of enforcement. Unfair competition actions. Alongside the court proceedings, administrative enforcement has emerged as an important route, particularly through unfair competition actions. In Russia, anti-monopoly mechanisms are increasingly used by patentees as an additional tool to protect patent rights. This reflects an important feature of the regional enforcement environment, where patent disputes do not exist in isolation from competition law. Patentees may use competition law where a GX business attempts to enter the market before the patent expiry date, to secure relief beyond classic infringement claims. Since 2024, these actions have gained importance, and a number of decisions issued by the Federal Anti-Monopoly Service (FAS) became subject to judicial scrutiny in 2025. While the courts have initially overruled several FAS decisions, on the 11th of March 2026, the Supreme Court of Russia upheld the decision of FAS confirming unfair competition by a Russian GX business with respect to the innovative drug of an international big pharma producer. The Supreme Court concluded, in particular, that The patentee of the invention used in the GX drug must not be the direct competitor of GX's business. Even if the foreign patentees have not been present in the market on their own, unfair competition action remains available for its local subsidiary, partner, or distributor. Information included in the EPP register can be used as evidence of the protection of a compound. In the case of a gross violation, FAS is authorized to impose an obligation on GX's business to pay a penalty equal to all illegal revenue from sales of the GX drug. Based on the above, unfair competition actions are likely to remain a powerful tool for patentees going forward. GX defensive strategies. At the same time, GX businesses continue to actively use defensive and delaying strategies. Patent revocation proceedings remain the most common response to enforcement. These proceedings may target national or Eurasian patents. Challenges to patent term extensions also play an important role, especially in the pharma sector where the commercial value of additional exclusivity is substantial. However, the success rate of such actions remains relatively limited. In many cases, these proceedings are used primarily as part of a delaying strategy aimed at slowing down or staying patent infringement proceedings. Alongside patent revocation and patent term extension challenges, GX businesses bring compulsory license claims. These claims have sometimes been brought in parallel, and in a manner that is arguably contradictory, to challenges aimed at invalidating the same patents. In certain instances, compulsory license claims have also been brought as counterclaims in patent infringement proceedings. Courts in the region have responded cautiously to this strategy. Where compulsory license claims are filed simultaneously with revocation or patent term extension challenges, courts tend to stay the proceedings pending resolution of these earlier challenges. At the same time, a wider compulsory licensing framework is a real source of concern for innovators. In both Russia and Belarus, such claims have been brought on the basis of alleged insufficient use of the patented invention. Some disputes have been resolved through settlements reached in closed hearings, while others remain unresolved. In Belarus, courts have dismissed some compulsory license claims, signaling a relatively strict approach to the statutory requirements for such licenses. The risks associated with compulsory licensing based on patent non-use are particularly important due to the legal ambiguity surrounding the concept. Questions remain about the interpretation of insufficient use and how the burden of proof should be allocated, whether a simple presence of an innovator's drug on the market is sufficient to defeat such a claim. These issues affect launch strategies, supply planning, import arrangements, state procurement participation, and litigation tactics. The ambiguity of regulations, the broad interpretation of insufficient patent use by the courts, and the unrestricted scope of compulsory licenses granted have already attracted the attention of higher courts. On the 12th of March 2026, the Constitutional Court of Russia, CC, announced its decision, based on requests of two international big pharma businesses, to check whether the current compulsory license law provisions complied with the Constitution of Russia. The CC confirmed that the provisions of the compulsory license law are consistent with the Constitution. While the CC admits that compulsory license is an extraordinary measure, it also confirmed that the following actions of patentees might give a ground for a compulsory license grant. Abuse of IP rights in Russia or outside of Russia when the patentee has no intention to satisfy the demand on the market and creates obstacles for others to launch in order to preserve its dominant position in the market. Failure to participate in tenders or supply drugs, by patentees or their distributors. The price of innovative drugs is significantly higher than the price of other drugs that can be offered in case a compulsory license is granted, especially in cases where the supply of the drug is essential for the health and life of citizens. Other situations when the patent owner is unable to independently ensure the effective and dynamic use of the patented inventions for objective reasons, in which case, according to CC, the patentee, acting in good faith, must conclude a license agreement. The CC explained that the courts shall take into account the licensee's actual ability to use the invention, to avoid any harm to the health and lives of citizens, and must limit the scope of the license in line with the actual needs of the market. The CC highlighted that compulsory license may be terminated, in particular, when the market needs are satisfied, the prices decrease, there are guaranteed supplies of the drugs, and the patentee is ready to use the inventions to fully satisfy the needs of the patients. This CC ruling provides guidance on innovators' strategies in the EAEU, including future interactions with GX businesses and decisions on market access. From a strategic perspective, the rise of compulsory license claims changes the nature of patent defense. It is no longer enough to hold a valid patent and simply monitor infringements. Companies need preventive strategies aimed at reducing compulsory license exposure, such as monitoring potential claims, coordination between legal and commercial teams, and readiness to contest the proposed license. In some cases, where the patentee prefers to avoid a court case, the strategy can vary from settlement negotiations to withdrawal of the patent. In others, they may seek to narrow the scope of any potential use or challenge proposed royalty terms. These developments show that patent protection in the EAEU is increasingly defined by interaction between multiple legal tools. Litigation is the core enforcement tool through which patentees seek to block the GX entry. The administrative unfair competition actions may enhance enforcement leverage. Revocation and patent term extension challenges are standard GX defensive tools. Compulsory license claims introduce a further tool for targeting the terms under which exclusivity is exercised. The EPP registry contributes to a broader system in which transparency, procurement practices, and enforcement increasingly influence one another. For innovative pharma businesses, successful patent enforcement in the EAEU requires a coordinated, forward-looking, and evidence-driven strategy. It is not enough to react when a GX drug is approaching launch. Companies should monitor regulatory developments, maintain records proving use of their inventions, consider administrative avenues, and ensure that key patents are recorded with the EPP registry in a timely manner. They also must be prepared for a sophisticated GX defense. In sum, patent protection in the EAEU is now more developed but still demanding. The region has jurisdictional differences, and not every state offers the same volume of enforcement. Yet, patent enforcement in the region is active, defensive strategies are evolving, and compulsory license risks are increasing. For market players, this means that the value of a patent in the EAEU will depend not only on registration, but also on the quality of the strategy around it.
Page 56. Advertisement. SN Anku IP Firm. Attorneys and consultants. Your patent, trademark, industrial designs, and copyright are fully protected with us. Practice areas. IP registration and recordals. Patents, trademarks, industrial designs and copyright. IP litigation and enforcement. IP portfolio management. Due diligence consulting. Specialized IP training services. Technology transfer and commercialization support services. Entertainment law. Our jurisdictions. Ghana, Nigeria, the Gambia, the 22 ARIPO member states. Saranorka Yenkeyu. Global managing partner. For more info, +233 597 237 710. info@snankuipfirm.com.
Page 57. Profile Switzerland. Name, Claudia Kaya. Title, Director and Managing IP Consultant. Company, Dorman IP. Country, Switzerland. Website, www.dorman-ip.com. Claudia Kaya acts as Director and Managing IP Consultant for the Swiss IP law boutique firm Dorman IP located in the Canton Zug. She holds a Master of Science in Chemical Engineering from the Technical University of Dortmund and a degree in Interior Architecture and Interior Design from the Hamburg Academy, HAF. Claudia started her career at the University of Dortmund, working in the Department of Process Technology as a research associate. Thereupon she entered an international chemical group dealing with know-how, trade secrets, and licenses in 36 countries all over the globe as one of the production manager. Before her assignment in Switzerland, Claudia acted as managing IP consultant and branch manager at one of the leading IP offices in Turkey. Leveraging her experience and expertise with global IP matters, foreign business, and legal and social communities, she provides efficient IP service to a worldwide clientele. Her practice areas are patents, industrial designs, and trademarks, focusing on the industries of chemical and mechanical engineering and medical engineering, polymer processing, life sciences, and interior equipment. She is an intuitive business developer who uses creative yet critical thinking. Claudia regards empathy and emotional intel as essential in the hypercommunicative world of business. She believes solid and friendly conversations help to build better business relationships. She pays great respect to client perception, speedy feedback, and follow-ups. Peers say she is a fast adapter, flexible, versatile, and resourceful. Claudia lives with her family in the countryside near the Alps, where she loves outdoor walking, photographing nature, and strolling through different art and archaeological exhibitions. Her favorite artworks are by Jack Vetriano, Klimt, Klett, Irene Sherry, and German Expressionism. Having a professional dance education, she loves to visit dance tournaments. She has also developed choreographies for children and youngsters herself. Claudia acts in many charity associations through which she gained awards for international understanding. Her language skills underline her international personality. Claudia is a native speaker of German, has close to native speaker fluency in English and Turkish, and basic to intermediate knowledge of Italian and French. Memberships: INTA, ECTA, PTMG, VPP, INGAS, and AIPPI. Page 58. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Championing Innovation and Fair Access in a Changing IP Landscape. Subhead: Claudia Kaya, Director and Managing IP Consultant at Dorman IP, sits down with Women's IP World Annual to discuss Swissness, AI-driven disruption, and the evolving role of women shaping the future of IP. With a background that spans chemical engineering and international portfolio management, Kaya brings a blend of technical expertise and commercial insight to the field of IP. From overseeing trade secret agreements and licensing to guiding startups through trademark, design, and patent strategies in Switzerland's dynamic innovation ecosystem, she operates at the intersection of law, technology, and business. She joined us to reflect on the many opportunities and challenges facing IP professionals today. Tell us about your background and what led you to specialize in IP law. I hold a master's in chemical engineering from TU Dortmund, and I graduated as one of the top in my class for the compulsory IP module during my studies. I started my career as a production manager in an international chain of chemical companies. As in-house counsel, I was responsible for trade secret agreements and granting licenses, which led me to patent protection. I also have a BSc in decoration and interior architecture, and am a certified trademark and design consultant. What are your primary areas of expertise within IP, and how do you see these areas developing in today's legal landscape? I am acting as a managing IP consultant, leveraging my experience and expertise in domestic IP issues, international business, and legal and social communities to provide efficient IP services to our local and foreign clients. I manage international IP portfolios for exclusive clients by developing strategies to obtain and defend trademark and patent rights. With empathy, I am developing relationships with existing and potential international clients to drive business growth. My primary areas of practice include trademark and design prosecution and enforcement, and consulting for startups and company foundations, including assisting startups with IP portfolio protection. In Switzerland, we have a big startup scene. Share a significant case or project that has had a lasting impact on your career. We just witnessed a striking decision. The Swiss Federal Institute of Intellectual Property, IPI, won the first Swissness court case against a foreign company. In January, the IPI won a case against BD Swiss AG before the Bern Commercial Court. BD Swiss AG must now remove Swiss from its name and the Swiss cross from its logo because it does not fulfill the legal requirements to use the Swiss indication of source. Swissness legislation. Specific rules in the Trademark Protection Act are the cornerstone of what is known as Swissness legislation. Companies that want to use the indication of source Switzerland must comply with the legally defined criteria and be able to prove this compliance in the event of a legal dispute. Companies can advertise their services as Swiss if they have a registered office in Switzerland and they are actually managed from Switzerland. The second condition is designed to prevent companies from claiming that a letterbox alone is a sufficient connection to Switzerland. Swiss products and services enjoy an exceptionally good reputation both domestically and abroad. Anyone who wants to benefit from the added value of Swissness by labeling goods or services with the Swiss cross or a designation such as Swiss or Made in Switzerland must comply with the legal provisions and provide proof if a case is brought to court. What do you consider to be the most pressing challenges currently facing IP professionals globally? Legal systems must carefully weigh the societal impact of granting exclusive rights in special areas to avoid monopolies that hinder scientific progress. Balancing protection with public access is crucial in IP law, as an overly restrictive approach can stifle innovation. Open access movements and fair use provisions aim to address this issue by allowing certain uses of IP without permission. By evolving to meet modern challenges, IP law can continue to support innovation while promoting a more equitable, accessible framework that benefits society at large. Navigating the complexities of modern IP law requires a nuanced approach that balances incentives for innovation with public accessibility. Digital piracy, international discrepancies in IP protection, and ethical concerns in biotechnology and AI represent some of the most pressing challenges. Solutions must evolve with technological advancements and globalization, as well as with the ethical considerations unique to fields such as the life sciences and AI. By adapting IP law to address these issues, legal frameworks can continue to protect creators' rights while ensuring that innovation remains accessible and equitable, supporting both economic growth and societal progress. Globalization has encouraged cross-border trade and collaboration, but it also exposes IP to infringement in countries with weaker or differing legal protections. Digital piracy and international infringement. One significant challenge in IP law today is protecting digital content amid widespread online piracy and unauthorized sharing. Digital advancements have made it easy to copy, share, and distribute content globally, often without the IP holder's permission. Enforcement remains difficult across different jurisdictions, where varying legal frameworks can complicate regulatory efforts. How do you see emerging technologies, particularly AI, shaping the future of IP law and enforcement? As AI tools become increasingly adept at generating content, the key question is whether AI poses a threat to human creators or serves as a valuable collaborator. AI has evolved significantly, with advances in computing power, data storage, and algorithms. These developments have enabled AI to become more sophisticated and powerful, leading to its increased use in various industries. The use of AI in creating images, text, and even source code may raise questions about who owns the IP rights in the resulting creations. Furthermore, AI is programmed to generate content based on existing texts, images, code, or data, leading to disputes over ownership as AI systems that are not properly programmed or trained may inadvertently infringe on existing IP rights. With the widespread adoption of AI around the world over the past year, the technology's potential to cause harm has become clearer. While the use of AI across industries has led to innovative products and services, it has also created new challenges for IP owners and regulators. Companies that use AI in their products or services need to be aware of these challenges and risks and develop strategies to protect their IP rights. Having worked across multiple jurisdictions, what are the complexities of cross-border IP protection, and how do you navigate them? The goal is to generate IP that not only sets you apart from competitors but also creates tangible value for your business. It's about recognizing the value and investing in the protection to keep the competitive edge sharp. These portfolio management challenges include increased workload, reduced headcount, time constraints, manual tasks, risk management, global team collaboration, the need for reliable technology. What challenges have you observed or experienced as a woman in the IP field, and what advice would you offer to women looking to build a successful career in this field? Visionary women whose innovations have reshaped industries and created entirely new markets remind us of the rich legacy that awaits full acknowledgement. In my opinion, women shape the world with their ingenuity and female perspective on things. Balancing family and work will always be a big challenge, but I know many outstanding women in the IP sector who manage this exceptionally well. What legacy would you like to leave within the IP community, and is there any message you would like to share with our global readership? I love to work in IP because it's a big team effort. interacting with our international and local network of colleagues who have become long-standing friends like family. The legacy I'd like to leave is one of sharing knowledge and benefiting from practical know-how and insider tips from the IP industry.
Segment page. Asia. Women's IP World Annual 2026.
Page 61. Profile, India. Name, Dr. Shweta Singh. Law firm, Ennoble IP. Position, Founder and CEO. Country, India. Website, www.ennobleip.com. Dr. Shweta Singh is a distinguished entrepreneur, IP strategist, and global thought leader working at the intersection of IP, emerging technologies, and innovation ecosystems. As the founder and CEO of Ennoble IP, she has redefined how organizations protect, manage, and commercialize ideas, transforming IP from a legal function into a strategic business asset. A first-generation serial entrepreneur, Dr. Shweta brings over a decade of expertise in IP law, business strategy, and technology-led innovation. With a doctorate in IP law, she has built Ennoble IP into a globally trusted, technology-enabled organization delivering end-to-end IP solutions, including patent strategy, portfolio management, IP analytics, commercialization, and legal advisory, across more than 150 jurisdictions. The firm partners with startups, corporates, universities, and research institutions, enabling them to unlock the true value of their intellectual assets. Driven by a larger vision to strengthen global innovation ecosystems, Dr. Shweta is deeply committed to positioning India among the world's leading innovation economies. Her work focuses on fostering research-led growth, enabling IP commercialization, and building awareness around the strategic importance of IP, particularly in the era of artificial intelligence and digital transformation. Beyond her entrepreneurial success, Dr. Shweta plays a pivotal role in shaping national innovation frameworks. As chairperson of the Council for Industrial and Innovation Research, she leads initiatives that bridge academia, industry, and government to accelerate innovation and IP adoption. She is also the visionary behind Innovasthan, a nationwide movement designed to empower universities, startups, and SMEs to transform ideas into scalable, market-ready innovations. A strong advocate for inclusive growth and women's empowerment, Dr. Shweta founded the Women Innovation and Entrepreneurship Foundation, supporting women-led startups and first-time entrepreneurs through mentorship, strategy, and ecosystem access. Her leadership philosophy combines business excellence with social impact, making her a role model for emerging women leaders globally. Expanding her entrepreneurial vision, she is also the force behind Hachi, a next-generation skincare platform rooted in Vedic science and modern biotechnology, reflecting her belief in combining traditional intelligence with scientific innovation. Dr. Shweta has also contributed as an advisor and IP expert to leading national and international institutions, including associations with global organizations such as the World Intellectual Property Organization, bringing a global perspective to her work in IP and innovation. Her excellence has been recognized through numerous prestigious awards and honors, including 40 Under 40 by Times Now, Most Inspiring Women Leader, 2022 and 2023, by The Economic Times. Women Entrepreneur of the Year by the Ministry of Finance, India. Exceptional Women of Excellence by the Women Economic Forum. Award for Exceptional Work in IPR for Higher Education by the Ministry of Commerce, India. She has also been praised by the humble Prime Minister of India, Narendra Modi, for her contributions to innovation and women entrepreneurship, and has been featured in leading publications such as Forbes, Businessworld, and Outlook. An inspiring speaker, mentor, and investor, Dr. Shweta Singh continues to influence the global IP landscape by advocating for innovation-led growth, strengthening IP ecosystems, and empowering the next generation of entrepreneurs and leaders. Her journey reflects resilience, vision, and a relentless commitment to transforming ideas into impact through the power of IP.
Page 62. Advertisement. Ennoble IP. Global IP Advisory Practice. Protecting innovation. At every meridian. At Ennoble IP, we advise innovators, enterprises, and global institutions on building and defending intellectual property portfolios that endure. Led by Dr. Shweta Singh, Our practice combines rigorous legal expertise with deep commercial intelligence, enabling organizations to transform ideas into protected, scalable global assets across every major jurisdiction. 151 jurisdictions covered, 25K portfolios managed, 36+ months forward IP intelligence. Core practice areas: patent strategy and global filings, patent research and analytics, trademark protection and brand strategy, IP portfolio management, innovation and technology advisory. Sectors served: technology, AI and ML, life sciences, semiconductors, agriculture, electronics and communication, clean energy, academic and research, media and entertainment, and many more. We see intellectual property not as a passive asset, but as a strategic business instrument, anticipating market shifts, securing competitive position, and delivering measurable commercial returns. Dr. Shweta Singh, founder and CEO at Ennoble IP. Website: www.ennobleip.com. Phone: +919958166931. Email: info@ennobleip.com.
Page 63. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: From Ownership to Omniscience: How Women Are Redefining IP Leadership in the Intelligence Era. Subhead: Dr. Shweta Singh, founder and CEO of Ennoble IP, India, argues that true IP leadership means moving beyond mere patent filing to continuous, intelligence-led value creation. Website: www.ennobleip.com. The provocation: you file, but do you own anything of value? The global IP system has achieved something remarkable in the past 2 decades. It has produced millions of patents and destroyed billions in strategic value, simultaneously. Companies spend fortunes on prosecution, on filing, prosecuting, and maintaining patent portfolios, and then watch those assets gather dust in legal databases, unlicensed, unenforced, and largely irrelevant to the business decisions being made 3 floors above the IP department. Here is the uncomfortable question every IP leader must eventually confront. If your patents cannot be licensed, enforced, or leveraged in a negotiation, do you actually own anything of value, or are you simply the custodian of very expensive paperwork? This is not a critique of the professionals who do this work. It is a critique of the model they have inherited. A model built around filing as the finish line. A model that measures success in application numbers, grant rates, and cost per patent, while quietly ignoring the only metric that matters to a board of directors: IP return on investment. Filing a patent is not an asset. An asset is something that generates returns. Most patent portfolios are liability disguised as achievement. The global IP community has arrived at an inflection point. Artificial intelligence is accelerating the pace of invention. Geopolitical shifts are redrawing the map of where innovation is protected and where it is exploited. And a new generation of IP leaders, many of them women, is beginning to ask the questions that the old model was never designed to answer. The diagnosis: why filing is not value creation. The prosecution-only model of IP management suffers from 3 structural failures, each compounding the other. The first is the silo problem. In most organizations, IP exists in a legal or technical department, disconnected from R&D strategy, commercial planning, and M&A activity. Patents are filed in response to invention disclosures, not in anticipation of competitive landscapes. The portfolio that emerges from this process reflects the company's past innovation, not its future leverage. The second is the cost center mindset. When IP is framed exclusively as a legal function, it is managed for efficiency rather than effectiveness. The question asked is always, how do we reduce the cost of prosecution? Never, how do we maximize the return on this portfolio? These are categorically different questions, and an organization can only optimize for one at a time. The third is the one-time due diligence trap. Organizations assess their IP position when something forces them to: a merger, an acquisition, a litigation threat, or a licensing negotiation. The rest of the time, IP sits unmonitored, its competitive relevance untracked, its vulnerabilities unmapped. By the time the organization looks again, the landscape has shifted, and the portfolio is already misaligned. Consider the analogy of a landowner who purchases a significant parcel without ever surveying what neighbors are building, leasing to tenants, or understanding what the land might yield. The title is held. But ownership, real ownership, the kind that creates wealth, requires continuous engagement, not a one-time transaction. There is a critical difference between owning IP and controlling IP value. Most organizations have achieved the former while never attempting the latter. The new model, from IP due diligence to IP intelligence. What the IP profession needs, and what the most sophisticated organizations are beginning to build, is not better prosecution. It is a shift from IP due diligence to IP intelligence. IP due diligence is transactional, backwards-looking, and episodic. It asks, what do we own, and is it defensible? IP intelligence is strategic, forward-looking, and continuous. It asks, what does our IP position tell us about where we should compete, where we are vulnerable, and where the next opportunity for value creation lies? The distinction matters profoundly because the intelligence gap between organizations that manage IP continuously and those that do not is widening at a pace that few practitioners have fully reckoned with. Generative AI is dramatically accelerating prior art identification, claim analysis, and freedom to operate assessment. Companies that deploy these tools within a continuous intelligence framework gain real-time visibility into their competitive position. Those still relying on periodic reviews are, effectively, flying blind between landing strips. IP intelligence, properly implemented, becomes a board-level function. It informs R&D investment decisions by mapping white spaces and competitor filing trajectories. It guides M&A strategy by revealing portfolio synergies and acquisition risks before deal teams engage. It supports licensing by identifying undermonetized assets and prospective partners with aligned technology roadmaps. And it protects organizations by continuously monitoring for infringement and emerging threats. The framework, 4 pillars of end-to-end IP management. At Ennoble IP, we have built our practice around a 4-pillar framework that treats IP management as a continuous, value-generating discipline rather than a transactional legal function. Each pillar is interdependent, and the power of the model lies in the loop, the way insight from one stage continuously informs the others. The first pillar is Discover, the intelligence layer that connects R&D activity to IP strategy before a single application is filed. This means understanding competitor filing behavior, identifying technology adjacencies, and ensuring that inventions are captured and prioritized based on their commercial potential, not simply their technical novelty. The second pillar is Protect, and this is where quality must decisively replace speed. The global IP profession has a quality crisis driven by volume pressure. Claim architecture, the craft of drafting claims that are simultaneously broad, defensible, and enforceable, is what separates a patent that creates leverage from one that creates false confidence. Quality prosecution is not more expensive. It is dramatically cheaper over the life cycle of a portfolio because weak patents cost vastly more to defend and yield nothing in licensing. The third pillar is Monetize, the stage where IP value is actually realized. This encompasses licensing strategy, technology transfer, IP-backed financing, and strategic partnerships. Most organizations never reach this pillar because they are too consumed by managing the costs of the first two. Building monetization into the model from inception, asking how will this asset generate returns? At the point of filing, changes the quality of every decision upstream. The fourth pillar is Monitor, the continuous intelligence loop that keeps the entire framework alive between transactions. This means tracking competitor portfolios, watching for infringement, anticipating regulatory shifts, and ensuring that the organization's IP position evolves in step with its commercial strategy. An IP portfolio is not a library. It is a living strategic asset that demands the same continuous attention as a product roadmap or a commercial pipeline. Building an IP empire, a woman's blueprint for strategic leadership. I did not set out to build an IP management firm. I set out to solve a problem I had watched destroy value at organizations large and small, the complete disconnection between the intellectual assets a company creates and the business outcomes those assets are supposed to support. Building a noble IP has been, in many ways, an exercise in applying the same four-pillar framework to a firm as we apply to a portfolio. Discover what the market genuinely needs, not what it thinks it needs. Protect the quality of the work relentlessly, even when clients push for speed. Build a monetization model that aligns our incentives with our clients' outcomes. And monitor continuously the competitive landscape, the technology environment, the evolving expectations of the businesses we serve. What I have come to understand, having built this practice and having worked alongside some of the sharpest IP minds across jurisdictions, is that the qualities most associated with women in leadership are precisely the qualities that end-to-end IP management demands. The ability to hold multiple stakeholder perspectives simultaneously. The willingness to ask uncomfortable questions about whether the established model is actually serving the client's interests. The relational intelligence to build the cross-functional trust that makes IP a strategic partner to the business rather than a cost center it tolerates. This is not an argument for essentialism. It is an observation about what the IP profession needs at this moment, and about who is positioned to provide it. The transition from an IP profession organized around filing to one organized around value creation requires leaders who can hold the technical depth and the strategic breadth simultaneously. It requires people who are comfortable challenging orthodoxy. It requires, above all, the conviction that IP leadership is not about managing a process. It is about shaping outcomes. Women who are building practices, leading IP departments, or shaping policy in this space are doing something more significant than their titles suggest. They are rewriting the operating model of a profession that has been running on the same assumptions for 40 years. That is not incremental leadership. That is transformation. The manifesto, what the IP profession must now demand. The global IP community, practitioners, in-house counsel, policymakers, and the organizations that depend on their counsel must hold itself to a new standard. Stop measuring IP success by filing counts and start measuring it by value generated. Prosecuting 10,000 patents that yield no licensing revenue, create no competitive barrier, and inform no strategic decision is not an achievement. It is an expensive illusion. Demand continuous intelligence, not episodic due diligence. The organizations that will lead in the next decade are those whose IP position is as current as their commercial strategy, not those who discover what they own when a deal forces them to look. Build IP leadership into the boardroom. IP is no longer a legal function. It is a strategic asset class. It belongs in conversations about R&D investment, and a strategy, and competitive positioning, not in a quarterly report that no one reads. And recognize that the women entering and leading this profession are not filling seats at the table. They are building a different kind of table altogether, one where IP management is understood, finally, as the high-stakes strategic discipline it has always deserved to be. The future of IP leadership is not about who can file the most. It is about who can see the furthest, and build the intelligence architecture to act on what they see. The shift from ownership to omniscience is not a luxury. For organizations that want to compete in a world where intellectual capital is the primary source of value, it is the only viable path forward. About the author. Dr. Shweta Singh is the founder and CEO of Ennoble IP, a full-service IP management firm. She works with innovators, enterprises, and institutions globally to build IP strategies that generate measurable business value. Page 66. Profile, Indonesia. Name, Migni Miryasandra. Title, Managing Director. Company, Biro Octroy Rusino. Country, Indonesia. Website, www.iparbor.com. IR. Migni Noah Hardy, S. H. MIP. MSL. MM. Daughter of Toeti Harati, granddaughter of Rusino, was born in Bandung. She graduated in 1985 from the Department of Environmental Engineering, Bandung Institute of Technology. She also took an IP course in 1993 conducted by the Faculty of Law, University of Indonesia, and the Directorate General of Copyright, Patent and Trademark, Department of Justice. She earned a master's degree in IP in 1994 from the Franklin Pierce Law Center, Concord, New Hampshire, USA, and a master's degree in environmental law from the Vermont Law School, South Royalton, USA. After graduating from Franklin Pierce Law Center, she took practical training at the Library of Congress, Washington, D.C., in 1994 and EG&G, Incorporated. At Wellesley, Massachusetts, USA. Like her grandfather and mother, Migney has focused her career on IP, which she began after she left college. She took a specialized course in IP rights at the Japan Institute of Innovation and Invention, JIII, in Tokyo, Japan, and the Indonesia-Australia Specialized Training Project in 1996. She became one of the panelists at the APEC/ABAC Joint Symposium on IP in 1999 at Kitakyushu, Fukuoka, Japan. She is also a member of several IP associations, including Asian Patent Attorneys Association, APAA, International Trademark Association, INTA, Association Internationale pour la Protection de les Propriétés Intellectuelles, AIPPI, Indonesian Intellectual Property Society, IIPS, and Asosiasi Konsultan Hak Kekayaan Intelektual, Association for Intellectual Property Consultants, AKHKI. Migney has been fully and actively involved in IP by managing the operations of Biro Octroi Rusino and PT. Biro Octroi Rusino. Under Migney's leadership, Biro Octroi Rusino has achieved important milestones, including standardizing the following services through ISO certification for ISO 9001:2015 Quality Management Systems, ISO/IEC 27001:2022 Information Security Management Systems, ISO/IEC 27701:2019 Privacy Information Management Systems, ISO 37001:2016 Anti-Bribery Management Systems. In 2017, guided by her strong vision and leadership, Biro Octroi Rusino took bold steps to expand its business internationally by establishing a new branch office in Singapore. At that time, Migney was already managing Biro Octroi Rusino, where her strategic direction and unwavering commitment played a crucial role in accelerating the firm's growth and increasing its presence in the regional market. In the field of IP, Biro Octroi Rusino offers the following services: filing and prosecution of patents, trademarks, copyrights, industrial designs, geographical indications, and layout designs of integrated circuit applications in Indonesia and abroad, registration and maintenance of IP, annuity fee, consultant services on IP, patent and trademark searches and registrability opinions, patent and trademark surveillance and/or infringement investigation services, checking and managing patent, trademark, and copyright portfolios of individuals and companies, consultant services, and legal assistance in nullity lawsuits and/or enforcement of preparation and review of licensing agreements. Key practices: filing, prosecution, registration, and maintenance of IP, consulting services on IP, IP searches and registrability opinion, management of patent, trademark, and copyright portfolios of individuals, companies, plant variety protection. Membership: INTA, AIPPI, APAA, AKHKI, and IIPS. Page 67. Profiles: Sri Lanka. Profile 1. Name: Anomi I. Wanigasekara. Title: Senior Partner. Company: Julius and Creasy. Country: Sri Lanka. Website: www.juliusandcreasy.com. Anomi I. Wanigasekara, attorney at law, is the senior partner of Julius and Creasy, Sri Lanka, a legal firm founded in 1879 that has established itself on a rich tradition and the highest professional principles over its 147-year journey. She is also the partner in charge of the firm's IP division. Anomi holds a master's degree from the University of Wales in International Trade Law and diplomas in Intellectual Property Law, International Trade Law, and Banking and Insurance Law from the Institute of Advanced Legal Studies of the Incorporated Council of Legal Education, which expanded her legal knowledge across distinct fields of law. She is a member of the International Trademark Association, INTA. Anomi co-chairs the INTA General Advisory Council South Asia region for the term 2026-2027. She is also a member of the INTA Unfair Competition Committee for the term 2026-2027. Anomi is a member and councillor of the Asian Patent Attorneys Association, APAA, and the Vice President of the Sri Lanka Group. Anomi has contributed to many local and international journals on various topics related to IP. She has extensive experience in all IP prosecution matters as well as enforcement, opinions on all aspects of IP, including patents and copyright, management and transactional matters pertaining to IP law, including representing clients before the NIPO, acting for multinationals as well as Sri Lankan conglomerates in respect of infringement actions, and applying for injunctions and search and/or seizure orders. Anomi also overlooks drafting and reviewing of contracts and advises on regulatory compliance matters in relation to food, drugs, cosmetics, tobacco and narcotics, and more. She is a leading IP lawyer with a wealth of knowledge and extensive experience of over 42 years in all aspects of IP law. Awards: Legal 500 Hall of Fame, Chambers and Partners Asia Pacific Band 1 IP, 2022 to 2025. The Lawyer Network Full Service Lawyer of the Year Sri Lanka 2025. The Lawyer Network Intellectual Property Lawyer of the Year Sri Lanka 2025. Legal 100 Best Partner of the Year Sri Lanka 2025. Manda Today Best Partner of the Year Sri Lanka 2025. American Business Vanguard Best Partner of the Year Sri Lanka 2025. Advisory Excellence Exclusive IP Law Position Sri Lanka 2025. Advisor Society Exclusive Intellectual Property Expert of the Year Sri Lanka 2025. Leaders in Law IP Law Expert Sri Lanka 2024. Full Service Lawyer of the Year 2024 Global Law Experts. Full Service Lawyer of the Year 2024 Corporate America Today. Full Service Lawyer of the Year 2025 Corporate America Today. Memberships: Life Member of the Bar Association of Sri Lanka. Life Member of the Law Society of Sri Lanka. Council Member of the Asian Patent Attorneys Association, APAA. Vice President of the APAA Sri Lanka Group. Member of the International Trademark Association, INTA. Committee Member of the Unfair Competition Committee of INTA for the term 2026 to 2027. Co-chair of the INTA General Advisory Council South Asia region for the term 2026 to 2027. Profile 2. Name: Sabira Sharif. Law firm: Julius and Creasy. Position: Partner. Country: Sri Lanka. Website: www.juliusandcreasy.com. Sabira Sharif, attorney at law, is a partner at Julius and Creasy, Sri Lanka, a legal firm founded in 1879 that has established itself on a rich tradition and the highest professional principles over its 147-year journey. She was called to the bar in the year 2014 and joined the firm in 2016. Sabira holds a master's degree, LLM, from the University of Colombo in the field of commercial law. She was also awarded the title of Best Student in the Certificate Course in IP at the University of Colombo, based on merit. Sabira has contributed to several international journals and guides on various IP-related topics. She is a member of the Asian Patent Attorneys Association, APAA, and has attended its conferences in 2023, 2024, and 2025. She serves as the country representative on the APAA Copyright Committee, including presenting the country report for the year under review. Sabira is also a life member of the Bar Association of Sri Lanka and a member of the International Trademark Association, INTA, Anti-Counterfeiting South Asia Subcommittee for the term 2026-2027. Sabira is attached to the IP division of the firm and is well experienced in enforcement matters in relation to IP, including civil and criminal prosecution. She provides opinions on all aspects of IP to local and foreign clients. She is also engaged in drafting submissions, oppositions, and observations in relation to trademarks, drafting cease and desist letters and cautionary notices, reviewing commercial agreements, and advising on regulatory compliance matters. Sabira is currently reading for the M.Phil at the University of Colombo in the area of IP law. Publications. Contributor to the Global IP Matrix across multiple editions, including Issue 22 on parallel imports in a Sri Lankan context, Issue 18 covering the protection of certification marks, collective marks, and geographical indications in Sri Lanka, Issue 11 discussing the protection of unregistered marks under the theme What is worth copying is worth protecting, Issue 9 examining patent rights during the COVID-19 pandemic, with a focus on vaccine development and compulsory licenses. Contributor to Chambers and Partners across multiple publications, including Innovate or Stagnate, Intellectual Property as a Key Catalyst for Sri Lanka's Future Growth, the 16th of February 2024, Patent Litigation 2026 Sri Lanka Guide, Trademarks and Copyright Global Practice Guide for 2025 and 2026. Contributor to the Women's IP World Annual across multiple editions, including 2026 issue on recognition of well-known trademarks in Sri Lanka, 2025 edition covering the Online Safety Act of Sri Lanka, 2022 edition on enforcement and protection against unauthorized disclosure under the Intellectual Property Act No. 36 of 2003. Contributor to Corporate Livewire Handbooks and Expert Guides across multiple editions, including 2025 Expert Guide on Brand Protection through Trademark Registration with Sri Lanka Customs and Protection of Non-Traditional Marks, 2024 Intellectual Property Expert Guide addressing layout designs of integrated circuits, 2023 Handbook on Industrial Design Protection in Sri Lanka, 2022 Handbook on Geographical Indications Protection in Sri Lanka, co-contributor for World Trademark Review Anti-Counterfeiting and Online Brand Enforcement, Global Guide 2025, Sri Lanka Chapter Sri Lanka, Legal Framework and Enforcement Strategies for Combating Counterfeits. Page 68. Article. Title, Recognition of Well-Known Trademarks in Sri Lanka. Subhead, written by Anomi Wanigasekara, Senior Partner, and Sabira Sharif, Partner, of Julius & Creasy, Sri Lanka. Website, www.juliusandcreasy.com. Sri Lankan law recognizes and protects well-known trademarks, outlining the relevant statutory provisions, international obligations, and enforcement mechanisms under the Intellectual Property Act. The main function of a trademark is to distinguish the goods of different enterprises. According to Lord Diplock, the interest of the general public requires that they should not be deceived by the trademark. In Sri Lanka, the Intellectual Property Act, No. 36 of 2003, IP Act, governs all aspects of IP, including trademarks. Sri Lanka is a signatory to the Paris Convention for the Protection of Industrial Property and the Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS Agreement, both of which specifically mention and recognize well-known marks. Registration provides exclusive rights in relation to a trademark subject to certain statutory limitations. In Sri Lanka, the use of a trademark is not a prerequisite for registration. Registration of a mark may be granted to the person who is the first to fulfill the conditions of a valid application or is the first to validly claim the earliest as provided in the IP Act. Further, the admissibility of a mark will be examined under Sections 103 and 104 of the IP Act. According to Dr. D.M. Karunaraten, Section 104(1)(d) denies the registration of marks in the light of well-known marks and trade names. Also, well-known marks are recognized as a relative ground for third parties to object to the registration of a proposed mark. However, the IP Act does not define well-known marks. According to Section 104(1)(d) of the IP Act, the Director General shall not register a mark if it is identical with, or misleadingly similar to, or constitutes a translation or transliteration or transcription of a mark or trade name which is well known in Sri Lanka for identical or similar goods or services of a third party, or such mark or trade name is well known and registered in Sri Lanka for goods or services which are not identical or similar to these in respect of which registration is applied for, provided in the latter case the use of the mark in relation to those goods or services would indicate a connection between those goods or services and the owner of the well-known mark and that the interests of the owner of the well-known mark are likely to be damaged by such use. It is apparent that the section speaks of two circumstances: the use of a proposed mark in relation to identical or similar goods or services, and in relation to different goods or services. Where the proposed mark is identical with, or misleadingly similar to, or constitutes a translation, transliteration, or transcription of a well-known mark for identical or similar goods or services, registration of such well-known mark in Sri Lanka is irrelevant. Article 16.3 of the TRIPS Agreement extends the protection of Article 6 bis to well-known marks when used on unrelated goods or services in cases of well-known marks. The use of the well-known mark in Sri Lanka is not material. The facts and circumstances of the particular case will matter in determining whether a mark is well known in Sri Lanka. Section 104(2) provides certain non-exclusive or exhaustive criteria for the purpose of determining whether a mark is well known. Criteria include any fact or circumstance from which it may be inferred that the mark is well known, the degree of knowledge or recognition of the mark of the relevant sector of the public, the duration, extent, and geographical area of use of the mark, the duration, extent, and geographical area of promotion of the mark, including advertising or publicity and the presentation at any fair or exhibition of the goods or services to which the mark applies, the duration and geographical area of the registration or the application for registration of the mark, to the extent that they reflect use or recognition of the mark, the record of successful enforcement of rights of the mark, in particular, the extent to which the mark has been recognized as being well known by the competent authority, the value associated with the mark. Article 16(2) of the TRIPS Agreement states that in determining whether a trademark is well known, members shall take into account the knowledge of the trademark in the relevant sector of the public, including knowledge obtained as a result of the promotion of the trademark. The IP Act defines the relevant sector of the public to include actual or potential consumers of the goods or services, persons involved in distribution channels of those goods or services, any person or body dealing with such goods or services to which the mark applies. It is noted that India has introduced and maintains a well-known list of marks published on its official Trademark Office website. In conclusion, the enforcement of the rights of well-known marks in Sri Lanka may be through civil and criminal action. Unregistered marks may also be enforced under the provisions of unfair competition provided in Chapter 32 of the IP Act. In such circumstances, even without registration, well-known marks could be protected in Sri Lanka.
Segment page. IP Industry Services. Profiles and Articles. Women's IP World Annual 2026. Page 72. Advertisement. United Trademark and Patent Service. Intellectual Property Attorneys. Your reliable partners for intellectual property matters in Pakistan, South Asia, Arabian Gulf, Middle East, and Africa. Trademark, patent, design, copyright, domain name registration, litigation and enforcement law. Pakistan Office. 85, The Mall Road, Lahore 54000 Pakistan. Adjacent Rado Kronos / Hang 10 Mall Plaza Building. Telephone +92 4236285588-90, +92 4236285581-84. Fax +92 4236285585, 362855586, 362855587. Email unitedtrademark@unitedtm.com. Websites www.utmps.com and www.unitedip.com.
Page 73. Profile UK. Name, Chulin Dai. Title, Senior Patent Analyst. Company, Patworld. Country, UK. Website, www.patworld.com. Chulin Dai is a senior patent analyst at Patworld, specializing in the development of patent strategies and the delivery of comprehensive patent searches and analyses, particularly in chemistry-led innovative technologies. She supports organizations in navigating complex technological landscapes, enabling them to make informed and strategic decisions. After obtaining an MS in chemistry from Bangor University, Chulin joined Patworld in 2017 following a recommendation from a friend. Motivated by a desire to apply her scientific expertise and further refine her analytical capabilities, she embraced the opportunity to explore the field of patent intelligence. Since then, she has developed a strong understanding of how innovation progresses from early-stage research into real-world applications and the potential these developments have to create positive societal impact. Working collaboratively with colleagues in the chemistry team, Chulin applies her scientific knowledge and analytical skills across a wide range of patent search projects. Her work includes patentability, freedom to operate, FTO, invalidity, state-of-the-art, and mapping studies. She is experienced in designing tailored patent search strategies to meet individual client requirements, analyzing large volumes of patent data, interpreting complex technical information, and identifying key trends to deliver clear and actionable insights. Chulin has a particular interest in emerging technologies and the role they play in addressing global challenges. In her recent research into decarbonization technologies, she has examined patent filing activity, technology classifications, and legal status data to identify innovation trends within the sector. Her work provides valuable insight into competitive pressures faced by industries as they respond to climate change challenges and evolving regulatory demands aimed at reducing carbon emissions. Throughout her career, Chulin has demonstrated a commitment to continuous professional development. She has achieved a Level 4 diploma in Principles of Leadership and Management from ILM, further strengthening her ability to contribute effectively in a collaborative, client-focused environment. Outside of her professional responsibilities, Chulin enjoys spending time at the theatre and regularly attends performances. She also enjoys walking in local parks and exploring a variety of cuisines, using food as a way to experience different cultures and unwind from her work. With experience spanning bioscience, chemistry, electrical and mechanical engineering, IT, and physics, Chulin contributes to PatWorld's ability to offer specialist patent searching services across a broad range of technologies. Through a data-driven and tailored approach, she helps deliver high-quality analysis that supports clients in making confident, informed decisions. Page 74. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: Visualizing Decarbonization, a Data-Driven Analysis on Patent Trends. Subhead: Chulin Dai, Senior Patent Analyst at PatWorld, UK, explores recent patent trends to reveal how innovation is driving the global transition to low-carbon technologies. Website: www.patworld.com. The global push toward decarbonization has become one of the defining technological and economic transformations of the 21st century. As governments set out stricter climate targets, global corporations and research institutions are increasingly under pressure to develop and deploy low-carbon technologies to reduce greenhouse gas emissions while maintaining industrial productivity and economic growth. Within this rapidly evolving landscape, patent intelligence plays a critical role in understanding where innovation is happening, who is driving it, and which technologies are shaping the future of the low-carbon industry. The decarbonization imperative. Decarbonization refers to the process of reducing carbon emissions released into the atmosphere by using alternative energy sources, improving industrial processes, and deploying technologies that capture or prevent emissions. This includes carbon capture and storage, renewable energy generation, including offshore wind, and the electrification of transport systems. Such technological pathways are widely recognized as key mechanisms for achieving the global greenhouse gas reduction goals established under the Paris Agreement, United Nations. The urgency of this transition is reflected in the scale of global emissions. Currently, the largest contributors to global carbon emissions include China, the US and India, largely due to the scale of their industrial sectors and energy consumption. Global Carbon Project. 2. In response to growing climate concerns, international cooperation has intensified. The Paris Agreement, adopted in 2015, established a global framework to limit global temperature increases and encourage nations to reduce greenhouse gas emissions. Many countries have since introduced ambitious national policies aligned with these commitments. In the United Kingdom, the government has committed to achieving net zero greenhouse gas emissions by 2050, supported by legislative frameworks and independent oversight from the Climate Change Committee, House of Commons Library, 2025. 3. Recent assessments from the Climate Change Committee suggest that the UK has performed relatively strongly among G20 countries in reducing greenhouse gas emissions, reflecting sustained policy focus and investment in low-carbon technologies. Climate Change Committee, 2025. 4. Mapping innovation through patent data. This study focuses on patents associated with decarbonization-related technologies, particularly in patent classification Y02C020/40, capture or disposal of greenhouse gases of CO2. An area of significant importance due to its impact on global carbon emissions. This analysis addresses several critical questions. Which countries are leading innovation? Which companies are investing most heavily in these technologies? Which technical areas are gaining momentum? Where might the next wave of innovation emerge? Recent growth in patent activity. Figure 1 examines the number of patent families by the earliest priority year, offering insight into how innovation activity has evolved over time. Note: the apparent decline shown in 2025 may be due to patent applications that have yet to be published, and that would claim priority in that year. The data reveals a clear upward trend in patent filings over the past 20 years, indicating a steady increase in research activities and sustained growth in innovation within decarbonization technologies. This trend reflects increasing awareness of climate change, stronger regulatory pressure, and the growing commercial importance of low-carbon technologies. It also reflects the impact caused by the COVID-19 pandemic. During this period, many research programs and industrial activities were delayed or paused. In response, many national IP offices introduced deadline extensions. After this period, patent activities have recovered. This is reflected in a modest increase in the number of filings around the period between 2021 and 2022. Global leaders in decarbonization innovation. Figure 2 examines the distribution of earliest priority filings by jurisdiction, indicating where innovation is concentrated. The data shows China dominates the field, accounting for the highest volume of patent filings. The US and Japan follow as the next most active jurisdictions. Note: WO and EP publications are not shown on this map. The table below shows the distribution of the earliest priority filings in the top 10 jurisdictions. Priority country. The data shows that China and the US account for 48.3% of total patent filings in these technologies. As expected, these two countries are amongst those with the highest carbon emissions, due to their strong presence in the manufacturing industry, accounting for 1/5 of the world's carbon emissions. The volume of filings shown reflects a strong strategic focus on accelerating the decarbonization of their manufacturing industries. The large number of filings by these jurisdictions may also reflect increasing competition for technological leadership in this field. As some patented technologies may ultimately become industry standards, faster innovation cycles could enable these countries to shape technological pathways and secure leadership positions. Patent protection signals strategic importance. The chart in Figure 3 examines how the legal status of patent filings has changed over time, demonstrating the importance of patent protection and commercial potential for innovators. The data suggests that an increasing volume of filings are progressing to granted status, which follows a trend of strong technological progression and economic potential. At the same time, a large proportion of patents remain active and in force, indicating that companies continue to invest in research and development and maintain protection for these technologies. This trend signifies the importance of this sector for innovators. When companies maintain patent protection over long periods, it demonstrates that the underlying technology has strong commercial value or strategic relevance. This trend suggests that many stakeholders are anticipating long-term value in this sector, which is becoming a growing market of interest. Figure 4 examines the distribution of legal status by jurisdictions in more detail. Overall, China and the US lead in patent protection in these technologies. Both China and the US have a large proportion of patents, in both granted and pending states, signaling their strong presence and leadership in these technologies. This is also reflected in their high government energy spending, as both countries consistently rank as the top spenders on low-carbon transportation and electricity. 6. By comparison, Japan shows a more balanced portfolio with a more moderate number of filings in the pending state, suggesting a mature innovation position in which technologies in this field may be moving from the developmental stage toward protection and deployment. A notable pattern is the comparatively high volume of dead patents for the top 3 countries. This reflects the experimental and competitive nature of decarbonization technologies, where innovations may fail to reach long-term viability, underlining the uncertainty and fast evolution in these technologies and emerging green sectors. Identifying the dominant innovators. Figure 5 shows the distribution of patent filing activities by the top 10 leading assignees over the past 20 years. It identifies Air Liquide, Mitsubishi Heavy Industries, and Air Products and Chemicals as having the largest shares in decarbonization technologies. Overall, patent activity has shown a general increase over the years, with peaks around 2010 to 2012 and again in 2020 to 2022. Air Liquide and Mitsubishi Heavy Industries showed consistent activity in the early years and remain relatively strong in output, but have shown a slight decline in recent years. Notably, Mitsubishi Heavy Industries recorded no filings in 2022 but has since resumed its activities. A revealing trend is the rise of Chinese organizations such as China Petroleum and Chemical, Huining Clean Energy Research Institute, and Sinopec, which had little to no activity before 2010 but demonstrated rapid growth from the mid-2010s onward, indicating growing momentum and a shift in innovation leadership towards China in recent years. This reflects a transition from early dominance by established industrial economies to a growing contribution from China, with both sustaining patent activity in the industry. Key technical areas of innovation. Further analysis of patent activities from the most active players. This final chart, Figure 6, examines the technologies these companies are currently working on by looking at the most prevalent IPC classifications. In general, most concentrated activities are in B01D53/00, separation of gases or vapors, recovering vapors of volatile solvents from gases, chemical or biological purification of waste gases, in particular for subclasses B01D, 053/62, removal of carbon oxides, and B01D 053/14, absorption of gases or vapors. This indicates that gas separation, purification, and treatment technologies are the dominant areas of focus across all companies in this field. Other areas showing high activity include subclasses B01D 053/04, stationary adsorbents, B01D 053/02, adsorption, and C01B 032/50, carbon dioxide. Among the top players, Air Liquide and Air Products and Chemicals are leading in adsorbent technology, as represented by B01D 053/04 and B01D 053/047, pressure swing adsorption. Mitsubishi Heavy Industries and Toshiba are focused on the treatment of carbon dioxide-related technologies represented in C01B 032/50. Meanwhile, Chinese organizations exhibit more distributed activity across multiple technology fields, with a smaller overall presence. They display notable interest in B01J020 classes, solid sorbent compositions or filter aid compositions, sorbents for chromatography, processes for preparing, regenerating, or reactivating thereof, indicating their expertise in this technology. PatWorld's expertise in patent landscape analysis. For companies operating in rapidly evolving technology sectors, understanding the innovation landscape is essential. Patent intelligence provides far more than simple counts of patent filings. By analyzing trends in filing activity, technology classifications, and legal status, we can identify emerging opportunities, competitive pressures, and potential collaboration partners. At PatWorld, we offer technical expertise and advanced patent search strategies to produce detailed technical analysis and interpretation that can help identify where technologies are moving and where future breakthroughs may occur, supporting companies in strategic decision-making. As this research demonstrates, the story of decarbonization is not only about policy commitments or climate targets, but also about innovation, collaboration, and technological ingenuity. And through close analysis of patent data, we gain valuable insight into how the future of the sustainable industry is being shaped. Page 79. Profile: Switzerland. Name: Nadine Stuttle. Title: Founder and CEO. Company: PSS Solutions. Country: Switzerland. Website: www.pss-solutions.com. Nadine Stuttle is the founder and CEO of PSS Solutions, where she leads the delivery of transformational change across the IP sector by combining operational excellence, digitalization, and disciplined project execution. With more than 25 years of experience spanning the legal, IP, and technology sectors, Nadine is widely recognized and awarded for her deep expertise and thought leadership within the industry. Early in her career, Nadine established her own career path within the legal profession, moving into operations and technology at a time when these disciplines were still emerging within the sector. This strategic decision positioned her at the forefront of operational and digital transformation, enabling her to bridge legal expertise, technology platforms, and business performance. Her career has been shaped by a deep understanding of how IP systems, processes, and people must align in order to deliver sustainable and scalable change. Nadine has worked extensively with global corporates and leading IP firms across Europe, North America, and Asia, bringing a truly international perspective to transformation programs. Her global experience enables her to design and deliver initiatives that scale effectively across jurisdictions while remaining sensitive to regulatory, cultural, and operational differences. She is particularly skilled at navigating complex stakeholder environments, aligning leadership teams, and delivering results across multinational organizations where transformation requires both strategic clarity and disciplined execution. As CEO of PSS Solutions, Nadine partners closely with clients to modernize operating models, streamline processes, and embed digital capability across their organizations. She leads high-impact programs spanning system implementation, process redesign, governance enhancement, and large-scale change management initiatives. Known for her pragmatic and hands-on approach, Nadine remains closely involved in program delivery, ensuring that transformation initiatives move beyond strategy and translate into measurable, lasting outcomes. Her focus is always on achieving practical improvements that strengthen operational performance and create long-term value. In addition to her client work, Nadine serves as a trusted advisor to the private equity market, supporting mergers and acquisitions across the legal, IP, and technology sectors. She provides operational and technology due diligence, integration planning, and post-merger transformation support, helping investors identify operational risks, uncover opportunities for value creation, and execute integrations aligned with strategic objectives. Her ability to quickly assess complex operating environments and design practical solutions has made her a valued partner to investors and leadership teams alike. Alongside her commercial work, Nadine is deeply committed to supporting the development of talent within the IP and legal operations community. She is passionate about mentoring professionals across the sector, sharing her experience to help others navigate evolving career paths in operations, technology, and transformation. By encouraging knowledge sharing and supporting emerging leaders, she actively contributes to strengthening the future capability and resilience of the industry. Nadine is recognized as an industry thought leader in operational excellence and digital transformation. Her insights are grounded in decades of practical delivery experience and informed by exposure to global markets and rapidly evolving technology landscapes. She is known for cutting through complexity, providing clear strategic guidance, and maintaining momentum through organizational change. Integrity, accountability, and professionalism define Nadine's leadership style and underpin the trusted relationships she builds with clients, investors, and industry peers.
Page 80. Advertisement. IP Tech and Innovation Services Annual. Recognizing the game changers, redefining innovation, and driving support across the world of intellectual property. Showcase your IP tech innovations to a global audience in the 2027 edition. The global platform for IP technology and service providers. Whether you're offering solutions or seeking them, join the publication that connects innovators, law firms, and corporates worldwide. Feature your profile, share your expert editorial, showcase your platform's capabilities, and enhance your brand visibility in the IP Tech and Innovation Services Annual 2027. Contact us today at call +440 2038130457. Email technovation@northonsprmarketing.com. Website www.iptechnovation.com.
Page 81. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: A Scientist and a Lawyer. Subhead: Dr. Claudia M. Duffy, European patent attorney and founder of Innovair IP, UK, recounts how she united a career in physics with IP law to champion innovative IP strategies. Website: www.innovair-ip.co.uk. A scientist and a lawyer? This is a question I have been asked many times, and one I have come to embrace as the most concise summary of an unconventional, international, and deeply rewarding career path. The answer, as I hope to demonstrate, is not only yes, but absolutely, and here is why. From Romania to Cambridge, a scientist's journey. My story begins in Timisoara, Romania, where I graduated first in year from my BSc in physics and chemistry. In 1998, straight after graduation, I left my home country on a one-way bus ticket to pursue a career in science. That single act of departure set the tone for everything that followed: a willingness to move, to adapt, to pursue excellence across borders and disciplines. I completed a Master of Science in Physics at Technische Universität München, with my project sponsored by Siemens, an industrial partnership that placed me at the forefront of semiconductor memory research. I then worked as a research scientist in analog IC design at Infineon Technologies, a spin-off from Siemens. Following that, I was awarded a PhD at the Cavendish Laboratory, Cambridge University, sponsored by Hitachi, investigating organic thin-film transistors. Cambridge was formative in ways that extended well beyond the laboratory. It was there that I first encountered the role of IP in business, and where I also, painfully, experienced what it means to have your innovation taken without acknowledgement. That experience of having IP taken away from me, without attribution, was the catalyst that set me on a new course. Determined not merely to be frustrated by the system but to understand and improve it, I entered the patent profession in 2008. The value of being both scientist and patent attorney. Whilst qualifying as a European patent attorney via Queen Mary University of London, CP, and the European qualifying examinations, I came to appreciate something that is not always obvious from the outside. The combination of a deep scientific background and formal legal qualification is not just complementary, it is genuinely rare and exceptionally powerful. A patent attorney who has spent years in a clean room, debugging experimental setups, writing reports for industrial sponsors in Japan and Germany, and navigating the politics of R&D departments brings an entirely different perspective to the patent drafting table. I can hold a conversation with an inventor in their own language, literally and technically ask the right questions, spot the invention, and translate innovative science into legally robust claims. In today's innovation-driven economy, that translation work is where much of the real value lies. My scientific and in-house attorney careers spanned well over a decade. Working as a Master of Science researcher and research scientist at Siemens and Infineon Technologies in Munich, then as a PhD researcher in Cambridge, and later as an in-house patent attorney for two Cambridge University spin-outs 819, Organic Solar Cells, and Cambridge Display Technology, OLEDs, I accumulated a practical understanding of how innovation actually happens inside organizations, how it gets protected, how it is commercialized, and all too often, how it gets overlooked. An international career, private practice, in-house, and beyond. My career has taken me from Munich and Cambridge to London and Edinburgh, with periods in private practice firms alongside my in-house roles, as well as university research commercialization. This breadth of experience has been invaluable. In-house work taught me to think strategically about IP as a business asset, to be commercially sharp and cost-conscious, to understand the rhythms of R&D and how they intersect with funding cycles and commercial timelines. Private practice then gave me the technical rigor, procedural discipline, and client-facing skills to complement that strategic thinking. And research commercialization blended all of these skills in academia-industry collaborations. I have worked as a European patent attorney, UPC representative, and IP consultant across firms in London, Cambridge, and Edinburgh, before founding Innovare IP in 2019, a full-service practice of patent and trademark attorneys and IP consultants. I hold British and Romanian citizenships, am fluent in English and Romanian, and have conversational knowledge of German, a linguistic range that reflects and reinforces a genuinely European perspective on IP. A different kind of IP practice. When I founded Innovare IP, I made a deliberate choice to depart from conventional private practice models. Rather than focusing primarily on large corporates or filing volume-driven work, Innovare IP works within the entrepreneurial ecosystem, SMEs, investors, accelerators, and university technology transfer offices. The focus is on IP commercialization and IP strategy, helping founders and growing businesses understand not just how to protect their IP, but how to leverage it as a genuine business asset to unlock funding and accelerate growth. This means acting as a fractional in-house attorney for high-growth companies, conducting IP due diligence for investor groups, advising on the interplay between IP portfolios and funding rounds, and working with university technology transfer offices to commercialize university-generated IP. I have also served as an IP mentor for the RBS/NatWest Accelerator and as a business mentor for the Company Formation Programme of Young Enterprise Scotland, and have provided IP advice and mentoring directly to student and staff tech transfer organisations at Heriot-Watt University, the University of Strathclyde, the University of Edinburgh, Cambridge University, and King's College London. Innovare IP has also moved into the IP legal tech space through IP Blocks, a project developing a SaaS-based application designed to help businesses correctly identify, catalog, and commercialize all their IP. The ambition is to make IP strategy accessible and actionable, not just for the sophisticated in-house teams of large corporations, but for every founder with an innovation worth protecting. Shaping the relevance of the profession, SEPA, EPI, and UKIPO. Beyond day-to-day practice, I have invested considerable energy in shaping the relevance of the IP profession itself. I am currently chair of the IP Commercialization Committee at SEPA, Chartered Institute of Patent Attorneys, and a member of its Public Affairs Committee. At the European level, I am a member of the IP Commercialization Committee at EPI, the Institute of Professional Representatives before the European Patent Office, and vice-chair of EPI's IP Awareness Working Group. I am also the only patent attorney on the UK IPO's IP Finance Advisory Group, a position that allows me to contribute directly to policy discussions about how IP-backed lending and IP valuation frameworks can support SME access to finance. This work has already translated into published contributions to parliamentary inquiries and SEPA journal articles on subjects ranging from IP-backed lending to the financing and scaling of UK science and technology. Diversity in IP and entrepreneurship, a mission, not a motto. If there is a thread that runs through everything I do, from my scientific career, to my legal qualification, to my current practice and committee work, it is a deep commitment to diversity. Not as a box-ticking exercise, but as a genuine conviction, rooted in personal experience, that innovation suffers when it excludes half the population. I grew up in environments where women in STEM were rare, where glass ceilings were real and solid, and where the structures meant to protect innovators often failed those who were least connected to the traditional networks of power. Those experiences shaped my commitment to change. Since 2022, I have served as an ambassador for Women's Enterprise Scotland, acting as a role model and talking to women about starting their own businesses. I have also served as a member of the Royal Society of Edinburgh's Young Academy of Scotland and its Economy and Enterprise Committee, contributing to evidence-based policy on entrepreneurship and innovation. Within the IP profession itself, I served on EPI's Diversity and Inclusion Working Group and remain actively involved in the Changing Perceptions Initiative, a collaborative project with Women's Enterprise Scotland aimed at improving gender diversity in STEM and enterprise. The data is sobering. Women constituted only around 13% of inventors named on European patent applications in 2019. Thus, fewer than 1 in 7 inventors in Europe are women. Changing perceptions, IP in women-founded enterprises. Which brings me to the subject I want to close with, one that I believe deserves far more attention than it currently receives: the IP created by women-founded businesses, and why so much of it remains invisible, undervalued, and unleveraged. The dominant narrative around IP and entrepreneurship is one shaped almost entirely by the patent system. Investment follows patent-rich, technology-driven businesses. Those businesses are, statistically, most likely to be founded by men. Women-founded businesses are disproportionately concentrated in sectors: education, health and social care, arts and entertainment, food and drink, beauty and services, that are less likely to generate patent applications. The immediate and false conclusion drawn from this observation is that women-founded businesses create less IP. That conclusion is wrong. What it actually reveals is a critical failure of the IP system and of the advisors, investors, and policymakers who perpetuate it, to acknowledge the full spectrum of IP types. Trademarks, copyrights, database rights, and trade secrets are among the most commercially significant forms of IP for women-founded businesses, yet they are systematically overlooked in the metrics used to assess innovation, in the criteria used to evaluate investment readiness, and in the educational resources available to entrepreneurs. The 2023 Rose Review of Female Entrepreneurship estimated that if women started and scaled businesses at the same rate as men, up to £250 billion of new value could be added to the UK economy. The 2023 Scottish Government's Pathways report found that just 2% of institutional investment in Scotland goes to women-led companies, despite copious evidence that the entrepreneurial and related capabilities of women are equal to those of men. These are not gaps in women's capability, they are gaps in our collective ability to see, measure, and support the value that women-founded businesses create. The Changing Perceptions campaign I have been championing in cooperation with Women's Enterprise Scotland, SEPA, and EPI aims to address this directly. The goal is to develop gender-appropriate educational resources on the IP system, generate a targeted survey of women entrepreneurs, create a new dataset of the types of innovation and IP present in women-founded businesses, and publish a white paper that makes the evidence base impossible to ignore. The ambition is not simply to tell women that their IP matters, though it does. It is to give them the tools to conduct their own IP health check, to identify every trademark, every copyright, every protectable process or database that contributes to the value of their business, and to leverage that IP in conversations with investors, lenders, and partners. So, a scientist and a lawyer? Absolutely, yes. And that combination has given me a perspective on IP that I would not trade for anything. The science trained me to ask rigorous questions and to look for what others have missed. The law gave me the tools to protect and leverage what the science reveals. The entrepreneurial journey taught me that the most important IP is often the IP that no one has thought to look for yet. In an innovation-driven economy, the gap between those who understand IP and those who do not is a gap in economic power. Closing that gap for women entrepreneurs, for SMEs, for underrepresented innovators of all kinds is not just good policy. It is an economic and moral imperative. And this is the work I continue to champion. Are you in?
Page 84. Advertisement. Women's IP World Podcast. Celebrating the work and achievements of women in IP law and innovation globally. Explore an empowering podcast series highlighting the extraordinary contributions and milestones of women shaping the landscape of intellectual property and global innovation. Visit www.womensipworld.com. Hosted by Michelle S. Katz, founder, Evitum IP, LLC, Chicago, USA.
Page 85. Article. Disclaimer: images and references related to this article can only be seen in the print and digital versions of the magazine. Title: A Podcast Just for Us. Subihad: Celebrating Women's Voices in IP, the Women's IP World podcast shines a spotlight on inspiring leaders, innovative ideas, and the stories behind the profiles. Website: www.womensipworld.com/podcast. 5 seasons in, and we've only just begun to explore the depths of possibility. This year, the Women's IP World podcast proudly celebrates its 5th anniversary, with host Michelle S. Katz leading the way. By engaging in meaningful conversations with the authors of IP publications, the podcast brings the women behind the words to life, showcasing their brilliance, success, and inspiring journeys. Presented on behalf of Northlands Media PR and Marketing, publishers of the Women's IP World Annual and the Global IP magazine, based in London. The Women's IP World podcast was born amid the COVID-19 pandemic and has been going strong ever since. This podcast is a conversation series featuring the inspiring women and authors of, you guessed it, the Women's IP World Annual. Its host, Katz, is one of the first contributors to the magazine since its inaugural issue. She's the co-founding partner of law firm Advitum IP, based in Chicago, with over 20 years of IP experience. Hence, a veteran host, active in the field and dedicated to inspiring women across the IP legal sphere, was a perfect fit. The Women's IP World podcast aims to further the dialogue with amazing women in IP from around the world, discussing their timely publications beyond just the words on the page, breathing life into their profiles to reveal the people beneath. The success and drive of these women are clearly expressed in their work and serve as a testament to empower the future leaders in IP. Speakers come from all around the globe and are given a chance to elaborate on what brought them into the world of IP and how they came to write about their given subject matter. Speakers also talk about their lives outside the workplace, their drives and passions, and stories that have shaped them into the IP leaders they are renowned as. IP law encompasses a broad range of topics, many of which have been featured in the podcast and in Women's IP World publications. Topics have included the effects of COVID-19 in the field and our practices, anti-counterfeiting, augmented and virtual realities, international nuances of patent and trademark law, gender in the workplace, work-life balance, leveraging IP as a tool for business development and more. The Women's IP World podcast hosts discussions on today's relevant topics and introduces listeners to the authors. Fueled by Katz's diverse experiences in IP, she delves deeply into the backgrounds of the guest speakers and offers unique commentary for listeners. Both the publication and the podcast are always in search of new, contributing authors to feature. If you are interested, please contact us today at +44 0 2038130457 or email us at wipw@northonsprmarketing.com. Episodes are released monthly and are available at www.womensipworld.com/podcast.
Page 86. Advertisement. Women's IP World Ranking 2027. Top 100 influential women leaders in IP law. Champions of Leadership, Innovation, and Global Influence 2027 ranking. Subscribe now to receive exclusive updates. Be the first to know when nominations open for the 2027 Women's IP World Ranking. Brought to you by Northons Media PR and Marketing Ltd. Call +44 0 2038130457. Email wipw@northonsprmarketing.com. Website womensipworld.com.
Page 87. Ranking results. Women's IP World. Women's IP World Ranking Results 2026. The top 100 influential women leaders in IP law, celebrating leadership, innovation, and global influence 2026 ranking results. Brought to you by Northons Media PR and Marketing Limited. Category: Excellence in IP Strategy and Portfolio Management. Number 1. Alfa Chayeb, Managing Director at Harchaichi & Co., Tunisia. Number 2. Liliane Rories, Partner at Lix Attorneys, Brazil. Number 3. Anna Maria Stein, Partner at Evershed Sutherland, Italy. Number 4. Virginia Cerveri, Senior Partner at Cerveri Monsuarez, Uruguay. Number 5. Anna Marija Stancic Petrovic, LLM, Head of ICA IP at Petosevic, CWB, Croatia. Number 6. Yuzo Amaka Emerald, Partner at Denton's ACAS Law, Nigeria. Number 7. Elvira Andrade, Telecom Engineer and Patent Advisor at Lix Attorneys, Brazil. Number 8. Natalie Glitzenhern Augustine, Attorney at Law at Glitz Law, St. Lucia. Number 9. Perk Fustinoni, Vice President, Head of IP and Tech Legal at Mezzo Corporation, Inland. Number 10. Laura Colada, Managing Partner at Dumont, Mexico. Category: Leadership in IP Commercialization and Licensing. Number 1. Maria Rosa Fabara Vera, Managing Partner at Bustamante Fabara, Ecuador. Number 2. Antonina Pakarenko Anderson, Managing Partner at Pakarenko and Partners, Ukraine. Number 3, Adriana Barrera, Managing Partner at Barlaw, Barrera and Asociados, Peru. Number 4, Deniz Dinar Yuga, Managing Partner at Bolton IP Company, Turkey. Number 5, Maria Faruk Khan, Managing Partner at United Trademark and Patent Services, United Arab Emirates. Number 6, Odina Timonia, CEO and Attorney at Law at TARS Intellectual Property SRL, Romania. Number 7, Jennifer Brandt, Founder and CEO at Innovation Insights, Switzerland. Number 8, Dilek Zabel, Partner Trademark and Patent Attorney, WIPO UDRP Painlist at Starka IP, Turkey. Number 9, Alina Shamrina, Partner at Pakarenko and Partners, Ukraine. Number 10, Jujia Teng, CEO at Wei Insight, China. Category: Excellence in Trademark and Brand Protection. Number 1, Aparna Wartle, Partner at Halfords IP, Australia. Number 2, Elena Martini, Managing Partner at Martini Manor and Partners, Italy. Number 3, Barbara Porcario, Partner at Porcario Law, Argentina. Number 4, Magali Garcia, Managing Partner at Allende and Garcia Abogados, Peru. Number 5, Laura Castillo Sepulveda, Partner at Inventiva, United States and Dominican Republic. Number 6, Joana de Matos Siqueira, Partner at Montori Pimenta, Machado and Vieira de Mello, Brazil. Number 7, Clarissa Yeager, Partner at Montori Pimenta, Machado and Vieira de Mello, Brazil. Number 8, Ana Vargas, Founding Partner at Iberbrand, Mexico. Number 9, Andrea Pocinhas, Partner at Gruenbaum, Pocinhas and Teixeira, Brazil. Number 10, Esra Yalcin Basturk, Partner/Trademark Attorney/Lawyer at Orbis IP and Law, Turkey. Category: Leader in IP Policy Development and Reform. Number 1, Dr. Shweta Singh, Founder and CEO at Ennoble IP, India. Number 2, Roba Hammam, Partner and Legal Director at AP Genius, Switzerland. Number 3, Gina Carvajal Vega, Gerente General Corporativa at Banco Popular, Costa Rica. Number 4, Advocate Hamidar Asif, Associate Patent Attorney at Barucha and Company, Pakistan. Number 5, Alyssa Arcos Zima, Senior Associate at Perez Bustamante and Ponce, Ecuador. Number 6, Gabriela Bodden, Co-Managing Partner at Epoint, Costa Rica. Number 7, Tina Nan, Managing Partner at Co-Horizon IP Attorneys, China. Number 8, Anomi Wanigasekara, Senior Partner at Julius and Creasy, Sri Lanka. Number 9, Irmak Yalcina Oktam, Managing Partner, Patent and Trademark Attorney at Yalcina Patent and Consulting Limited, Turkey. Number 10, Fabiola dos Santos, Senior Associate at Maddens, Australia. Category: Innovation Leadership in Patent Law and Prosecution. Number 1, Stephanie Soto, Founding Partner at Mertz Peru, Peru. Number 2, Sarah Norka Anku, Global Managing Partner at SN Anku IP Firm, Ghana. Number 3, Michelle Katz, Founding Partner at Advitum IP, United States. Number 4, Stephanie Curcio, Co-Founder and CEO at NL Patent, Canada. Number 5, Cinemaraya Mikola, Partner, European Patent Attorney, COO at Boko IP Ori AB, Finland. Number 6, Christina Kiotsis, Attorney at Law/Manager at Kiotsis and Associates Law Offices, Greece. Number 7, Deepar Bavishi, IP Counsel at Online PSB Loans Limited, India. Number 8, Pawarisa, Fon, Suwarnashot, Partner at ZICO Law, Thailand, Limited, Thailand. Number 9, Moha Hanish, Associate at Ulcare Legal Attorneys, Jordan. Number 10, Isadora Lima, Partner at Gruenbaum, Pocinhas and Teixeira, Brazil. Category: IP Enforcement and Anti-Counterfeiting Leader. Number 1, Carolina Catono, Head of Trademark Prosecution at Lix Attorneys, Brazil. Number 2, Diana Romero, Partner and IP Head IP Department at Cuesta Lawyers, Colombia. Number 3, Wendy Crosby, Director, Patents, Head of Designs Team at Murgatroyd, UK. Number 4 Diksha Anand, partner at Sujata Chowdhury IP Attorneys, India. Number 5 Ursula Baraval, patent attorney and partner at Kish IP, South Africa. Number 6 Georgia Rousseau, legal counsel at Intellex, Greece. Number 7 Sangita Punyamurthy, co-chair, Canadian Intellectual Property and Technology Group at DLA Piper, Canada, LLP, Canada. Number 8 Twiggy M. H. Liu, principal at Twiggy M. H. Liu Law Office, Hong Kong SAR. Number 9 Evis Yoni, partner at Gjika and Associates, Albania. Number 10 Hilda Diab, patent counsel at Aptiv, Ireland. Category: Excellence in IP management for emerging markets. Number 1 Catherine Borner, director, patents, Electronics Patent Practice Group coordinator at Murgatroyd, UK. Number 2 Nicole Mogales, head of the IP department at Maranello Advogados, Brazil. Number 3 Erin McEwen, trademark agent, department head at Nelligan Law, Canada. Number 4 Parami Kerativitayanan, partner at Zico IP, Thailand. Number 5 Margarita Romero Rosales, partner at PBP, Ecuador. Number 6 Daphne Ekp, founding editor/attorney at Journal of IP Professionals, JIPPS, United States. Number 7 Eileen Ozga, partner trademark and patent attorney at Starka IP, Turkey. Number 8 Irene Rodriguez, head of IP at BBVA Banco Bilbao Vizcaya Argentaria, SA, Spain. Number 9 Jimena Souza Ferreira, partner at Osterling Abogados, Peru. Number 10 Maria Ceballos, partner and co-head of Trademarks Department at Cural Sunal SLP, Spain. Category: Thought leadership in IP law and practice. Number 1 Mrinali Menon, senior IP manager at HSM IP Limited, Cayman Islands. Number 2 Deborah Flores Garza, global legal director intellectual property at Televisa Univision, Mexico. Number 3 Keisha Fleming Lake, managing attorney at Cerveri Monsuarez Caribbean, Anguilla. Number 4 Shilpi Mehta Nanda, founding partner at Zeal Attorneys, India. Number 5 Clarice Ferreira da Silva Medeiros de la Cerda, research assistant at Syracuse University College of Law, Brazil/US. Number 6 Stephanie Bilao, legal director at Sociedad de Auto Res y Compositores de Mexico, non-profit, Mexico. Number 7 Navlin Swain, managing partner at Eludication, Advocates and Legal Consultants, India. Number 8 Ana Correa, head of patent filing and prosecution practice at Lix Attorneys, Brazil. Number 9 Karen Fraser, director, patents at Murgatroyd, UK. Number 10 Mariana Furtado de Mendonça, partner at Montori Pimenta, Machado and Vieira de Mello, Brazil. Category: Leader in women's advancement in IP. Number 1 Isabella Robledo McClymont, partner at Cural Sunal SLP, Spain. Number 2 Nithya S., senior legal consultant at R.K. Dewan & Co., India. Number 3 Paulina Reyes, senior counsel at McDonnell, Cuesta, Larca and Esquivel, Mexico. Number 4 Eleonora Carrillo, managing partner at Jacobacci and Partners, SLU, Spain. Number 5 Torit Seju Dotti, partner at Aluko and Oibode, Nigeria. Number 6 Mariana Bullrich, partner and head of patents at Notinger and Armando, Argentina. Number 7 Gunjan Paharia, managing partner at Zeus IP Advocates LLP, India. Number 8 Wiramrudi Mokavisa, partner at Tillich & Gibbons International Limited, Thailand. Number 9 Brenda Matano, head of practice at Matanga IP Attorneys, Zimbabwe. Number 10 Astha Negi, partner at Fidus Law Chambers, India. Category: Pioneering IP work in sector-specific tech and innovation. Number 1 Beth Marshall, director, patents and ESG lead at Murgatroyd, UK. Number 2 Melissa Litvin, partner at Litvin Maserati Legals, Argentina. Number 3 Sandra Mao, vice president, product management at Clarivate, United States. Number 4 Claudette Vernet, director at Estrategia Juridica, Colombia. Number 5 Gabriela Miranda, Partner, Intellectual Property at BDO Costa Rica, Costa Rica. Number 6. Florence Huis, Partner at Kern & Whale, France. Number 7. Mabel Klimt, Managing Partner at El Zabiru, Spain. Number 8. Gabriela Salerno, Partner at Montori Pimenta, Machado and Vieira de Mello, Brazil. Number 9. Nadine Stuttel, Founder and CEO at PSS Solutions, Switzerland. Number 10. Omanif Irabor Benson, Deputy Team Lead, Intellectual Property Practice, Strun & Bland Partners at Strun & Bland Partners, Nigeria. Page 91. Ranked Directory Listing. Women's IP World Ranking 2026. A ranked directory listing. The top 100 influential women leaders in IP law, celebrating leadership, innovation, and global influence 2026 ranking. Brought to you by Northlands Media PR and Marketing Limited. Disclaimer: images related to directory listing can only be seen in the print and digital versions of the magazine. Directory listing under the category of Excellence in IP Strategy and Portfolio Management. Ranked number 1 Alpha Chayeb, Managing Director at Hachaichi & Co., Tunisia. Recognized for excellence in IP strategy and portfolio management, I bring over 25 years of experience advising international clients across Tunisia and the Maghreb, with a strong commitment to trust, consistency, and long-term relationships. Website: www.hachaichi.com. Ranked number 4 Virginia Severi, Senior Partner at Severi Monsuarez, Uruguay. Lawyer with 30-plus years of experience in intellectual property, leading a top-tier practice. Expert in trademarks, enforcement, anti-piracy, and IP strategy across the full lifecycle of intangible assets. President of Anti-Piracy Chamber and active in global committees. Website: www.severimonsuarez.com. Ranked number 5 Anamarija Stancic Petrovic, LLM. Head of ICA IP at CWB Limited, Croatia. Brussels-based European and Croatian IP attorney with nearly 30 years' experience in global IP strategy, enforcement, and protection. Expert in patents, trademarks, designs, and copyright across fashion, pharma, luxury, and automotive, advising clients throughout the EU and beyond. Website: www.cwbip.com. Ranked number 8 Natalie Glitzenhern Augustine. Attorney at Law at Glitz Law, St. Lucia. Natalie Glitzenhern Augustine is a seasoned IP practitioner with 30 years' experience advising clients on the strategic management of national and international IP portfolios. Her work links trademark strategy with economic and cultural development, strengthening IP protection and awareness in St. Lucia and beyond. Website: www.glitz-law.com. Ranked number 10 Laura Colada. Managing Partner at Dumont, Mexico. Laura Colada is Managing Partner at Dumont and a renowned Mexican IP lawyer with 35-plus years of experience, including service at IMPI. Active in INTA, AIPPI, and Marques, she promotes DEI and education, and has earned major recognition as one of Latin America's top IP lawyers. Website: www.dumont.mx. Directory listing under the category of Leadership in IP Commercialization and Licensing. Ranked number 2 Antonina Pakarenko Anderson. Managing Partner at Pakarenko & Partners, Ukraine. Recognized for shaping Ukraine's intellectual property framework, she has spent over 30 years as managing partner building the legal and educational foundations that enable effective IP commercialization. Her work has established systems that allow others to succeed, marking her as a true market-shaping leader. Website: www.pakarenko.ua. Ranked number 3 Adriana Barrera. Managing Partner at Barlaw, Barrera and Asociados, Peru. Adriana Barrera, founder and managing partner of Barlaw, with almost 30 years of experience advising global companies on IP, trademarks, patents, copyrights, unfair competition and data protection. Active member of leading associations and recognized by top legal rankings. Website: www.barlaw.com.pe. Ranked number 4 Deniz Dinar Yuga. Managing Partner at Bolton IP Company, Turkey. Deniz Dinar Yuga is a leading figure in Turkey's IP field, known for strategic insight and strong expertise, advising both national and international clients. Yuga acts as an effective bridge between Turkey and international IP systems, helping clients develop strong and coherent IP strategies. Website: www.bolton.com.tr. Ranked number 6 Odina Timonia. CEO and attorney at law at TAS Intellectual Property Agency, Romania. Odina Timonia is the founder of TAS Intellectual Property Agency and also the managing partner at Campan and Timonia law firm. Odina holds the title of representative before the European Union Intellectual Property (EU IPO) and is also nationally authorized by the State Office Trademarks. Website: www.tarsregistration.com. Ranked number 8 Dilek Zabel. Partner trademark and patent attorney at Starker IP, Turkey. Dilek Zabel is managing partner at Starker IP and a chartered trademark and patent attorney with 20+ years experience. A WIPO UDRP panelist, she advises global clients on IP strategy, enforcement, IP strategies, and domain name disputes. Website: www.starkerip.com. Ranked number 9 Alina Shamrina. Partner at Pakarenko and Partners, Ukraine. Recognized as a distinguished leader with over 25 years of experience, she specializes in strategic intellectual property management and leadership. As a partner, she oversees and monetizes substantial IP portfolios, including licensing and IP transfers, combining strong commercial oversight with hands-on IP strategy. Website: www.pakarenko.ua. Ranked number 10 Jujia Ting. CEO at Wei Insight, China. Jujia Ting operates at the intersection of intellectual property and global business leadership. She is known for bringing strategic clarity, governance discipline, and long-term perspective to complex, cross-border environments. Website: en.wei-insight.cn. Directory listing under the category of Excellence in Trademark and Brand Protection. Ranked number 1 Aparna Wartle. Partner at Halfords IP, Australia. Aparna Wartle is recognized for leading complex, multi-jurisdictional brand protection matters. She translates fast-moving commercial realities, including AI development, digital marketing, and duping culture, into practical trademark strategies that protect and harness brand value for growth. Website: www.halfords.com.au. Ranked number 2 Elena Martini. Managing Partner at Martini Manor and Partners, Italy. Elena specializes in contentious and non-contentious IP across a wide range of sectors. She advises on the full spectrum of IP matters, including trademarks, designs, patents, trade secrets and copyright, and has led high-profile, precedent-setting cases. She is a member of Eplore, Marques, ECTA. Website: www.martinimanor.com. Ranked number 3 Barbara Porcario. Partner at Porcario Law Argentina. Barbara Porcario is the founder and head of Porcario Law, an Argentine IP lawyer specializing in trademarks, IP litigation, and strategic advisory. She is known for blending legal expertise with innovative, business-focused solutions for both local and international clients. Website: www.porcariolaw.com. Ranked number 8 Ana Vargas. Partner at Iber Brand, Mexico. Ana Vargas is a trademark attorney and IP leader recognized for her strategic influence in brand protection and enforcement in Mexico and Latin America. She is known for her ability to align IP strategy with business objectives and is active in leading international IP associations. Website: www.iberbrand.com. Ranked number 10 Esra Yalcin Basturk. Partner and attorney at law and trademark and patent attorney at Orbis IP and Law, Turkey. Esra Yalcin Basturk works in the field of intellectual property law. She is an attorney at law and a registered trademark and patent attorney, with experience across various aspects of IP rights, particularly trademark law. Website: www.orbisiplaw.com. Directory listing under the category of Leader in IP Policy Development and Reform. Ranked number 2 Roba Hammam. Partner and Legal Director at AP Genius, Switzerland. Roba Hammam is an intellectual property strategist with over 20 years of experience advising creators, businesses, and institutions. Based in Geneva, she brings international leadership experience and engagement in IP policy discussions, combining deep IP and AI expertise to deliver future-ready solutions. Website: www.apegenius.com. Ranked number 3 Gina Carvajal Vega. Gerente General Corporativa at Banco Popular, Costa Rica. Gina Carvajal Vega holds a degree in economics from the University of Costa Rica, is 43 years old, and is a development effectiveness specialist at the Inter-American Development Bank. She specializes in banking and national development, with a focus on climate change, agriculture, gender, SMEs, and financial inclusion. Website: www.bancopopularfi.cr. Ranked number 4 Advocate Hamadar Asif. Associate Patent Attorney at Bharucha & Company, Pakistan. Hamadar is an associate patent attorney with 21+ years of experience in patent prosecution, opposition, and litigation, specializing in life sciences, biotechnology, chemistry, and pharmaceuticals. She advises national and international clients and is a registered patent agent and advocate of High Court. Website: www.bharuchaco.com. Ranked number 6 Gabriela Bodden. Co-managing partner at EPROINT, Costa Rica. Globally recognized IP leader with 28+ years experience across the Caribbean and Latin America, advising on complex IP-driven transactions, global trademark portfolios, MANDA and enforcement, and shaping regional IP strategy for international clients. Website: www.eproint.com. Ranked number 7 Tina Nan. Managing partner at Co-Horizon IP Attorneys, China. Co-Horizon is a provider of advanced technological and comprehensive legal services for both international and domestic clients. Co-Horizon holds one-stop capabilities for handling all intellectual property issues across the China mainland, Taiwan, and Hong Kong, with a team consisting of over 150 professionals and more than 50 patent attorneys. Website: www.cohorizon.com. Ranked number 8 Anomi Wanigasekara. Senior partner at Julius & Creasy, Sri Lanka. An expert in all aspects of IP law with experience spanning over 4 decades, Anomi Wanigasekara is the senior partner and head of the IP division of one of Sri Lanka's oldest law firms, Julius & Creasy. She has taken senior roles at INTA and APAA and has won several awards globally. Website: www.juliusandcreasy.com. Ranked number 9 Irmak Yalciner Oktum. Partner, patent and trademark attorney at Yalciner Patent and Consulting Limited, Turkey. Irmak Yalciner Oktum is a Turkish patent and trademark attorney and partner at Yalciner Patent, recognized for 25 years of leadership in IP policy development, patent, trademark and design law, and international advocacy through roles with AIPPI and INTA. Website: www.yalciner.com. Ranked number 10 Fabiola dos Santos. Senior Associate at Madden's Patent and Trademarks Attorneys, Australia. Fabiola is a senior trademarks attorney with 16+ years experience across private practice and in-house. She is known for strategic, commercially focused brand advice and for championing women in IP through mentorship, leadership, and active engagement in the profession. Website: www.maddens.com.au. Directory listing under the category of Innovation Leadership in Patent Law and Prosecution. Ranked number 1 Stephanie Soto Bendezu. COO, founding partner at Mertz IP, Peru. Stephanie Soto is a scientist and intellectual property strategist with over 12 years of experience. She specializes in technology transfer, innovation protection, and IP strategy, working closely with universities, businesses, and public institutions in Peru and abroad. Website: www.mertzperu.com. Ranked number 2 Sarah Norka Anku. Global Managing Partner at SN Anku IP Firm, Ghana. Intellectual property lawyer, consultant and trainer, managing partner at SN Anku IP firm, Ghana, Nigeria, the Gambia and a repo agent covering 22 African countries, lecturer at NUST Ghana, expert in IP policy development, litigation, commercialization and capacity building across Africa. Website www.snankuipfirm.com. Ranked number 4 Stephanie Curcio, CEO and co-founder at NL Patent, Canada. Stephanie Curcio is CEO and co-founder of NL Patent, an AI-native patent research and intelligence platform. An IP attorney and entrepreneur, she is internationally recognized for her leadership in AI and patent law, with a focus on modernizing practice across prosecution, litigation, and IP strategy. Website www.nlpatent.com. Ranked number 5 Sinamaria Mikkola, Chief Strategy Officer, Partner, European Patent Attorney at Boko IP Ori AB, Finland. Sinamaria Mikkola combines technical expertise with strategic insight. As a European patent attorney and CSO at Boko IP, she drives the firm's strategy execution, advances IP management through local and global associations, and ensures clients' innovations are protected with effective solutions. Website www.bokoip.com. Directory listing under the category of IP Enforcement and Anti-Counterfeiting Leader. Ranked number 6 Georgia Rousseau, IP lawyer at Intellex, Greece. Recognized IP and pharmaceutical law expert with over a decade of experience. Holds a Dr. Juris from LMU Munich and is the author of the Edward Elgar, London, publication on supplementary protection certificates. Ranked number 1 in policy and advocacy in 2025 and repeatedly listed among the top 100 women leaders in IP. Website www.intel-lex.eu. Ranked number 8 Twiggy M. H. Liu. Principal at Twiggy M. H. Liu Law Office, Hong Kong SAR. We specialize in all types of non-contentious and contentious IP in the Greater China region and beyond. Twiggy M. H. Liu Law Office. Email, mail@tliu-lawoffice.com. www.tliu-lawoffice.com. Prominence IP Services, Shenzhen, Ltd. Email, mail@psz-ip.com. www.psz-ip.cn. Website, www.tliu-lawoffice.com. Ranked number 10 Hilda Diab, IP Counsel at Aptiv, Ireland. European Patent Attorney, EPA, with 20+ years of experience managing global patent portfolios across STEM inventions. Recognized as a proactive, visionary leader who bridges inventors, R&D, business, and legal teams globally to deliver high-value IP assets and excellence in prosecution strategies. Website, www.aptiv.com. Directory listing under the category of Excellence in IP Management for Emerging Markets. Ranked number 3 Erin McEwen. Trademark Agent at Nelligan Law, Canada. Erin McEwen is an internationally recognized Canadian trademark agent whose work protects brands and supports innovation worldwide. Known for strategic trademark leadership, enforcement, mentorship, and service, she advances intellectual property with purpose and impact. Website, www.nelliganlaw.ca. Ranked number 6 Daphne Ekp. Associate Attorney at Welsh Flaxman and Gittler LLC, WFG, United States. IP and technology lawyer with cross-border experience across US and Africa. Recognized for advancing strategic IP practice and portfolio management at WFG, contributing to social impact IP initiatives through TIL, and driving IP awareness and thought leadership via Let's Talk IP with Daphne and JIPPS. Website, www.iplawsolutions.com. Ranked number 8 Irene Rodriguez Alonso. Head of Legal IP at BBVA, Spain. Ranked number 1 in Diversity and Inclusion 2026. As Head of IP at BBVA, I lead client-focused IP strategy in a global financial institution, ensuring innovation, legal certainty, and inclusive access to value creation through technology and intangible assets. Website, www.bbva.es. Ranked number 9 Jimena Souza Ferreira. Partner at Osterling Abogados, Peru. Jimena Souza Ferreira heads the Life Sciences and Regulatory Area and co-heads Intellectual Property and Competition in Osterling Abogados. She advises both clients and brands regarding trademarks, patents, consumer protection, unfair competition, advertising, health regulation, and clinical trials. Website: www.osterlingfirm.com. Directory listing under the category of Thought Leadership in IP Law and Practice. Ranked number 2 Deborah Flores Garza. Global Head of IP at Televisa Univision, Mexico. Leads global strategies to protect, unify, and monetize large-scale intellectual property portfolios on a truly global scale, driving anti-piracy programs, rights governance, and IP registration frameworks across multiple jurisdictions, while aligning legal, business, and creative teams. Website: www.corporate.televiseunivision.com. Ranked number 3 Keisha Fleming Lake. Global Head of IP at Televisa Univision, Mexico. Keisha Fleming Lake, LLM, is an attorney with 25+ years of experience across the Caribbean. Licensed in Anguilla, Antigua and Barbuda, and St. Kitts and Nevis, she specializes in intellectual property and corporate law, advising clients on complex, multi-jurisdictional matters. Website: www.severimonsuarez.com. Ranked number 4 Shilpi Mehta Nanda. Founder and Managing Partner at Zeal Attorneys, India. She is an independent director at PPL India with 19 years expertise in IP, technology, and corporate laws. A BIS convener and former UKIPO attaché, she holds an LLM from Franklin Pierce Law Center, USA. A published author, speaker, and lecturer, she contributes widely to national and global forums. Website: www.zealattorneys.com. Ranked number 6 Stephanie Bilao Salazar. Legal Director at SACM, Mexico. Legal Director at SACM with 20+ years in copyright and digital rights. Vice Chair of CISAC's Legal and Policy Committee and part of its Latin America regional group. A leading voice in IP, ensuring authors are properly remunerated, advancing women in the industry and committed to continuous learning. Website: www.sacm.org.mx. Directory listing under the category of Leader in Women's Advancement in IP. Ranked number 2 Nithya Somasundaram. Advocate and Patent Agent at R.K. Dewan & Co., India. Ms. Nithya Somasundaram is an internationally recognized Indian IP leader, honored for advancing women in IP through mentorship, leadership initiatives, and awareness programs, while representing India's IP fraternity across global forums. Website: www.rkdewan.com. Ranked number 7 Gunjan Paharia. Managing Partner at Zeus IP Advocates LLP, India. Built a solo practice into one of India's most respected IP law firms, leading cross-border enforcement, anti-counterfeiting initiatives. I-shape policy, influence landmark cases, modernize IP systems, driven by a commitment to innovation, transparency, equity, lasting impact in the legal community. Website: www.zeusip.com. Ranked number 9 Brenda Matano. Head of Practice at B. Matano IP Attorneys, Zimbabwe. Founder and Head of Practice, B. Matano IP Attorneys. 20 years at the forefront of Africa's IP landscape, protecting global companies and startups, championing reform, and building the frameworks and policies that drive continental innovation. Website: www.bmatano.com. Ranked number 10 Astha Negi. Partner at Fidus Law Chambers, India. Astha is a partner leading the firm's trademark, copyright, and design practice. A global brand protection strategist, she advises Fortune 500 clients across sectors, manages multi-jurisdictional IP portfolios, appears before Indian TM offices, and is internationally recognized for IP prosecution. Website: www.fiduslawchambers.com. Directory listing under the category of Pioneering IP Work in Sector-Specific Tech and Innovation. Ranked number 3 Sandra Mao. Vice President of Product Management at Clarivate, United States. Sandra is Vice President of Product Management for IP at Clarivate. Prior to joining Clarivate, she was the CEO and founder of Trademark Vision, an award-winning AI startup doing visual brand protection and the world's first online visual search engine for trademarks and designs. Website: www.clarivate.com. Ranked number 4 Claudette Vernet. Director at Estrategia Juridica, Colombia. Since 2000, I have spearheaded initiatives to combat illicit markets in Colombia, fostering strong interagency collaboration and implementing best practices to dismantle criminal organizations. In 2025, we trained over 500 public officials, strengthening institutional capacity. Website: www.estrategiajuridica.com. Ranked number 9 Nadine Stuttel. Founder and CEO at PSS Solutions, Switzerland. Nadine Stuttel is a globally recognized leader in IP operations, technology and organizational transformation, and founder of PSS Solutions. With 25+ years of international experience, she helps organizations deliver people-centered, sustainable change and operational excellence. Website: www.pss-solutions.com. Women's IP World. Secure your place in the 2027 directory listing. Global recognition, all year round. Get year-round visibility with a Women's IP World annual directory listing, including a 300-character description, profile picture, name, position, firm name, country, and website URL, and global exposure across our print, digital, and audio platforms. Email us on wipw@northonsprmarketing.com or visit our website www.womensipworld.com.
Page 97. Half-page advertisement. Women's IP World Ranking 2027. Top 100 influential women leaders in IP law. Champions of Leadership, Innovation, and Global Influence 2027 ranking. Subscribe now to receive exclusive updates. Be the first to know when nominations open for the 2027 Women's IP World Ranking. Brought to you by Northons Media PR and Marketing Ltd. Call +440 2038130457. Email wipw@northonsprmarketing.com. Website: womensipworld.com. Page 98. Advertisement. Northons Media PR and Marketing Ltd. Specialists in intellectual property publishing, media, PR, and marketing. Why rely on agencies that need to learn your industry first? Your work in intellectual property is specialized, technical, and globally significant. Your marketing should reflect that, delivered by a team that understands the industry inside out. Publishing, social media management, brand awareness/lead generation, webinar/conference, event planning and management, website development and maintenance, 20+ years experience, 100+ successful clients, 25K+, global distribution, 85% retention rate. Contact us today to enhance your visibility with a free consultation. Call +440 2038130457. Email info@northonsprmarketing.com. Website: www.northonsprmarketing.com. Page 99. Inside back cover. Glitz Law Attorneys at Law. Consider it done. Our services: IP services, corporate and commercial law, patents, company formation and administration, conveyancing and notarial work, trusts, wills and successions. Contact us to schedule a consultation and start your journey towards legal success. www.glitz-law.com. Natalie.augustine@glitz-law.com. Phone: +17584516355. Suite number 1, first floor, Bourbon House, Bourbon Street, P.O. Box 1, 695 Castries, LC 04101, St. Lucia. Page 100. Outside back cover. Fakhnina and Partners, Russia. Eurasian and Russian patent and trademark attorneys. Trademarks, patents, utility models, designs. Dr. Tatiana Fakhnina, Dr. Alexey Vaknina and Dr. Elena Atkina. EAPO, Armenia, Belarus, Kazakhstan, Azerbaijan, Georgia, Moldova, Armenia, Russia, Kyrgyzstan, Tajikistan, Turkmenistan, Uzbekistan. Trademarks, trademark search, trademark prosecution, trademark monitoring and trademark litigation. Contact: Russia, ip@vaknina.com. Armenia, am@vaknina.com. Kyrgyzstan, kg@vaknina.com. www.vaknina.com. ip@vaknina.ru. Tel, +74952314840.
You have been listening to the Women's IP World Annual 2026. If you would like to be part of the Women's IP World Annual 2027, then please get in touch with us at email wipw@northansprmarketing.com or call +44 0203 813 0457. Website www.womensipworld.com. Thank you.